Kelly, allow him to use both of his hands, please, sir.
We are.
Thank you. This is a pre-hearing procedure in the matter of state against Richard Alexander Murdaugh. Its case numbers 2022 GS 15-00592 through 00595. Defendant Murdaugh was indicted for the murder of his wife, Margaret Branstetter Murdaugh, and his son, Paul Bennett Murdaugh, and related weapons charges. His trial began on January the 23rd, 2023. 6 weeks of trial. On the evening of March the 2nd, 2023, the jury returned a verdict of guilty on all 4 indictments, on which the defendant was sentenced on March 2023 to 2 consecutive terms of life imprisonment. Notice of appeals of his convictions and sentences were filed by defendant Murdaugh's attorneys on March the 9th, 2023 with the South Carolina Court of Appeals. The transcript in this very lengthy trial took several months to produce, even in draft form. Before the attorneys received the final transcript, on September the 5th, 2023, defendant filed with the Court of Appeals a motion to suspend his appeal and for leave to file a motion for a new trial with accompanying affidavits and transcript experts. After further defense and state filings on October the 17th, 2023, the Court of Appeals granted appellant Murdaugh's motion to suspend the appeal and to remand this case to the circuit court to allow defendant Murdaugh to file a motion for a new trial. Defendant Murdaugh received the final trial transcript and very shortly thereafter filed a motion for new trial in the College County Clerk of Court's office. Subsequently, Judge Clifton Newman recused himself from further proceedings in this matter. On December the 18th, 2023, Chief Justice Donald W. Bailey signed an order appointing or directing that the Honorable Jean Hayford Toll, retired Chief Justice of South Carolina, be assigned exclusive jurisdiction for the limited purpose of presiding over defendant's motion for a new trial. I promptly contacted counsel in this case and set deadlines for briefing and arguments of the new trial motions. The new trial motions were set to be argued on January the 23rd, 30th, and 31st of 2024. And after several rounds of pretrial briefs having been submitted to me, I also set today's date for a procedural pre-hearing. Before I begin, if I may, and I thank publicly Attorney Jay Bender for agreeing to be the voluntary media coordinator for this matter, as he did for Judge Clifton Newman on trial of this matter. Cell phones are normally not permitted at all in our courtrooms. Cell phones and laptops and electronic devices because of the non-jury nature of this portion of the proceedings. But if any device rings or sounds to receive a call or to receive an email or a message, that device will be confiscated and the owner will be asked to leave. Major topics to be covered today have been addressed by me and discussed with counsel in a short pretrial conference in my chambers. And counsel may have certain things that they will put upon the record as we proceed through these topics that deal with what should be covered. The first topic is an evidentiary hearing necessary at all? The state took the position that the answer to that was no. Obviously, the defendant not. I have set an evidentiary hearing because I felt like we had to have some brackets on the time we would spend on this matter. The matter is affecting the arguments the state makes about the procedural posture of this matter. The next topic would be the burden of proof. Who has the burden of proof in this matter? And what must be shown to meet that burden of proof? And what must then be shown to contest what has been shown and proved? The third topic is procedural defects, most specifically a contention by the state that this motion is untimely because it was rendered accepted in the jury poll. And finally, we need to discuss witnesses, juror witnesses. The clerk of the court of Compton County is Hill, and other witnesses and exhibits. I note that at least one attorney in the room is an attorney for some of the jurors, and other jurors may have other attorneys. When I get to the portion of this discussion where we talk about specific witnesses, and if I am asked to hear from attorneys for the witnesses, I will at least consider that request. I don't know where we will be at that time in terms of what has been decided, but I will at least inquire about that. To that end, if you have not already, during the first break, be certain that all of them, the lawyers participating at council table, and any other lawyers that feel that they have some interest in the proceedings that would warrant comment by them, please give your cards or information about your contacts to our court reporter, Ms. Harris. With that, Mr. Harper, you're moving part.
Love you. Love you.
Please, of course, Your Honor, you've raised, I assume you want to go in the order in which you just.
I would.
Okay. You've raised a number of legal issues from whether we've waived, a number, I forget the order you just took. Mr. Griffin is going to address those in seriatim based on what you said a moment ago as to the witnesses and the jurors. I will be.
Mr. Griffin, we'll hear from you now.
Yes, thank you, Your Honor. The first issue that you've asked us to address is an evidence necessary, and the answer to that question is yes, under established case law and the Supreme Court, Fourth Circuit, and the South Carolina Supreme Court under Reamer. A Reamer hearing is absolutely necessary where there has been credible evidence presented, there has been improper third-party contact with the jury prior to their deliberations that frankly, whether it goes to the merits or not, a Reamer hearing is absolutely necessary. And we believe contemplated a Reamer hearing. And in a Reamer hearing, evidence is presented as to what outside influences were brought to bear upon the jury. We have in our motion for a new trial submitted affidavits of one deliberating juror, one alternate, and then another affidavit of a witness to an interview of an alternate, and all three statements are consistent, and in that they heard Ms. Hill, the clerk of court, prior to deliberation, and frankly before the defense put on their case. Ms. Hill instructed not be fooled by the defense. That's what the sworn statements say. And secondly, before Mr. Murdaugh took the stand, Ms. Hill advised one deliberating juror and two alternates and watch his demeanor, which is an implication of, he's going to lie. And so then the question becomes, factually, did those contacts happen? And then, we proceed from there as to what the burden of proof is after that. But are we entitled to evidentiary hearing? The law is crystal clear that we are.
Thank you, sir. Mr. Waters, to the state.
Thank you, Your Honor. May it please the court. Your Honor, obviously, you've addressed the issue of whether an evidentiary hearing is necessary. The state certainly understands that. It is incumbent upon us, though, based on the law, to preserve our arguments as to procedural bar, and those are twofold. And the first one, of course, is that a motion for a new trial must be filed within 10 days of the verdict, unless there's after discovered evidence. And I think an initial inquiry that needs to be determined is when the defense first learned of these particular allegations and conversations with the defense. They said they're going to give me an answer, that they may have had conversations with juror 785 prior to her being represented, which was only a couple days after trial. So if that is the case and they were aware of these allegations, then we would want to argue to Your Honor and preserve the issue that this is not. We made the affidavits on their face. The deliberating juror indicated that 6:30 in that affidavit only said that she voted guilty. She had questions but voted guilty because she felt pressured by the jurors. And of course, the law is crystal clear in multiple cases that sort of internal debate, it's actually in Rule 606B, that's not any sort of misconduct or anything that is an appropriate venue or mechanism in order to attack the verdict. So for that reason, we've argued that their showing in their motion for a new trial is insufficient based on the case law for an evidentiary hearing because there is on its face no prejudice. That being said, of course, we fully understand and expect the evidentiary hearing to go forward. And we'll be happy to address burden of proof after the defense makes their arguments.
Very good. With respect to, Mr. Griffin, anything in reply?
Your Honor, it does not appear that the state, takes a position contrary that a Reamer hearing is required. They're arguing that we have sort of waived the right to that hearing. There's no evidence in the record of that. I can assure the court we did not know of this information within 10 days after the trial, and when we learned of it, we promptly acted.
Well, in conversations with Mr. Harpootli and Mr. Griffin, we're going to actually look into that and look at their paralegals notes. So I fully rely on and trust the defense to give me a fair answer to that question. And then again, if there's an issue to be raised, we would raise that. We're not conceding anything. We just wanted to preserve our procedural issues.
I don't think we need to go back and forth many times about this. I think I understand your position. Here is my position on the matter. First of all, I am not conducting a Rimmer hearing. Rimmer is a 1954 decision of the United States Supreme Court that deals with the question of influence of the jury and a motion for a new trial on the basis of after discovered evidence of that influence. I rely on the South Carolina decision of our Supreme Court authored by Justice Kittredge, State versus Green. And the Green decision specifically says that Rimmer is not the guidance that South Carolina trial judges should look to in conducting hearings on after discovered evidence. Now, that says nothing about what the burden of proof should be, and I don't intend to say anything thereby. But I do intend to tell you right away that I will be relying on South Carolina's jurisprudence and South Carolina's jurisprudence specific of this nature and who bears the burden of that proof. All right. And that leads to the very next topic that we'll now take up, which is the burden of proof. Mr. Griffin?
Yes, Your Honor. As we cited in our papers, we believe that the controlling agent, and that is conduct of a court official, here clerk of court, having communication with the jury about the substance or the merits of the case, that the standard to be applied is not Green, because Green, Judge Kittredge says that the contact by the bailiff was about a procedural issue, not about the merits of the case. Here we're dealing specifically with the merits of the case, and the Court of Appeals decision in State v. Cameron, we believe, is the controlling standard. And in State v. Cameron, and that was decided in 1993, and the court says, and citing Holmes v. United States, which is a Fourth Circuit opinion, says in this case there was a private communication of the court official to members of the jury, an occurrence which cannot be tolerated if the sanctity of the jury system is to be maintained. When there has been such a communication, a new trial, unless it clearly appears that the subject matter of the communication was harmless, presumption standard in State v. Green, Your Honor. And it's important, the Court of Appeals decision looking to the Fourth Circuit, because as Your Honor knows, this case, and I would encourage the court to look at the Holmes decision out of the Fourth Circuit, which we cite, which applies Reamer. It applied Reamer in a habeas corpus case when they said Reamer is the clearly established law in the Fourth Circuit. And it vacated a death penalty conviction out of North Carolina because the North Carolina courts did not follow Reamer. And so the Court of Appeals decision in Green says we look to Reamer. Justice Kittredge says, we're not going to apply the Reamer presumption here because it didn't go to the merits. What we have in this case, and what we have, presented through proffer on the affidavits, something that goes to the heart of the merits. It's the defense. It's the credibility of the defendant's testimony. And so we do have the burden of production, but we do believe that the standard in Cameron is we just have to show that the subject matter of the communication, that it was material to the case, and that then the burden shifts to the defendant to prove that it was harmless. The burden shifts to the state to prove it was harmless.
Thank you, sir.
That's what we believe the standard is.
Mr. Waters?
Your Honor, and I'm going to walk through some of the cases in South Carolina that address this issue. But as Your Honor is aware, of course, when we deal with these issues, we have two types. We have internal misconduct, and our courts have been reluctant. Rule 606 says this as well, to delve into that unless there are concerns of fundamental fairness, like racism and things like that. And then there's external allegations of external influence and that sort of thing. And that's what we're dealing with here today. And to quote State v. Grovenstein, which is a 1999 case of the State Supreme Court, it cites Aldred and Kelly and says, "We have consistently held the defendant must prove prejudice in these sorts of claims." And if we walk through all of the case law, our court has been very careful, and as much said so in Aldred, which was an internal case, to sync the analysis and the standards between those two, and have consistently held that the defendant has to show prejudice. It's their burden to do so. In Blake in 1992, the court held don't presume prejudice, and the test, of course, was whether or not the verdict was solely the product of honest deliberation or whether it was the product of outside influence. We go over to State v. Kelly. Of course, Your Honor concurred with Chief Justice Finney's dissent in that case, but in that case, there was a pamphlet in the grand jury room. Clearly, an external influence was alleged there. And ultimately, in that case, the court held that the defendant failed to show prejudice from that particular external influence. In State v. Grovenstein, in this instance, it was clearly external. There was an alternate who was present in the jury room and even took a preliminary vote with the jurors. So clearly an external influence, far more than is even alleged in this case. That juror was removed, curative instruction was given, but ultimately the court was very clear that we have consistently held the defendant must prove prejudice. Again, the burden being on the defendant. In Bryant, this was a capital case, one that argued way back when. And in that instance, there was a police investigation, background investigation into death qualified jurors in a capital case. Clearly external. The trial court conducted an inquiry with questions submitted by the parties as well, and ultimately noted that it was the defendant's burden to prove actual bias on the part of the jury. In State versus Pittman, another case that I argued before, Your Honor, in that particular case, there was a juror who had a conversation with his wife and with the bartender. And ultimately, again, the court held that the defendant failed to meet the burden of prejudice because the wife's comment was the defendant was not guilty, and the comment to the bartender took place after deliberations had begun. And then, of course, in Green in 2020, Your Honor just commented on that, and the court clearly held that the Rimmer presumption of prejudice doesn't apply here. And then, of course, went on to note that the defendant bears the burden of proving prejudice. And Cameron is a case that they rely on a lot. And I would say this about Cameron, that Cameron, of course, goes on to say that the mere fact of any official communication does not necessarily mean that the jury was prejudiced, and went on again to do a prejudice analysis and a harmless error analysis. Covington is the Court of Appeals case from 2000. In this particular case, there were jurors who supposedly knew the defendant and knew some external information about whether or not he had had previous difficulties with his wife and that sort of thing. Clearly external information. And again, the court held that the defendant failed to show prejudice. So the case law in South Carolina, both from our state Supreme Court as well as our state Court of Appeals, it's clear, it's in sync, it's uniform, that is the defendant's burden to show prejudice. And that's, of course, only after there's a determination that any sort of extraneous influence occurred. And that would be the state's position, that it is the defendant's burden. And again, we can address at the appropriate time what the state's position is as to the order of which the evidentiary hearing should go.
Thank you, sir. Mr. Griffin, you reply?
Yes, Your Honor, there is a tremendous difference in the law as to how the court analyzes juror misconduct, as in Kelly, where the juror reaches out to her pastor, gets a pamphlet, brings it into the jury room, and that was found during the course of the trial. The trial judge removed juror O, who had gotten a pamphlet, voir dire every juror to ask what effect that had and if they could put that out of their mind and then deliberate. So that happened during the middle of the trial, but it was juror misconduct. All the other cases that he cited and the state relies upon are juror misconduct cases. Not unauthorized third-party communication that goes to the heart of the Sixth Amendment, right by a defendant to confront his accuser, to cross-examine witnesses who present evidence. When a third party makes an improper contact with the deliberating jury before they deliberate, that falls at the heart of the Sixth Amendment, which is a different animal altogether than where a juror engaged in misconduct. And that's where you get to Cameron. That's where you get to Green, which Green said it was a procedural communication, not a marriage communication. And Your Honor, in Bryant, well, I would note, Your Honor, dissented in Kelly, but in Bryant, I mean, no jurors were interviewed, as best we could tell by the record. But in Bryant, it was a death penalty case. Law enforcement, I believe it was Horry County, were out questioning the jurors' relatives and friends and trying to get their belief as to whether they believe in the death penalty. Apparently, some of that kind of leaked back to one juror, or maybe, but there was no record saying the jurors were prejudiced by that. But the court said that behavior cannot stand, and we find prejudice based on the conduct, not on the juror's testimony. And they didn't use the word presumption, but they found prejudice. And I don't want to get caught up in this issue of do we have to establish prejudice? I think prejudice is established, but the question has to be established. But the question is it presumed under the circumstances? And if it's presumed under the circumstances, what does the state have to rebut it? And so, prejudice is a touchstone, but the question is evidentiary presumption. Here, where there's a third-party communication that goes to the merits of the case, the law is crystal clear that there is a presumption of prejudice, and the state has the burden of proving it's harmless beyond a doubt.
Thank you, sir.
Thank you.
All right. Mr. Waters? I'm not going to go back and forth a million times, but if you want to have a short comment and additional part.
Very short, Your Honor. He said that these were not external influence cases, and every one of them that I listed was, Your Honor. Blake was a bailiff. Kelly was a pamphlet. Again, it was an external piece of information coming in. Grovenstein, it was an alternate. Again, that's an external influence. Bryant was a police investigation. Pittman was a bartender and a wife's comment. Green was a bailiff. And Covington was, evidence that was not admitted at trial that the jurors were aware of. So clearly, all of those were external influence cases, Your Honor.
All right. I do not regard State versus Cameron as the guidance that needs to be used by me in making a determination about this case. It's a Court of Appeals case. Since that case in 1993, there have been several cases, including Green, Oliver, and others, that very specifically talk about this issue of what the burden is when a motion for a new trial on the basis of after discovered evidence that involves tampering or alleged tampering with the jury. All those cases say that prejudice must be proved, not presumed. And it may very well be that is what's going to be shown. But for purposes of what the defendant must show as the case goes forward to an evidentiary hearing, the presumption simply by the contact, which we don't have any sworn evidence about except in the area of one juror at this time. A presumption is not the way to examine this issue, but rather specific evidence about what was said, when it was said, and how it was perceived by the juror is what I believe is required by State versus Green and other cases. And therefore, that is the approach I will take. All right, the next area of inquiry is the procedural argument of the state that this matter was untimely made. Mr. Waters?
Yes, ma'am, Your Honor. And again, we have raised the issue, as I talked about earlier, that we believe that there is at least an inquiry as to a procedural bar, that if the defense was aware of these allegations during the 10 days, then it is not after discovered evidence and the motion is untimely. And additionally, we also, as I previously expressed, have raised the issue that the affidavits on their face are insufficient to put in play an evidentiary hearing, and there are multiple cases that have in the state that have held, I think Yarborough is one of those that have held, showing was not made, that the trial court properly denied an evidentiary hearing. So we would just preserve those issues, understanding the court's plan and procedure that you previously expressed.
All right. Mr. Griffin or Mr. Harpootlian, let me say that I will say to the defense, to the state, I believe that issue needs further exploration, so I am not prepared to rule that this matter is untimely in the least. We're going to have a hearing on this matter, at which time this issue will be further explored. So the state has preserved its position, but you need not argue about that matter at this time.
Thank you, Your Honor.
And now the matter that to me is the heart and soul of what we're doing today is the witnesses, the exhibits, and the procedure needed with respect to the witnesses. And the witnesses, at least, are the jurors and the clerk of court, Ms. Hill. What I'd like each side to explore with me is how those witnesses should be presented, who should present them, and how they should be questioned, and whether there are any brackets or limitations that should be imposed on what these witnesses are asked. And I will begin with the jurors, which is really the heart and soul of the matter. Other witnesses are very secondary to the first issue, which is the jurors themselves. Mr. Harpootlian, you are the moving party, and you may proceed.
Your Honor, we agree, all 12 jurors should testify. I think both sides agree, Your Honor, it's a question of jurors. The only question is, not only question, but the first question would be, as Your Honor questions these jurors, would you, in all the cases the judge questions the jurors, would you want suggestions from us as to what additional questions after they respond to your questions, that raise additional questions? That's number one. Number two, each one of these jurors, except of the original 12, I think all have been interviewed. Maybe two have not been interviewed by SLED and given statements, recorded statements. The rest have all given recorded statements. And then SLED prepared a memorandum of interview. We have reviewed all these videos and the MOIs, and I can tell the court that the MOIs aren't consistent in many instances with what was said on the video, to the extent that information was left out. Now, if Your Honor is going to be very restrictive and ask, did the court communicate something to you, and did it affect your decision? I guess that's what we're hearing, Your Honor, when you're following State versus Green. If you're going to say that, ask those questions. There's some of these jurors who indicated they heard the court say what the jurors that gave the affidavit for us say, and I think they're going to say it didn't affect them. Which is fine. If it affected that one juror, we believe that's enough. And that juror has obviously given an affidavit to us. The alternate, which was excused, and we keep calling her the egg lady, but she was also excused. The alternate because she wasn't needed. The egg lady because the judge found that she had contact with people and discussed the case. They further indicated we'll be happy to do that, or the court can do that. So there are witnesses, and then we have the court herself. I talked to her lawyer this morning, who indicated she's not made a decision as to whether or not she would assert any constitutional right not to testify. And obviously that would be on a question by question basis. Maybe, I don't know, I mean, we're not ready to argue what the standard is on the Fifth Amendment this morning. But if she does testify, there are literally thousands of emails that were furnished last week by Colleton County, some information furnished by SLED this morning and the Attorney General, which might be utilized, I can't say right now what it would or wouldn't, depending on her answer, to impeach, to contradict. So I can't tell you what exhibits there would be or what we would do because I don't know what her answers are going to be. We believe we should be able to examine her as a hostile witness. We should be able to call her as a witness. Because the burden is on us, as Your Honor has just enunciated. Now, the only other thing I would say is this. Even if Your Honor determines that a piece of evidence or a question is not admissible for your consideration for purposes of the appellate record, we believe we ought to be able to make a proffer. So it may be that Your Honor allows us to go forward, and then in your decision decide it's not relevant, in your decision decide you didn't consider it, or whatever. But stop and go is going to elongate that hearing dramatically. And again, since you're the finder of fact, you can decide not what a jury's going to hear, but what it matters to you. So we think that the examination of the court should be wide open, and we think that the exhibits we would use to impeach her, we would attempt to keep it relevant to the specific issues in this case. I mean, her son has been indicted, for instance, her son's been indicted for wiretapping. There seems to be some inference, at least what we read in the papers, we don't have any specific knowledge, that she was aware of that and that wiretapping was in relation to some ethics complaint about her. That's not relevant. We're not going to ask her about it. We're continuing to examine whether or not there is some connection there, and we're investigating that. But at this point, I would tell you that's not where we're going. Where we are going, by way of example, is we have been furnished an email that she got on February 24th from somebody, which was a photo, a screenshot of a looks like a posting on some sort of Facebook page where the ex-husband of a juror, not the egg lady, alleges that his ex-wife has been talking about the case and she is going to vote guilty because she hates men. Now, we know she got it. We know she got it on February 24th, yet on the morning of February 27th, she tells in the chambers, the hearing we were all present at, that she had seen a Facebook page posting by Egg Lady's ex-husband alleging that she was talking about the case and she didn't think he was guilty. That Facebook page had never been produced, and then she produced a Facebook posting, she said, by the Egg Lady's husband. Turns out to be a guy I interviewed in Georgia, apologizing for what he had posted on Friday night, which concerned his wife's aunt meddling in their marriage. I think that's fertile ground for cross-examination. Your Honor may disagree with me, but I still would like to put those items into evidence for the appellate record at the time. The last thing I would say is this. In terms of Your Honor questioning the jurors, we need instructions from you as to whether you want, if you finish with the juror, do you want us to submit questions to you? I doubt you're going to let us question them. How is that process going to work? And will that be done someplace? Will it be done in this courtroom? Will it be done somewhere else? And if the jurors are going to be questioned outside of this courtroom, will there be a way for the public to hear what they have to say? Thank you. rightly points out, it's not just what they heard, may have heard from the court, but did any of the other jurors, for instance, Equate, we keep calling her, gave an affidavit indicating Becky said things like, don't be fooled, watch the body language, watch the body language testifies to Mr. Murdaugh. Did she relay that to any other jurors? It's not just what, I mean, did it, or did the sitting juror or the alternate in the one other point, in the memorandum of interview, now, the court's private lawyer, Mr. Lewis, objected to any videotaping or audio taping of the court when she was interviewed. But in the memorandum of interview, that is, the court indicated she had conversations with the four-lady outside the presence of the rest of the jury about what was going on in the jury room. Obviously, I would cross-examine her on that, but it may be necessary if she testifies to things that are inconsistent in that MOI for us to call the SWAT agent that did the interview to corroborate the MOI. The MOI may be introducible in and of itself as an exception to the hearsay rule, but I believe it may be necessary for us to call the SWAT agent. We're not going to, and Your Honor, you've indicated that you're not going to want any sort of summaries of those interviews by the jurors when we talk back in chambers, or necessarily the MOIs. You want your own fact finding with the jurors. To the extent that they contradict those, we may put all of that into the record for appellate purposes. And if you want to see those before you have this hearing, we obviously put those into the record today, or have those available to you, both the MOIs and the videos. We're obviously we're going to do whatever you tell us to do, but we're looking for some guides as to if there's anything we can get you prior to that evidentiary hearing concerning those memorandum interviewed by the SWAT agents and the videotapes. Whatever you instruct us to do. Thank you for some intelligence, Bill. Your Honor, we mentioned, and Mr. Griffin reiterated to me just now, and obviously you don't need to tell us this today because we're not going to be doing the questioning, but there is the consideration of 606B and the incursion into deliberations. At some point, we don't need to know that today, but at some point prior to you questioning the jurors, we'd like you to enunciate what your position is on that.
You're going to have to outline that a little bit more for me. What part of 606B are you discussing?
Well, it says, if I can find my glasses. Upon an inquiry into the validity of a verdict or indictment, a juror may not testify as to any matter or statement occurring during the course of the jury's deliberations or to the effect of anything upon that or any other juror's mind as or emotions as influence a juror to assent to or dissent from the verdict.
All right, so and what are you saying that in courts for this?
Well, I mean, for instance, if we show you, we prove to you that the court said, do not be fooled, or, watch Murdaugh's testimony, watch the body language inferring he was lying, he will be lying. One of the issues is if the juror who sat during the deliberations and said that the court said that, did she discuss that with any other jurors? Did she infect the jury? Does this allow you to do that?
Well, you certainly, if you go to 606B, it gives you some guidance about that. It says, when inquiry into the validity of a verdict or indictment, a juror may not testify as to any matter or statement occurring during the course of the jury's deliberations or to the effect of anything upon that or any other juror's mind or emotions influencing the juror to assent or dissent from the verdict or indictment or concerning the juror's mental processes, except a juror may testify on the question whether extraneous, prejudicial information was improperly brought to the jury's attention, or whether any outside influence was improperly brought to bear upon any juror, nor may a juror's affidavit or evidence of any statement by the juror concerning a matter about which juror would be precluded from testifying be received for these purposes. I take that to give us the guidance we need about the parameters of the questions.
But if, again, if the juror that gave us the affidavit, would she be asked, did you discuss that during deliberations? Can she do that?
That apparently is very questionable under the terms of 606.
Yes, ma'am.
And I intend to abide by that. The way those questions have been asked in many cases I have reviewed is to ask the juror whether that's still their verdict. If they ask about improper context and they talk about improper context, then the way to pursue it beyond that for the judge is to ask about the impact on the verdict, not on the deliberations themselves. That may be a small slice of difference, but I think it's very important to understand that no one, not myself or anyone else, is going to be asking the jurors about the specifics of their deliberation, and the rule is quite clear about that.
Okay. And is it clear that you will not be using the SLED interviews or MOIs to attempt to impeach?
I told you when that was brought to my attention in our Chamber's conference this morning, I have made my mind up about that. I don't know what's in those summaries or anything else, and we're going to have to discuss that. But again, I'm the one doing the questioning at this point, Mr. Harper.
Yes, yes.
And I'm trying to see what you all are asking, and I'm going to go to the state now and see what their reaction is to what you said.
Thank you, Your Honor.
Mr. Waters?
Thank you, Your Honor. May it please the court. Your Honor, again, we would concur with what Your Honor just said about Rule 606 and, of course, all the cases that we've talked about and the need to show prejudice. And obviously, when you're talking about external influence, that prejudice, which will be an appropriate subject of inquiry to the jurors, is whether or not there was an impact on the verdict. And we, of course, have suggested to Your Honor, not only based on the cases, that should be judicially conducted in a manner that protects the privacy of those jurors and it protects the privacy of their identities. These jurors, were drafted into service, and this inquiry, of course, has to happen, but it needs to be conducted in a manner that respects their privacy and should be, of course, judicially conducted. We have suggested those two questions. If we look at the Bryant case specifically talked about the fact that depending on how the examination goes, there could be questions suggested by the parties. And obviously, I think we would need to cross that bridge if and when that bridge needs to be crossed. And that starts with the court's inquiry to those jurors. And only if something arises that needs further inquiry could that be addressed at that point. And that could be even a discussion from counsel with the court as to what additional questions may be proper. When the state first became aware of these allegations, the first thing that we did was have SLED do an independent investigation, and the goal was good, bad, or ugly to get to the bottom of what, if anything, happened. And the result of that is why we're still here today. And that is that in speaking with the jurors that spoke to us, that the balance of the evidence, as well as in talking to the clerk staff, was that there was no impact on any verdict. There was nothing unprofessional or untoward that happened that had any effect on the verdict. And so when we did that inquiry, and that is what the jurors said, that is why we're here today, and that's what this hearing is going to address. The only juror that we have is the one who filed the affidavit. That's 630, and even she, or that person, only said that she, eventually voted guilty because she felt pressured by the other jurors. Did not even mention any external impact. And so, unless she's going to change her story, that is what was in her affidavit. So, the balance of the evidence is the reason why we're here today, and why this hearing needs to take place. Your Honor, as far as inquiry to those jurors, again, there could be a need that the parties would suggest questions, and it could be, depending on how things go, that the affidavits or maybe even the recordings, all of which have been provided to the defense, the full recordings of those interviews of any potential witness in this case have been provided to the defense. It could be that issues could arise from either the state or the defense as to impeachment, and we can address those issues as they arise under the appropriate rules, 608, 613, and the like, dealing with not only prior inconsistent statements, but other evidence that would be properly impeachable. Ultimately, I do need to address one thing as it deals with all of this, and that is the defense's contention that somehow the clerk is a party opponent in this particular case, and we believe that that is incorrect. Obviously, there is a hearsay exception or a non-hearsay determination in the evidentiary rules, I believe in 801, that excludes statements of a party opponent. But just because the clerk is an elected official of the state, that does not make them a party opponent in the way that term is defined. A party opponent is an active litigant before the case, and that is, I think, different. So we would certainly say that the hearsay rules would still be in effect as it relates to Ms. Hill and any testimony that she may provide. I know there's been some discussion about the order in which the witnesses may be called and whether or not Ms. Hill would be a hostile witness. And obviously that's under Rule 611 and I believe C, which would allow leading questions, if a person is hostile. I think, again, at this point, I don't know that any showing necessarily has been made, but I understand the defense may raise that point and we may have some arguments at that time. But I don't know that there's been such an identification between Ms. Hill and the state that would allow her to be identified as a party. I think that's far out of bounds, but also that she would be applicable to allow defense leading questions under 611C. Your Honor, in looking at the type of examination that would need to happen here, and again, the issue also arose of the Fifth Amendment. And I know that the defense would like to brief that issue, and we're happy to respond. We don't know exactly how that might arise in the course of any examination. We need to cross that bridge again when we get there. We would say, though, that the Fifth Amendment is question specific. And so, again, it may be something that this court has to rule, as is in any sort of evidentiary presentation, question by question, based on any objection by the parties. So it's kind of hard to say that exactly what the blanket position would be until we actually get to that determination. Ultimately, the defense referred to some information provided this morning. Actually, both sides exchanged last night their communications with the clerk during the course of the trial. So both sides did that last night. And there were a lot of communications with the defense as well. And so, again, I just want to point that out that there's any sort of allegation or insinuation that the state's not providing information. We've been very diligent about providing any and all information to the defense. And if any additional information arises, we will continue to do so. But both sides exchanged that last night. And of course, there's been some reference in their filings as to emails that were forwarded from the clerk to me and to my paralegal. And they've actually even listed me on the witness list. And Your Honor, as we have had a chance to peruse the defense communications with the clerk, there was just as much communication and offers of help. It was just a uniform across the board courteousness that's reflected from those. So we think that that's a non-issue. And we think that should not be something that arises during the course of this evidentiary hearing, at least as it would require communication from or testimony from attorneys. Your Honor, ultimately, as we look at the inquiry that will need to be conducted, as the state has made clear, it starts with the jurors. And only if something arises in that inquiry, further inquiry to those jurors may be necessary. And that could be in discussion with the parties, as I've stated before. And then I know Your Honor has indicated the clerk should testify, and we certainly understand that. The clerk filed an affidavit denying any of these allegations. And so, again, as we address the clerk's testimony, the state would have objection to some of the information I believe the defense would propose to examine her on. We believe that an inquiry should be limited to what is appropriate and relevant impeachment, but not should be just a far-ranging fishing expedition or full inquiry into a lot of subjects that have come up since the trial that we believe are not relevant to any inquiry that is before the court here now. Obviously, rules 404, 401, 402, and 403, as well as, which of course address relevance and 403 objections, 404, which addresses other crimes or wrongs or acts, Rule 606, or excuse me, 608, which addresses inquiry into other specific acts and impeachment, and Rule 613, which talks about prior inconsistent statements. All of those rules potentially could come into play depending on the nature of the testimony and the nature of the inquiry. But there have been allegations since the trial about the book, about this wiretapping case, about investigations into alleged use of office for improper gain. But again, all those are subsequent to the trial. And so again, depending on how the testimony goes, the state would raise appropriate objections at that time to limit the inquiry to what is appropriate for what is before the court we would submit. And that is what occurred during the trial. So we would make those particular evidentiary objections as things developed. Ultimately, that would be the state's position. I know that we're trying to put as much meat on the bones as we can at this particular point in time. But I think the reality is that the court's inquiry to the jurors will really determine the nature of the inquiry that needs to proceed from there. And at that point, the state would take the positions that I've outlined here today.
You reply.
Please, court, Your Honor. 404, I find it somewhat ironic. The state is quoting Rule 404, Your Honor. One of the exceptions to 404, I know this will be surprising to Mr. Waters, is motive. As if he'd never heard that before. He told me this morning one of the assistants that worked for Ms. Hill during this trial was told by Ms. Hill during the trial that a guilty verdict would be good for sales of the book. Motive, selling books. So we believe we should be able to get into that. We should be able to ask Ms. Hill about it. If she denies it, to call that witness, that assistant, and have her testify that she was told that. Why would a clerk do what we allege she did? We think is important for Your Honor in terms of credibility and context. That's number one. Number two, Your Honor, I think we've all agreed, you're going to ask the questions, whether we agree or not. And we do agree with that. The question's going to become, as we go through that process, how, if a juror says X and they've said in their interview Y, or if they've said to us Y, or didn't include it in the original affidavit, and you don't ask that question initially, how are you going to handle, or do you care, how we suggest to you a further question? Because as Your Honor's seen this morning, the back and forth can go on for a while, and we certainly don't want that to go on with a juror. So we're going to need some guidance on that. I'm not expecting that guidance this morning. The last thing is, as these jurors are examined, I need to understand a little bit about the logistics. Are we going to do it in this courtroom? Are we going to do it in another courtroom? Is the public going to be able to hear the responses? Will it be an audio feed if we do it somewhere else? Are you going to have cameras turned? You can do it in this courtroom and have cameras turned off? And we're obviously not going to refer to jurors by their names. Even though 3 of these jurors went on the Today Show, another one went on ABC. They were all in the courtroom when the judge had brought in. They were in the courtroom, all except one of them, for the verdict. Cameras were there. I'm sensitive to their anonymity but I don't know that any of them have any real anonymity anymore. Saying that, I think it's important, not only for Your Honor to hear their answers, but for the public to hear their answers. Thank you. Thank you.
All right. With respect to the jurors first as witnesses, I will be doing the questioning of the jurors, and I will notify the parties pretty promptly what I intend to ask the jurors. The ambit of what I will be asking them is informed by the question of whether improper contact was made with them and whether it affected their verdict. I understand that you, on the defense side, have views about what further should be asked the jurors on two levels. One, as a predicate to what you want to do with the clerk herself in examining her. And two, as a means of further attacking the credibility of the clerk in her testimony. I have not seen any of the SLED material or memoranda concerning the state's summary of these interviews and so forth. I will be open to receiving that if it's done promptly, because we've got a hearing coming up the 29th, and I want there to be plenty of time to revise any current ideas about who to subpoena, who to call as witnesses, and who has to do that. But I can tell you that I am very, very reluctant to turn this hearing about juror contact into a wholesale exploration of every piece of conduct by the clerk alleged to have been improper on its own, indicative of her or characteristics or personality or anything of that nature. This is a very focused inquiry that deals with this jury and what impact contact, if any, had on this jury. So I am very mindful of the limited nature of it. As I say, I'm not excluding submission in advance of information that would take the questions beyond the limited questions I've initially indicated. But I will be very hesitant about any of those questions as it involves propounding those questions to the jury. As it involves questions to Ms. Hill similarly, this is not a time to explore every mistake or incorrect statement or false statement that ever has been made by this witness. I am the judge of the credibility of this witness for purposes of this new trial motion. I don't think it's necessary, nor do I think it's proper, to explore each and every impropriety alleged to have been committed by the clerk. At the same time, what specifically should be asked is something that I will look at as I look at the submissions that are made before the hearing takes place about what is requested to be allowed as topics for questioning of the clerk and what exhibits should be used. I can't imagine allowing thousands of emails to be made exhibits in this process either emails sent by her to attorneys in the case, to other court officials in the case, or to other individuals during the course of the trial of the case. I certainly will try to preserve the appellate posture of defense in this regard, but I will put certain limitations on just a wholesale exploration of every problematic piece of conduct, ethical dealings with the county, and so forth. This is a very focused inquiry about this jury and its ability to render the verdict it rendered in an impartial manner. So I say that to tell you that when the clerk is offered, and I think the clerk is going to have to be offered as a witness, the whole allegation revolves around the contention that the clerk made contact with the jury about matters material to their verdict, that contact was improper, and that it impacted their verdict. There's a whole lot more that Mr. Harpootlian has indicated he'd like to explore that I regard as totally extraneous to the inquiry that we maintain. I'm not going to allow those questions to be asked by way of proffer and then have the clerk answer those questions and have that be the proffer, although I consider them irrelevant questions. We're not going to handle the case in that way. If I exclude a certain question from being asked, then the proffer will be whatever in writing is chosen to be offered in that regard. But I will not conduct a hearing where there's a whole side hearing in which every question desired is asked and either required to be answered or dealt with in some other way. I don't think that is an appropriate use of this very targeted hearing that I'm directed to have. I also think it makes a great deal of difference whether the questions that are being asked relate to the clerk's conduct at the time this case was tried, as opposed to other conduct at a later time or in connections with other things than the trial of this case. So I will be looking very carefully before we conduct this hearing and trying to give the parties as much advice as I can about what I would find to be acceptable topics to pursue. I think you're entitled to that, but I also think the record of the case is not to be used as a platform to explore each and every fault of each and every witness, whether it be the juror or the clerk. And I'm not going to have the hearing conducted in that manner. I think there are other ways of preserving topics that I rule should not be pursued than having those questions asked and answered, even though I ruled that they're not proper in the hearing. So I hope that explains kind of where I am on the subject of how questions are asked. And therefore, some of the suggestions that are made and the filings you made with me about the additional witnesses you like to call and subpoenas, I think we need to be sure we're all on the same page about what is acceptable in evidence and what is not. But I can tell you that I would not allow the subpoenaing and examination of attorneys in this case, of the judge who heard the case, or any of those type of witnesses. This case is very focused on the jurors and the clerk of court, as I see it. Now, it's about 11:15, close to it. I'm going to do this. I'm going to take a break for a minute. Let's take until 11:25 as a break. And in that time, I would hope that you formulate the other things you think we need to look at by way of the specifics of how this matter is to be conducted. I will then do two things. When I come back, and ask you for further ideas, both sides, as to who should be called, get very specific about who can be called and who cannot, who should offer these witnesses. And I would also at that time ask those who represent potential witnesses in this matter to come forward and have a conversation with me about your position on behalf of your clients. I think that's particularly important because as we have the actual hearing itself, I've never heard of a situation where a witness can have their lawyer actively participate in the examination of the witness in a proceeding in which the witness is being offered. So I would not allow that, but I think we can protect the legal positions that attorneys for witnesses want to take and need to take and want to put on the record by pursuing in the way I just outlined, and I'll be prepared to do that when we return. All right, court will be in recess.
Thank you, Your Honor.
Thank you, Your Honor.
Okay, well, I guess now we'll let me take a quick look and see what we've got going on. See if there's anything on the Taylor Schabusiness hearing. Not seeing anything at the moment, so let me switch over to Michelle Troconis trial. Find the starting spot here. This isn't as easy as I thought here. Okay, here, I think we got it now. Let's go back a minute.
Thank you. We concluded the last session with an offer of proof concerning the technology of detection of hemoglobin. Attorney Manning, have you concluded that offer of proof?
Yes, Your Honor, I would just like to be heard on it if I can.
Yes.
Thank you. With respect to the presumptive test, Your Honor has already ruled that it is admissible. What I would like to clarify, I know Your Honor is concerned with respect to the conclusive nature, if there's any on the direct examination. What I would like to reiterate is the state is in no way seeking out a representation from the witness that this is a conclusory test. Number one, because it's not. Number two, because I don't believe Detective Riley testified to that, nor will he. What I would indicate is fall back on the many arguments that we had on Friday concerning the fact that it goes to its weight, not its admissibility, and would focus as well on the fact that it can be cross-examined, which I'm sure Attorney Shohern will cross-examine on that subject. Just because something is inconclusive does not mean it is inadmissible. With respect to the nature of the testimony, Your Honor, the witness was very clear that he was trained by the lab, that he did this test, I forget how many times, but for how many years, numerous times. He was also very clear that it's a presumptive test, that it could be anything from human blood, animal blood, to also come out with radishes or something that is not blood related. All of that can go to before the jury and they can make their own determination. It really is, in the state's view, up to the jury to determine, in light of all the evidence that's presented, whether or not what Detective Riley testified to is blood or radishes. So the state would offer it.
Attorney Shohern.
Yes, what the state has not indicated is that there was no confirmatory test whatsoever. I spent the weekend looking for it following when they took a swipe, when it went to the lab. There's no evidence this is even blood. So therefore, not only has it no probative value, as Moody points out by itself, there's no confirmatory test whatsoever. But I'll go further. It was then sent to the DNA department at the state lab, and they found no DNA of Jennifer Dulos in that sample. There was some unknown DNA that they found, but it did not apply to anyone connected to this case. So wholly aside from the fact that that this is not a matter, as the Supreme Court said, where it's inconclusive, the Supreme Court has said it has no evidentiary value, no probative value whatsoever. Your Honor allowed as I understand it, the limited information, because when it was collected on the floor, there was a suggestion that it was then part of the blood. It was there were some visible drops that were believed to be blood, and then Your Honor said it was sent on. But this now has to do with the Chevy Suburban. There is no evidence of blood. I want to emphasize that. that will be introduced. That was even, to my knowledge, tested. I was looking for a confirmatory test. Therefore, and it's not the DNA. There was no DNA of Jennifer Dulos in there. So the sole purpose is prejudicial. The sole purpose is to give the false impression, and I'll emphasize, false impression that Mrs. Dulos might have been in the rear of that compartment, and it's going to be, I don't know when, somewhere down the road where I'm only going to be able to cross-examine to show that it was not related to the case. So the state has, in my view, tried to introduce something that has zero evidentiary value, never mind getting to the weighing of probative versus highly prejudicial. It's to suggest falsely. It would be, in my view, it's as erroneous as putting on false testimony, perjured testimony, because it has no value even down the road. So the court made a ruling based on just what was presented at the time. We're going to allow a detective who collected samples now to testify as to its meaning, when all he did, as far as I can tell, is he gets kits from the lab and has taught how to use it. I note that phenolphthalein, which is one of the things in the kit. You know, previously, I don't have one now, I had an in-ground swimming pool at my house. That's what you test for chlorine levels. It turns red. If it's too dark, it gets bright red. If it's too little, it's pink. So that's what we're talking about. A little kit. You spray it in this case, or you put some on, you dab it on. And I think, what was the second thing? Peroxide. Again, I don't have that much familiarity with hydrogen peroxide other than it's used for infection sometime. I guess some people bleach their hair with it. But the fact that he's going to then go on and explain what it is when he has no scientific acumen whatsoever, there's no training in that, when the jury's going to be hearing this based on what I submit as a lay opinion, and then later on, at some point, we're going to hear it didn't lead anywhere. So I don't even understand why it's being offered.
If I can just address the fact that counsel is comparing it to perjured testimony here, I want to talk about false representations. There are two items that I think are at issue and should be separated and clarified. One, the presumptive test that Detective Riley talked about with respect to the tissues or the paper towels, which I think was what the objection came from. The other, he is now throwing into that same argument and objection is the luminol pictures, which is the trunk of the Chevy Suburban. So just to keep those totally separate here, with respect to the paper towels in the presumptive test that Detective Riley did on that, as well as numerous items in the garage that day, the state will stand on its argument, but also reiterate the fact that a confirmatory test was not done at the lab, and it's purely on a presumptive level, makes it even more clear to the jury the nature of this testimony. This is a presumptive test. It is inclusive. It's inclusive. It's not a conclusory lab test. It could be A, B, or C. Detective Riley is going to testify to that. It is clear. The jury can give it the weight it deserves. Switching to now the luminol, we can talk about false representations. Counsel indicated on Friday to the court that there was testing done on that trunk that came back that there was no blood in that Chevy Suburban. There was no testing that was done with respect to blood on that trunk. So that representation is completely false. With respect to the luminol pictures, Detective Riley, when he testifies to it and when we get there, which I believe was Your Honor's ruling on Friday, they were admitted for ID only until the offer proof would come with respect to those photographs, which the state was not able to elicit. But apparently we're talking about that now. Those, Your Honor, again, presumptive nature, it's a presumptive test. It is what it is. Just because it is inconclusive does not make it inadmissible in light of all the other evidence is presented.
Thank you. First, the court will address the contention that the jury will receive a false impression that the blood of Jennifer Dulos was found in the vehicle. The jury will hear the testimony from this witness and essentially is not testifying as an expert. He's testifying about his training as to what he was trained to conclude based on certain circumstances and results. If the jury hears testimony about a presumptive test, then the jury has to understand what the term presumptive means. That's going to be up to the state or the defense or both. The testimony by this witness and the wide open avenue for cross-examination in this court's view does not allow the jury to fall simply into a hole of false impressions. The court will allow the testimony. Bring the jury in, please.
Just for clarification, is the court also going to allow this witness to explain what the test does without a foundation as to his scientific, lack of scientific ability, or is he just going to be able to state that he collected it for that reason?
Well, the court is going to wait to hear the questions. And counsel has the opportunity to object. Good morning, ladies and gentlemen. Good morning. The counsel stipulate to the presence of all of the jurors.
Yes, Your Honor.
Thank you. Is your witness here?
He is, Your Honor. State would recall Detective Riley. I may just inquire if everybody's television.
And Detective Riley is still under oath. You may be seated, Detective.
Thank you, Your Honor.
Your Honor.
Detective, will you please just indicate, just for purposes of the record, your full name?
Yes, it's Matthew Riley, R-E-I-L-L-Y. Yes, ma'am.
If I may just have a moment, Your Honor, my wire got disconnected for the television. Thank you. Your Honor, for the record, I'm calling up states 9. I believe when we left off, it would be on file 3. And photograph 8. Detective Riley, how are you?
Good, ma'am. Thank you.
Just to recap a couple questions, we can take a look at the screen behind you. Again, states 9, file 4, picture 8. And briefly, if you could just describe what's depicted in that photograph.
Yes, that's a paper towel roll that I found on the counter of the kitchen island at 69 Wells.
And the 13?
The 13 is a evidence placard that denotes it's going to be seized as State Police Exhibit 13.
And did you put that 13 there?
Yes.
Picture 9. What does that depict?
That depicts some of the blood-like stains I found on the paper towel roll.
Now, sir, did you do anything with that paper towel holder?
I field tested it for the presence of blood, ensured it was photographed and documented, and then I packaged it.
You say field test. What does that mean?
I field tested it for blood. I use a screening test called the Kastle-Meyer test.
I would ask the court to note my objection.
Thank you. And for this test, I used 2 chemical reagents, phenolphthalein and hydrogen peroxide. And
If you can just walk me through what exactly is a Kastle-Meyer test?
it's a presumptive blood test.
Well, I would object, Your Honor, and there's been lack of foundation for this testimony.
Well, the question is, what is this field test? And the objection is,
There's a lack of foundation. This witness can, well, I think the question is, what is a Kastle-Meyer test? But I thought the question was.
If I can, Your Honor, I'll withdraw it and go back. What training have you received?
I've received training both at the State Police Forensic Lab on this particular test and in one of the crime scene courses I took at the University of New Haven on
What year did you receive that training?
sometime in the early 2000s.
And about how many tests have you performed?
Thousands.
Okay. Now, asking exactly how do you perform this test?
You perform the test by taking a swab, one of those long handle Q-tips, taking some, then you put a drop of the hydrogen peroxide on it. And if you get an immediate color change, you'll turn a bright pink color. That's a positive test.
Okay. Now, I'm sorry, did you say the phenol? I'm going to butcher that.
Phenolphthalein.
Phenolphthalein. Where do you get that?
I get that chemical from the State Police Forensic Lab in Meriden,
And the other item that you use?
which is the hydrogen peroxide and the sterile water that I use as a solvent. I get those from the chemical supply house.
And are these common tools on the van?
Yes.
Okay. Are they designated in different tubes? Can you walk me through how you store those chemicals?
The chemicals are stored in a refrigerator on the van, in a, almost looks like a plastic fishing box.
Sir, about how many residences or vehicles have you processed in your career with the Western District Major Crimes van?
Countless, ma'am.
Okay.
It's approximately 1,000 crime scenes,
And how many years were you with the van?
14.
Okay. And how many times have you utilized that test that you were trained in?
I've utilized this particular test thousands of times.
Now, with respect to the actual process of conducting the test, can you walk us through what you do? I believe you indicated you swab the item.
Yes. So prior to using this test, I'll test the reagents on a known blood source in the van. We use horse blood or pig blood. And then for each suspected blood stain, I'll go ahead and take a swab of the suspected material. In this case, I took it from inside the cardboard tube. Put a little bit on the Q-tip, treated it with 1 drop of phenolphthalein, waited a second or two, then I put a drop of the hydrogen peroxide on.
Does the swabbing of the actual item damage or alter the item itself?
No, it does not.
Now, you mentioned you did a control with animal blood or horse blood.
Yes.
Do you keep that in the van?
Yes, we do.
Okay, why do you do that?
It validates the test. It ensures that the reagents are working properly.
Do you do that every time you use that same reagent?
At the beginning of processing, yes.
And if you were to open a new reagent, would you test it first?
Yes,
And did you do that test here on this day, on May 25th, 2019?
yes.
Now, if it changes color, what color does it change into?
It changes to bright pink.
And what are the results? What does it mean when it changes to bright pink?
It's a presumptive blood test. It just tells us that the material is presumably blood, but it doesn't tell us whether or not it's human blood or animal blood. We will get a positive test result on any blood.
Your Honor, I'm going to object now. This goes into scientific testimony, and his opinion as to the conclusion of what it shows is not based on his training or his scientific act.
Well, the response was, it's a presumptive test. And that the presumptive test is not, as the court understands the testimony, limited to human hemoglobin. And so the objection is overruled.
Is it conclusory in any way?
No, further testing needs to be done by the forensic lab.
If I just may have one moment, Your Honor. And did you conduct that test on Exhibit 13, the paper towel swabbing that you did?
Yes, I did.
And what was the result?
The test was positive.
Actually, I should ask you this, sir, if I can. With respect to the kitchen area of 69 Wells, did you seize anything else in that area?
Yes.
What did you seize?
I found another blood-like stain on the faucet,
And is that the kitchen faucet?
the kitchen faucet on that center island.
Actually going to draw your attention to the screen behind you, states 9, file 3, picture 10. If you can, just explain what's depicted in that photograph.
This is the kitchen sink faucet on that island in the kitchen. And what you see there, marked by a adhesive label marked Exhibit 79, is the location of a dilute blood-like stain.
If you can, could you please, Your Honor, may I
Yeah.
ask him? Sir, if you could approach the screen, please, and just point out to where you're addressing.
It's right in this area.
Okay, lower right-hand corner, I'm actually going to scroll in. If you can, sir, there's a white, I guess, ruler marking there. Did you put that there?
Yes.
And EX79, what does that mean?
That's just our designation, and it's going to be State Police Exhibit 79.
And the marking that drew your attention, is that located on the screen with it zoomed in?
This area here, ma'am?
Yes, please.
Yes.
Okay. And what did you do, if anything, with respect to that area?
This area was field tested, again, using that Castlemeyer test. And the area was marked as an exhibit. And then I later collected a sample of this stain with 2 swabs that were moistened with sterile water.
Okay. Couple of questions on that. You tested it utilizing the same procedure that you just testified to?
Yes, it's always the same procedure.
Did you wear gloves while you did so?
Yes,
And any other protective gear?
just gloves.
Now, with respect to the Castlemeyer, can I call it KM?
Yes.
Is that okay? With respect to the KM test, what was the result?
The test was positive
And you indicated you took 2 swabbings. Was that after the test or before?
after the test.
And why 2?
We take 2 swabbings just for more samples, to collect more samples.
With respect to this this kitchen sink area, did you take any more samples or seize anything on the sink faucet?
Yes, up in this area here, we found another dilute blood stain.
Picture 11,
Yes.
if you can, sir. Could you please point out where and what you see in that photograph?
Yes, this is the dilute blood-like stain we found.
What did you do, if anything?
Again, the area was initially field tested using that KM test. The test yielded a positive result.
Could I just have a continuing objection so I don't have to keep interrupting on this issue with regard to the presumptive?
Thank you, overruled.
And following the test, I marked it as Exhibit 14 and later collected it with that same process of utilizing 2 swabs.
And with respect to the kitchen, sir, anything else in the kitchen area?
Yes, They're down below in the cabinet underneath the sink. We found some items of interest.
States 9, picture 12. What does that depict?
This depicts, what's that, exhibit 15, which was a blood-like stain that we found on the handle.
Sir, if I scroll in there, do you see, if you could point out, where is that blood-like stain shown on that?
Yes, it's this area here.
What did you do, if anything?
Again, it was field tested with KM. Positive test result. It was marked, photographed, and collected with that same 2-swab process.
And it says EX15, what does that mean?
State Police Exhibit 15.
Thank you. Now, inside, I see there's a yellow placard, 17, what does that mean?
We found 2 items of interest in there
Actually,
inside the cabinet.
if I can, I'm gonna go back one, actually, if I can.
Sure.
I'll just show you 14. If I can, states 9, picture 14, please, in file 3. You can explain what that photograph depicts, please.
The 2 items of interest that we collected from underneath the sink were Exhibit 16, which was a pair of latex gloves, and Exhibit 17, which was a box of white plastic trash bags.
Did you make the decision to seize 16?
Yes.
Why?
The gloves had a texture to them, they're dishwashing gloves, and I previously on our walkthrough, we found a blood-like stain pattern in the garage on the floor that appeared to be glove print, and the print appeared to have some sort of texture to it. It was somewhat similar to these gloves here.
And the 16 is what does that delineate?
Again, State Police Exhibit 16.
And 17?
17 is the box of hefty trash bags.
Did you make the decision to seize those, sir?
Yes.
Why?
Just because we found what appeared to be evidence of cleanup inside the garage. So, it was, we assumed that possibly one of these trash bags may have been used. And if found, maybe they could match it back to that box.
What day did you collect this evidence?
This was collected on May 25th of 2019.
Thank you. Anything else in the kitchen that you seized or swapped that day?
We found another blood-like stain up on the edge of the countertop.
Can, states 15. What does that depict, sir?
Again, that's the this blood-like stain here. That's discoloration.
And what did you do, if anything?
We field tested it for blood using that KM test. It was positive, and then we collected it using that same swabbing method.
2 swabs as well?
2 swabs.
Okay. I want to show you what's marked as states 16. I'm sorry, it's actually states 9, file 3, states picture 16. What is that?
This is a toothbrush that I found in the master bathroom upstairs on the 2nd floor.
And there is a yellow placard 31. What does that mean?
We seize that as State Police Exhibit 31.
Why did you seize a toothbrush?
In missing person investigation, we attempt to collect a pseudonym or something that a pseudonym DNA profile can be developed from. We do this by either collecting the missing person's toothbrush or razor, something of that nature.
By missing person, do you mean Jennifer Farber Dulos?
Yes, ma'am, Jennifer Dulos.
On May 25th, 2019, did you collect anything else from the house?
Yes, several other items.
You can have a seat, sir. Actually, I'm sorry. I'm going to show you what's been marked as 17. Actually, it's 9, file 3, picture 17. What is that?
That is a hair that we found on the garage floor.
Now, you indicated you did not process the garage on 525. Did you take this out of the garage on 525?
Yes, I did.
Okay, why this item?
Because the hair was loose and it could have easily blown away.
If I can, I'm just going to scroll up. Is the hair depicted in that photograph?
Yes.
Now, with respect to, actually, I apologize, strike that. And I'm going to show you what's marked as picture 18. What is that photograph?
That is one of the seals that we use to seal up the house at the conclusion of processing on the 25th. That is on the, appears to be the central garage bay.
That red tape that's depicted in the center part of the photograph, did you put that anywhere else in the house?
Yes, on the garage bay doors and the front door. And
Do you recall any other ones?
not off the top of my head, man.
Okay. With respect to, oh, yes, actually, right above the red tape, right, that the gray marking, what is that?
That's a garage door remote.
Okay. And did you take any action with respect to that?
Yes, on the 25th, I swabbed that in an attempt to collect any latent DNA material that may have been on it.
Okay, did you use that same two-swab process?
Yes.
Thank you. Now, on the 25th, did you, again, why didn't you process the garage on the 25th?
Our plan was to call in a bloodstain expert to come in to process the garage with us.
And who did you call?
It was then Lieutenant Mark Davison.
Okay. And what day was he scheduled to process the scene with you?
Objection, irrelevant with this witness.
Well,
Thank
the
you.
question is on what day was he scheduled to process the scene? And the objection is relevant, overruled.
He was scheduled to come on the 27th, which was Monday.
Now, did you go anywhere else on May 25th?
Yes, I did.
Where did you go?
In the morning, I went to Lapham Road in New Canaan.
Okay, sir, I'm gonna have you take a look behind you. This would be States 9, File 5, Photograph 1. Do you recognize what's depicted on that photograph?
Yes,
What is it?
that's an overhead view of the area of Lapham Road that I visited on the morning of the 25th.
If you could, would you mind standing up and just pointing to the area that you visited that morning?
It was generally in this area here.
Why did you go there? You can have a seat, sir.
Well, before you proceed, counsel, would you just indicate for the record what quadrant of the photograph
Oh,
the witness pointed to?
I apologize, Your Honor. For the record, that would be the middle to lower center right area. Is that correct, sir?
Yes, ma'am.
Thank you.
Thank you.
Now, why did you respond there?
We learned that the New Canaan Police Department had located Jennifer Dulos's Chevy Suburban on that road, and that they were going to be in the process of towing it back to their police department. We wanted to go there first to take a look at the outside of it, photograph it before it was loaded onto the tow truck.
What time did you go to Lapham Road that day?
It was in the morning, approximately 7 o'clock.
What did you do when you arrived on scene?
I looked at the outside of the vehicle and then photographed the four sides of it.
Did you walk around the entire vehicle?
I believe so, yes.
And with respect to, well, if I can, I'm going to show you, you take a look behind you. This is again file 5, States 9. Picture 2, do you recognize that photograph?
Yes.
What is it?
That's the photograph of the Chevy Suburban I was speaking about.
Did you take that photograph?
Yes.
Now, with respect to walking around the vehicle, how close was it to the, I guess, foliage and trees next to it?
I believe the right-hand side of the vehicle was right up against the bushes.
And the right-hand side, would that be the driver's or the passenger side?
I'm sorry, the passenger side.
Thank you. And the direction of the vehicle parked, I guess, is that, actually, if I can just go back briefly to picture 1. Sir, do you know what road is on the bottom here going from left to right?
That's the Merritt Parkway,
Okay.
Route 15.
And with respect to the vehicle, how it was parked, do you know which direction it was facing? Was it towards or away from the Merritt?
It was facing the Merritt.
Now I'll show you picture 3. What does that depict?
That's the left or driver's side of the vehicle.
And picture 4.
That's the rear of the vehicle.
Now, were you able to walk around the vehicle over here on the right side? You can see my cursor.
Not completely. I really just kind of had to look from, where I could access.
And did you find anything on that vehicle that you took note of?
I found some blood-like stains on the outside of the vehicle.
Where?
On the outside of the vehicle.
Okay, and where on the outside of the vehicle?
I believe it was on the rear bumper.
Did you photograph them?
Yes, I did.
Or I should say, I'm sorry. 5, states 5, what is that?
That's one of the blood-like stains I found on the vehicle.
Now, if I scroll in, it does not have, this photograph doesn't have a writing here. Did you put that white, I guess, measurement marker that we've seen?
Yes, I did.
Okay. There's nothing written on it. Is there a reason why?
I just included in the photograph for scale.
Did you process or take any action with the vehicle as it remained on scene?
No.
And what is 6 depict, please?
Again, that's another view of that same stain.
Now, so I'm going to draw your attention back to May 27th. Well, actually, before I go there, I'm sorry, strike that. The evidence that you collected on May 25th, I think we went through some of them, the swabbings, the 13 through, I forget the number now. What happened to the evidence after you packaged it and gave it a evidence number?
The evidence was sealed, and I labeled them appropriately per our protocol. Some of the electronic evidence was turned over to the New Canaan Police Department so they could pursue those items, examine those.
With respect to the items that you were shown photographs of, what
Yes.
happened to those?
I secured those in the major crime van, and at the conclusion of processing, I drove those up to our headquarters in Litchfield, secured them in the evidence room. And then on the 27th in the morning, I returned to Litchfield, took them out of the evidence room, put them on the major crime van, and drove them back down to New Canaan.
Why did you do that?
Because they were still in our custody.
Okay, and was it a state police case at this point?
I'm not sure when that changed, ma'am. We wanted to keep the evidence together, and normally we turn over evidence to the local police departments when we do an assist all at once.
Okay. And on the 27th, did you drive the van to 69 Wells that day?
Yes.
And in the van, is there a place to store the evidence?
We usually keep it in a banker's box on the floor.
And when you arrived at 69 Wells Lane on May 27th, who was there?
A lot of the same crew from the 25th was there, with the addition of Detective Jamie Pearson and Lieutenant Mark Davison.
And between 525 and, well, strike that if I can, that photograph we showed you with the red tape
Yes.
on the doors, was that in the same location when you arrived back on 527?
Yes,
Was anyone from New Canaan Police Department on scene on 527?
they had posted a uniformed officer in the driveway.
Did you see anybody from New Canaan Police Department go into the residence with you that day, or not with you? Did you just see them?
Yeah, they were just in the driveway, ma'am.
Did they enter the garage?
Not while we were processing it.
No. On May 27th, did you process any other area other than the garage?
Yes, we again continued to look through the rest of the house. In addition to the garage, we also did a latent print exam in various areas of the house.
Did you do that before you processed the garage or after?
It was pretty much ongoing. However, the latent print exam was probably one of the last things we did,
Why do you do that as part of the last things you do?
because we use standard fingerprint powders and it really makes a mess.
Was in the processing of the garage, was the garage, I guess, divided up?
Yes, we came up with a grid system just to make documentation easier. We laid out a grid with yellow tape similar to masking tape that has measurements on it. And we give them letter designations, A, B, C, D, all the way up to G.
You mentioned Detective Pearson was present with you on 527. What was her assignment?
Her assignment was to create a sketch map of the garage.
Have you reviewed those sketch maps, sir?
Yes.
I'm gonna draw your attention to the screen behind you. I am in States 9, File 6. And actually, if I may. Do you recognize what's depicted on the screen behind you, sir?
Yes, that is one of the finished maps that Detective Pearson created.
Did you have a particular process or procedure you conducted throughout the garage that day?
The garage was examined, for evidence along with the documentation done by Lieutenant Davison. We kind of worked it together.
Now, I'm going to ask you a couple questions, starting with garage A, marked A, if I can. Do you recognize the map behind you, sir?
Yes.
Okay. With respect to the letters and numbers that are printed inside of A, for instance, A18, A17, A16, what exactly are those supposed to designate?
Those numbers are for individual stains that Lieutenant Davison designated for his examination.
And the EX numbers or the EX letters?
Right, so those were samples that I took for DNA identification purposes. So Lieutenant Davison was examining the bloodstain patterns, and in his examination, he selected stains, gave them those letter designations, and from each stain pattern, I chose one and collected it.
Why did you only choose one?
Really, it's just to get a representative DNA profile from that stain pattern or region of the garage.
And as you say, you chose one. What did you do? I mean, if you could walk us through the process briefly.
Using the same method that I used on the previous blood-like stains. I field tested it with a KM test. Noted that, whether it was positive or negative, and then using that two swab process with swabs moistened with sterile water, I collected the stains.
I can just have a moment. It is. So just a couple questions if I can. If you can take a look behind you. Showing the map on the left, but on the right side, it's photograph 2 out of file 6 on states 9. What does that depict?
That depicts the photograph, an overall photograph of Area A, and corresponding overhead view on the sketch map of Area A.
Was that prior to processing?
This was in the process. This was the beginning of that examination.
And I can actually bring that back down. Okay. Picture 3 of that same file. Sir, what does that depict?
Again, that's another view of Area A.
If I can, just draw your attention and ask you some questions about these. There's a sort of like an upside down L-shaped file. What is that there for?
That's to help give scale to my approach to the
If you
screen.
can, thank you.
So you can see this discoloration here. That appeared to us to be white mark, where maybe some blood-like material was on the floor, and there was an attempt made to wipe it up.
Thank you. I'm sorry, sir, if you can, just move that microphone behind you, maybe up a little. The one. Thank you. And the yellow arrow up on the upper middle part of that photograph, what does that depict?
That's usually placed by the photographer to denote north.
So it's directional?
It's direction, correct.
And this yellow marking, is that the yellow marking you were talking about before?
Correct, that's that yellow masking tape I was talking about.
Okay. Now, with respect to these 3 items, did you put those down?
No, I did not.
And over here on the right-hand side, we have that same, I guess, ruler marking. What does that depict?
That's that same L scale is being used to denote another stain pattern found on the garage floor.
And is
close
that,
to the wall.
oh, I'm sorry. Is that for documentation?
Yes.
Now, with respect to the rest of the garage floor, there's these little dots here all over. I'm gonna push the photograph up if I can. All these little markings. What are those?
I mean, it's the garage floor. So you have plant material, you have, other types of vegetation, you have sand, road salt.
Now, I'm going to show you picture 4, sir. In that same file. What is this?
This is part of Lieutenant Casey's examination of the garage floor.
Were you present when these markers were placed down?
When they were placed down, no, but I observed these in place.
And just to, and what do they read, please?
They read A12, A13, A14, and A15 with my marking of State Police Exhibit 40.
And this is this corresponding on the map on the left-hand side of the screen?
Yes, in this area here.
Okay. And with respect to states 40, did you utilize that same two swab process in swabbing it?
It's the same process. It's first KM tested and then collected with the 2 swabs.
And the KM test?
Was positive.
And just to clarify, this is which one is what is this depicted?
That is stain A12.
Okay, if you can, so I'm just going to show you a series of photographs. If you can just point to the sketch map to show correspond where they are located. If you can,
A12.
thank you. Now state 6,
A13,
state 7,
A14,
and states 8.
it's A15 where Exhibit 40 was sampled.
And is that the area that you swabbed that day, sir?
Yes.
Thank you, that's state 9. With respect to these areas, did you mark these or delineate these in any way?
I did not place those scales.
Now, with respect to this area, if you could tell me what this is?
This is a photograph taken overhead of stains denoted as A16, 17, and 18, along with Exhibit 41, which is in this area here.
Now, just briefly, if I can, I just want to be clear. With respect to A16, 17, and 18, do you recall viewing those that
Yes.
day? Okay. And you took a swabbing off of which one?
Off of stain A18.
Okay, which is up here, right?
Correct.
Who took the photographs that day?
It was Detective Katie Keppel and Detective Bob Hazen.
If you can, sir, same question, series of photographs, if you can just point to the screen where.
This
it
is stain A16, A17, and A18.
Do you recall, by the way, this is kind of leaning, I guess, angled one way, and then I'm going to draw your attention to the preceding 2 photographs, 17 and 16. Actually, I'm sorry, it's photographs 12 and 13, but A16 and A17. They're leaning the other way for the photographs, and the overview has them this way. My question is just, which way are they supposed to be?
The scales were not moved. That makes things easier. The photographer was probably just standing on one side of the stain or the other.
In the course of the photography and processing, seen the scales ever move?
Not on the garage floor in this case.
And I believe and actually, did you review the part designated as garage B? And if I can, sir, do you recognize what is depicted on the screen there?
Yes, that is another.
Oh, I apologize, I hit the wrong.
Sure.
There you go.
And that is the another part of the left side garage bay in the center of the garage.
Okay. Is the photograph 1 on state 9, file 7, photograph 1, is that area depicted on the, or is, I should say, the map, a depiction of an area on that photograph?
Yes,
If you could just point it out on the photograph, please.
it's this area here. You can see the B placard right there.
And for the record, that was the middle portion of the
The
photograph.
middle, correct.
Okay, now on this, we have, on the map portion, we have the numbers ranging from B3 all the way up to B11. Is there a B1 or 2?
That I don't know.
And states picture 2, does that depict an area depicted in the map?
Yes,
and states 3.
Yes, that's the right-hand side of the map.
Okay. States 4. What is on that photograph, please?
That's a fragment of paper towel that appeared to have blood-like stains on it. That we found in area B of the left-hand side of the garage, and it's located right there on the sketch map. It is exhibit 42.
For the record, you're pointing to the middle portion of the garage. Question about the, well, sorry, withdraw that. With respect to the 42, that paper towel, can I ask you to describe some of the, I guess, dots that are contained in the 42? What exactly did that appear to be to you?
Yes, this material here appears to be plant-like, hard seeds or.
Did you take any swabbings in 42?
I did not,
Why not?
because I just seized the entire fragment of paper towel.
How did you seize it?
I put it in either a paper bag or a paper envelope.
Did you seize anything else out of that area B?
Yes.
What did you seize?
There were 2 stains. B3, I took a sample of is exhibit 38. B11, I took swabbings as exhibit 39. And exhibit 43, which I believe was another paper towel fragment.
Picture 5. What does that depict, sir?
That's another paper towel. It's a larger paper towel fragment with apparent blood-like stains. You can see this reddish staining here.
What did you do, if anything, with the 43?
Yeah, I just sure it was photographed, sketched into the map, and I seized it in a similar manner as 42.
Did you take any swabbings?
I did not.
And if you can, sir, is what's on picture 6 depicted on the map as well?
This was a stain designated as B3 that I took swabbings of as exhibit 38.
And did you do any testing on exhibit 38 as well?
I did a KM test.
And the results?
Positive.
Now, what does this depict, sir?
That is stain B4 located there.
And for same questions for the next couple, if you wouldn't mind just pointing out where it appears on the map corresponding with the picture. So picture 8, B5.
B5 is here.
Picture 9, B6.
B6,
Picture 10, B7 and B8.
B7, B8,
Picture 11, B9.
B9.
Picture 12, what does that show, sir?
So that is stains B9, B10, and B11, which are up in this area here. A sample of B11 I swabbed as exhibit 39.
And that is, if you, okay, and the same swabbing process, same every,
Same swabbing process that was also tested with the KM test that was positive.
now, picture 13, what is that, sir?
That appears to be one of those blood-like stains, that swipe mark that we saw up in area A.
And is this depicted on the map in any way?
I don't believe so.
Was that contained in area B at all?
Without seeing an overall shot, I really can say that.
Okay, let me see if I can. Here's the overview. Does picture 1 assist you in any way? If it doesn't, that's, if you could just say that.
It's hard to say that.
Now I'm going to ask you, if I can, about the bottom part of that garage side. You could take a look. Are you familiar with Detective Pearson's map for C?
Yes, this is the portion of that left garage bay closest to the door.
And for the record, I'm going to say it's 9. I am now in file 8. File 8, picture 1, what does that depict, sir?
That depicts that left garage bay. And area C is in, kind of the closest to the driveway. It's this area here.
Okay, and for the record, he's pointing towards the middle bottom portion of the photograph. Picture 2. What is that a picture of, sir?
Those are some more of the flood-like stains we found on the garage floor.
And the yellow arrow again?
Again, denotes north.
Picture 3. What does that depict, sir?
That is area C with some of the stains and exhibits marked up.
We have the 68 placard right here. What is that supposed to designate?
That designates another fragment of paper towel.
I can just. Is that depicted on the photograph?
Yes.
What did you do, if anything, with 68, please?
I collected it in the same manner as the other fragments of paper towel. It was packaged in paper.
Did you take any swathings?
I did not.
And if you can, sir, picture 4, and if you wouldn't mind, same thing, just to, if it is reflected on the map on the left side, if you could.
Stop, please.
Oh,
What has just happened, ladies and gentlemen, is that, of course, the entire proceeding is recorded. The recording system just went down. So what we would ask you to do is just return to the deliberation room. Please do not discuss the case. We're going to take our morning recess until 11:30. 11:30, Mr. Marshall.
All right. Start with very first.
The council stipulates to the presence of all of the jurors.
yes, Your Honor.
Yes.
You may be seated.
Thank you, Your Honor. Detective Riley, if you wouldn't mind taking a stand next to the TV again. And just to back up a few of my questions, with respect to States 9, File 8, Picture 4, I believe, if you could you just, is what's shown in that photograph on the map on the left-hand side?
Yes, with the exception of the state mark G20, which is not depicted on this map.
What area is that stain attributed to?
Area G.
And so the yellow numbered ruler in the, I guess, the middle portion of the photograph?
It would be this one here.
Picture 5, actually.
Is stain C0?
Now, with respect to the way the photograph is that how it's depicted on the map? If I can, I would go back to States 4 and draw your attention to the line again. Where is C0 on States 4?
It's here in the center of the photograph.
Please, Mike.
Oh, if you can,
It's in the center of the photograph.
thank you. And this is picture 5 and picture 6. If you could just identify that in the map as well.
Stain C1.
And picture 7.
Stain C2 in the center of the sketch map, from which I see is exhibit 37.
Same process as you indicated before with the swabbing
Same testing and swabbing process, correct?
and the test results.
Positive.
Now, picture 8, sir, what does that depict?
Picture 8 depicts the interior face of the left garage bay door.
Can. Did you seize anything for evidentiary value on the garage bay door?
Yes, I seized a sample of the flow-like stain. It's on the inside of the garage door.
States 9. Actually, I'm sorry, if I can go back to States 8. Where on the door, if you could please point, did you seize that item?
It's in the center of the photograph, slightly to the left-hand side.
Okay. For the record, he's pointing to the middle, essentially the middle left of the screen. And states 9, what does that depict, sir?
That is the stain,
And-
sample of which I seized is exhibit 67.
And the same process,
Same swabbing process, same testing process.
and the results?
The test was positive.
Did you process the right side of the garage? In the
Yes,
Are you familiar with Detective Pearson's map for zone G? I mean, I'm sorry, D,
area D.
area D. Yes, thank you. For the record, this would be states 9, file 9. And photograph 2. Do you recognize what that is, sir?
Yes, this is a overall photograph of area D, the right-hand bay of the garage. Out of frame to the left would be the mudroom door. Give you a little orientation.
And are there areas below area D?
Yes, you can see the marker for area E and area F, which would be by the overhead door.
I'll show you states 1 out of that file. What does that show, sir?
That's overall the right-hand garage bay with area D at the top of the photograph, area E in the middle, and area F at the bottom.
States 3, or picture 3, I should say. What does that picture depict?
That is a photo of a blood-like stain we found in area D.
And the 56, what does that mean?
Oh, I'm sorry. So I designated this as State Police Exhibit 56. However, it's the photograph. The exhibit is going to be the photograph of what we thought was a footwear impression or a shoe print.
If I can, sir, just a couple questions. Is that depicted, Exhibit 56 depicted on Zone D map?
Yes, Exhibit 56 is here in the approximate center.
Okay, and with respect to photograph 3, if you can, I'm gonna scroll in. What drew your attention to this area?
Well, it's another blood-like stain on the garage floor, and there was a distinctive pattern to it.
Could you see the pattern in that photograph, or?
Yes.
Here, I'll scroll up.
It appears to be, see these hash marks here?
And for the record, I would say the middle part of the photograph.
Yes.
Picture 4, what does that depict, sir?
Again, that's a stain pattern located here in area B of an apparent footwear impression.
And if you could just point to where that appears on the picture 4.
It's here in the center of the photograph.
Picture 6,
It's another stain pattern,
and where does that depict on the map?
Exhibit 7.
And if you could please, picture 6, point to what you are describing, please.
It's in the kind of the lower portion, the center of the photograph.
Actually, I'm gonna scroll, oops, sorry, if I can go back to 7D. With respect to Exhibit 7D, when you were pointing, if you could point to the area now that it takes over the whole screen, what you were describing.
Sure, it's a blood-like stain on the garage floor. You can see a partial distinctive pattern within the stain itself.
How did you place that 7D marker on there?
I did, yes.
Okay, how do you document this or seize this as an exhibit?
Well, the hard way would be to jackhammer up the floor and send that to the lab, but that's impractical. So what we decided to do is photograph them properly 90 degrees with scale and send the photographs to the lab as Exhibit 70 for identification and possible comparison.
Thank you. And 71, is that depicted on Zone D map as well?
Yes, it is Exhibit 71 here.
And why did you seize that item, sir?
Again, this is another blood-like stain on the garage floor. You can see that a similar pattern in it, but you can also see the swipe marks through it.
Picture 8, what does this show, sir?
Picture 8 is it's another area of blood-like staining that appear to be wipe marks.
And was this all contained in area D?
Yes.
And picture 9?
Yeah, it's the additional stain pattern found in area D.
If I can, I'm gonna scroll. Oops. What are you doing now? Up here, this marker, I guess L-shaped marker again. What is that?
Again, it's another blood-like stain on the floor with a similar pattern, but a lot less detail to it.
And with respect to these items just around, and if you could follow my cursor, sir, they're little dots or things. What are they?
It's pretty vegetative matter, plants.
And anything, actually, picture 10, was this contained in area D?
Yes, right here at the almost at the border of area E.
And is this the same item that you seized on 525?
This is correct. This is the hair.
Now, with respect to States 9, File 10, so are you familiar with Detective Pearson's map for Area E?
Yes.
Sir, photograph 1 out of that file, does that depict?
It's an overall view of, again, that right side garage bay. Area E is depicted here right in the center.
Photograph 2, what is that, sir?
This is a blood-like stain pattern that we located in area E. It's located here kind of top center of the area. And I took a swabbing of this area to sample the blood-like stain. It was on the garage floor.
Was that designated as a exhibit?
Yes, exhibit 51.
There is a pink arrow on the right side. Do you see where the pink arrow is?
Yes.
What exactly is that?
That in this large stain pattern, the arrow depicts exactly where I took the sample from.
And same process, 2 swabs?
2 swabs, yes.
Did you test it?
I did.
And the results?
Again, every now and then, just make the same objection regarding any quote results.
You overruled.
The test result was positive.
Thank you. Sir, picture 3?
There's a similar stain pattern. Another blood-like stain appeared to be a white. It's located here at the left-hand side of area E. And again, I sampled this using that same swabbing technique, same testing technique. And I took the sample from this area here.
And the test results?
Test results are positive.
Picture 4?
Picture 4 is another blood-like stain found in area E. And the stain pattern itself appeared to us to be a textured glove. If you can imagine 3 fingers here.
What exhibit was this marked at?
I marked it as State Police Exhibit 55.
And States 5? What does that show?
That's an overall view of area E taken from kind of with your back to the mudroom door. So you can see Exhibit 55 here, that swipe mark.
And picture 6?
It's an off-kilter view of area E and the right-hand side of the garage.
Thank you. I'm going to draw your attention now to States 9, File 11. Are you familiar with Detective Pearson's map concerning Zone F?
Yes, I am.
Picture 1 off of States 9, File 11. Sir, what does that depict?
It's an overall view of the right-hand side of the garage. You see area F is down here. This is the kind of threshold of the overhead door. And area F is up in this area. Makes up center all the way down to the bottom of the photograph.
Thank you. Picture 2.
It's another blood-like stain pattern we found on the garage floor. Again, this is the threshold of the overhead door.
I'm gonna scroll in a little bit. So that yellow arrow again, what does that depict?
That denotes north.
Picture 3.
That is, again, another blood-like stain pattern we found on the floor. Again, there's more detail inside this pattern. So we designated it as State Police Exhibit 54, photographed it in a similar manner as the others.
And is that depicted on the map?
Yes, it's located on the left-hand side of area F.
Picture 4.
Picture 4 is another blood-like stain pattern found on the floor.
And picture 5.
That is blood-like stain that I tested and sampled as Exhibit 52.
And with respect to the swabbing process, same swabbing process?
Correct, same testing and swabbing process.
And the test results of this one?
I referred my report.
Would it refresh your recollection to take a look at your exhibit report?
Yes.
I can, Your Honor, just a personal card from Smart ID. 11 for ID, please. Sir, would it refresh your recollection to take a look at your exhibit report?
Yes, it would.
I'm going to hand you and draw your attention, please, to page 3. Please take a moment, do not read that out loud, and look up to me when you're done. Did that sufficiently refresh your recollection, sir, as to the results of the test?
Yes, it did.
And what were the results of the test?
That KM test was negative.
Thank you. And is that depicted on the map as well?
Yes. Exhibit 52 is there.
Thank you. And state 6, or picture 6, I should say. What is that?
Yeah, that's another overall view of area F.
Are you familiar with area G, sir?
Yes.
And now states 9, file 12. Are you familiar with Detective Pearson's map?
Yes, I am.
Photograph 1, sir, what does that depict?
That is a photograph of the center garage bay, 69 Wells.
And is area G contained in that photograph?
Area G is in the area which the Range Rover is parked. So it's in this area here.
Photograph 2?
Photograph 2 are some blood-like stains found in area G up in this area. And for orientation, this is the step into the mudroom.
Now, what are the, were exhibit numbers given to each of these stains?
The stains that I sampled, yes.
With respect to exhibit, states picture 3, what is that, sir?
That is a stain we sampled as exhibit 47.
Is that reflected on the map?
Yes.
And when you say sample, did you conduct the swabbing process that you
I-
testified to earlier?
I did.
And the test, any test?
I did test that, and there were some stains up in this area that tested negative. And just from this, I don't remember which ones were which.
Would it refresh your recollection? Take a look at your exhibit report again,
Yes.
if I may. So I'm going to draw your attention to page 2 of your exhibit report. If you could please just take a look. So did that refresh your recollection?
Yes.
And with respect to the presumptive test that was performed on exhibit 47, do you recall what the results were?
The KM test was negative for this thing.
And 48,
48 was another blood-like stain in the same general area. It's right here by the stairs. Again, I sampled that and tested it and sampled it in a similar manner.
and the results of that one,
I'm not sure if you know.
if I can, if I may just have a moment. Your Honor, if I can, I'm just going to provide counsel, or provide Dr. Riley with 11A, or I'm sorry, 11 for ID, which is the exhibit report. Sir, if you can just take a minute and take a look at that, if you can, to refresh your recollection with respect to the results of any testing performed on exhibit 48 on 527.
Yeah, the KM test for exhibit 48 was positive.
49,
49, another blood-like stain located up here in the same general area. It was tested and swabbed, collected in the same manner as the others. And the test result for this stain was negative.
and picture 6,
Again, another blood-like stain on the garage floor, located here. I sampled it, tested and sampled it in the same manner, and the test result was negative.
picture 7,
Picture 7 is a fragment of paper towel found under the left front tire of the Range Rover. See it, it's located here.
did you take any action with respect to that?
After it was photographed, I just collected it.
Picture 8,
Is a photo of a blood-like stain. Again, it appears to be a swipe located in area G. Sample of which was seized as exhibit 45. It was tested and collected in the same manner.
do you recall the results?
The test result for this stain was positive.
Picture 9,
That is a stain pattern. It was designated G20 for a blood-like stain. A sample of which I see is exhibit 36. I tested it and swabbed it, collected it in the same manner, and the test result for this was positive.
picture 10,
As the stain marked as G19, located in area G, that I tested, swabbed, and collected in the same manner. Okay, and test result for this was positive.
picture 11,
This is a picture of the stain pattern found in area G after, I'm sorry, 2 stain patterns found in area G. And this photograph was taken after the Range Rover was removed.
actually going to go down to and what does this photograph depict? So it states 18.
This was a photograph along the process of Lieutenant Davison's examination of the blood-like stains on the floor.
And if I may just have a moment, Your Honor.
Yes.
From the council. Having a separate disc 10, states 10, I believe there's no objection to it. If I may just have a moment to switch it out.
No objection.
No objection, that's correct.
Stage 10 will be admitted as a full exhibit.
Sir, were you present when the Range Rover was removed from the garage?
Yes.
And did you conduct further processing of the garage scene with the Range Rover removed?
Yes.
You can just take a look behind you, sir. This is states 10, filed 16. What does that depict?
Fairfield County stain, that swipe pattern, sample from area G. We brought the yes, this was tested and sampled and seized as State Police Exhibit 45.
And just to be clear, the same process, same everything?
Yes.
Okay, results?
The test results for this was positive.
And at some point, the Range Rover was removed. Who removed it from the garage?
I believe we just towed it out of the garage and winched it up on a flatbed.
Okay. And did you continue processing the garage floor after the vehicle was removed?
Yes.
I'm going to turn your attention to the photograph 2. What does that depict?
That depicts the two stain patterns that would have been underneath the Range Rover. One here in the lower part of the photo and one here a little bit higher.
Just scrolling in. Sir, does the higher one appear on the screen?
Yes, up in this area here.
Now, what does picture 3 do?
That is the selected stains that were designated as GW1, GW2, GW3, GW4, and GW5.
And sir, what does GW mean?
Area G, I'm not sure what the W stands for. That would be Lieutenant Davison's area of
Marking.
expertise.
And were these I'm going to show you a series of photographs, please. You just indicated some numbers. Are these the ones that correspond to the numbers that you marked?
Correct.
Okay, that would be for the records for photo, sorry, 8, 7, 6, 5, and 4. Are photos 4 through 8 depicted in photo 3?
Yes.
Now, photo 9, what is that, sir?
This is that upper stain pattern in area G that was seen in the overall photograph. Where you have stain GE1, GE2, GE3, GE4, and GE5.
And just briefly, you could take a look at 10. What does that depict, sir?
That stain designated as GE1.
Could you point to the stain? Okay. And for the record, it's the middle of the photograph.
Center of the photograph. Correct.
Thank you. Picture 11.
This is stain GE2 in the center of the photograph.
Is this oriented like this picture? Sir, if I can, back to.
So you can see the elongated stain here.
So
The elongated stain here.
which way is it on the garage floor? Is it perpendicular or I guess parallel?
So if you turn this photo clockwise, they would align.
Okay.
It was just taken from a different angle.
Picture 12.
Stain GE3 in the center of the photograph. Stain
and
G,
I apologize. Same question with respect to GE3
similar to the scales did not move.
and GE4.
GE4, again, the stain in the center of the photograph. And the scale did not move from the overall.
And GE5.
GE5, similar. Is this elongated stain here? And again, it's oriented, the scale's in the same position in the overall photograph.
Just safe to say it's the way the photograph was done.
Exactly, it's just the way the frame was taken.
And picture 15, please.
15 is a photo of a stain on the garage floor. Appears to be a tire mark.
Thank you. If I may, Your Honor, the state's going back to states 9. States 9, file 13. Sir, what does that depict?
These are the garbage cans that were found inside of the garage at 69 Wells. They were in the corner of the right-hand bay. The garage door would be on the right-hand side of your photograph.
And did you find anything of evidentiary value on the garbage cans?
Yes, there were flood-like stains found up and around the lids on both garbage cans.
Photograph 2, what is that?
That is a photograph of the left garbage can.
And photograph 3.
Again, that appears to be the left garbage can. And you can see the flood-like stains both here and here.
Photograph 4,
That is a photograph, I refer my report to get left to right.
if it would refresh your recollection,
Yes.
please.
That's a photograph of the left-hand garbage can that you saw in the overall photo. This was taken during the evidence collection process. And it was tested, swabbed, and collected as State Police Exhibit 66 from this area here.
Were there other swabbings that were taken out of the garbage cans?
On the right-hand garbage can. So that's a right-hand garbage can. Again, in a similar area, found a little like stain.
And with respect to the garbage cans, about how many stain or swabbings did you take in all of the left garbage can? If it could refresh your recollection to go to your report, please.
Still the same, 2 swabs.
And with respect to the right side garbage can,
2 swabs.
and were those also tested?
Yes,
And the results?
positive.
Now, sir, did you all have an opportunity to examine the Chevy Suburban that you, or be part of the processing of the Chevy Suburban that you earlier in the day had gone to Lapham Road to
Yes.
examine? You can have a seat, sir. When was that?
That was on June the 28th, so it would have been the Tuesday after Memorial Day.
And actually, prior to leaving 69 Wells that day on May 27th, 2019, you testified earlier about latent prints. Did you conduct any latent print documentation?
Yes, we did.
I'm actually going to go to States 9 file 4. Where did you take latent prints from?
Well, we searched for latent prints around the points of entry.
I'm going to check as non-responsive.
Well, the question is, where did you take latent prints from? And the answer was, we searched for latent prints. It is non-responsive to
I
say.
will ask some foundation questions, sir. What exactly is a latent print?
It's a, lack of a better term, an invisible fingerprint. A fingerprint that's deposited on a surface that needs some sort of development to make it visible.
And is there a process that you utilize in searching for these?
Yes.
What is that process?
Process is visual observation, utilizing side lighting, different lighting techniques. And then in this case, it was the application of just standard fingerprint powders.
And how does fingerprint powder allow you to search for latent prints?
The fingerprint powder is extremely fine and it adheres to the fingerprint residue and makes the print visible.
And did you conduct that process at 69 Wells?
Yes.
At what locations?
Various locations throughout the house, the first floor, in and around the points of entry, around the mudroom door, around that, the kitchen island.
I'm going to show you some photographs, sir, if I can. If you take a look behind you, States 9, this is file 4. What do you see, sir, depicted in that photograph?
That's an overall photo of the door leading into the mudroom from the garage after latent print processing and prior to the collection of the prints.
And well, actually, I'm sorry, I went too fast. If you could, would you mind standing up and going back to the screen? Thank you. Couple questions, sir. Where is all on that photograph if anywhere on the photograph, you mentioned the black powder, finger powder. If you could just describe it for the record, please.
Right, it's this dark colored smudges all over the white door.
Did you put that on there?
Yes, I was one of the people who searched for latent fingerprints with.
I'm going to check is non-responsive. It's either he did it or it was one of the people.
Well, question was, did you do that? He said he was one of the people. The court understands parenthetically who did it. Overruled.
What is the process for putting that fingerprint powder on a door such as this?
We have special brushes that we use, that we put the fingerprint powder on and apply it to the surface. And sometimes fingerprints readily appear, become visible. Sometimes it takes a little bit of work to clean up smudges and things like that with the brushes.
And how would you do that? Clean up smudges, or what do you mean by that?
Oh, you just, if, to get more detail out of the print, you'll work it with finer brushes, smaller brushes, and try and clean out the fingerprint powder from in between the ridges that you see on the print.
Did you develop any latent prints out of the mudroom door?
Yes,
Where?
right here above the lock cylinder.
Show you what's been marked as it's picture 2. Sir, what does that show?
So this is the latent prints prior to collection, prior to lifting them.
And what do you mean by that?
So we will take photographs, obviously, to try and pick up the detail. And then once that's completed, we'll go ahead and take adhesive lifters. Usually it's adhesive clear acetate, almost like tape. In this case, down here, we used a gelatin lifter, which is a thin layer of gelatin on a rubberized backing. It's just used for different surfaces.
And the markings on the measurement tape, or the white stickers, I should say, what exactly does that mean?
So the LP stands for latent print. So we run them sequentially. So this would be
Your
latent print.
Honor, again, I'm going to object unless he's referring to himself in the plural. I would ask that he please clarify whether he did this or someone else did it, just for clarification.
So the question, as the court understood it, is not whether he did it. He was asked to explain what those designations mean, if the court understood it correctly.
That was the state's question, Your Honor.
Overruled.
So this is my handwriting on the markings. So LP stands for latent print. Latent print 7, which is also designated as State Police Exhibit 82. Here, LP 8, latent print 8, State Police Exhibit 83.
Did you go anywhere else in the house and conduct this process?
Yes.
Where?
The kitchen of the residence.
And with respect to the mudroom door, is this the side going into the garage or the side going into the kitchen?
So this is what we designated as the exterior side. So this is the garage side of that mudroom door.
Picture 3, do you recognize what's depicted in this photograph?
Yes, this is the area around the inside face of the mudroom door. You can see down here where I had removed the doorknob. So this is one of the casings. You see LP1, latent print 1, Exhibit 73. Above that, latent print 2, Exhibit 74. And down on the wall, Exhibit 75, which is latent print 3.
The blue writing, is that actually on the wall?
Yes, I did that with a grease pencil and China marker.
Why would you do that?
That designates which one I'm actually looking at, or what the actual lift is. So and it just depends on the amount of detail in that print. So in a photograph, if I just put up the scale, I don't know which one of these is the exhibit. That's why we circle it with the China marker, and the arrow just orients the print. And then sometimes that gets picked up on the lifter itself. So it's more for the examiner.
Did you search for latent prints in the kitchen area?
Yes, I did.
Where?
Mainly around the kitchen aisle, or where I found those other exhibits.
Show you what's been marked as picture 4. Do you recognize what's depicted in this photograph?
Yes, that's the inside of one of the cabinet doors.
And if you can, that same blue writing is on there. If you could explain that, please.
Correct, that's I marked out the print in blue China marker and designated it as late print 4, exhibit 76.
Show you what's marked as states 5. What is,
It's on one of the entry doors. May I refer to my report to?
if it would refresh your recollection, please?
Okay, this is the French doors leading out to the backyard, the rear patio.
And if you could walk me through, did you do this one?
I'm not sure if I dusted this, but I designated it and marked it up.
And if you could just walk me through what you did.
Okay, so after the latent prints were developed, I go around, people tell me where they found prints, and I will go around with a magnifying glass, pick out the prints for the best detail, mark them and label them in a similar manner, then notify the photographer as to their location so they can be properly photographed prior to collection.
And picture 6, please.
That is off of a exterior door handle. And if I could refer to my report, I can get you the correct door.
If you can, thank you.
Okay, that's the same set of French doors that we took prints off of in the previous photograph. And this is one of the exterior handles. And you can see the latent print here. I remember developing this, and then I went ahead and marked it. There's exhibit 80, latent print number 6.
Thank you, sir. You could have a seat. Now, I asked you previously about the Chevy Suburban. If you can, just briefly, and did you have an opportunity to process the Chevy Suburban at a later date?
Yes,
What day was that?
it was the 28th of May in 2019.
Where were you located?
At the New Canaan Police Department, the vehicle was located in their Sally Port.
And who was with you during that processing?
It was Sergeant Joe Duva was our supervisor. It's myself, Detective Gavin, I believe Detective Pearson, Detective Keppel.
And if I can, sir, I'm going to draw your attention just to take a look behind you. This is under States 9, File 14. Picture 1. Do you recognize that, sir?
Yes, that's the Chevy Suburban prior to our start of processing.
Picture 2.
That's the rear of the Chevy Suburban.
Picture 3.
That's a view of one of the running boards of the Chevy Suburban.
And if I can scroll in a little bit. Sir, what is depicted in the white marker and the, I guess, pink arrow as well?
Right, so that's a blood-like stain we found just above one of the running boards. It was designated, tested, and swabbed and collected in the same manner as we did in the house.
And with respect to the results
The test results were positive.
and the swabbing, did you conduct that in the same process as you did 2 swabs? And
Yes, 2
every-
swabs, same collection.
Now, were you wearing gloves and protective gear in the course of processing? the vehicle?
Yes, just gloves.
By the way, what was your assignment with respect to May 28th processing the vehicle?
I still maintain the position of evidence collection officer for this.
Picture 5, sir.
That is a blood-like stain pattern found on the lower edge of one of the doors.
And picture 6.
That's a sample from the stain pattern. I tested, collected as a State Police Exhibit 106. The arrow denotes the stains that I took.
The stains that you took for what?
Oh, I'm sorry, that I swabbed and collected as evidence.
State 7.
Again, those are additional stain patterns found on the door of the Suburban.
And state gate.
And that's another blood-like stain pattern.
And same questions, same.
It was tested, collected, and marked in a similar fashion, collected with the 2 swabs.
States 9.
That's the blood-like stain that I first saw on the bumper on Lapham Road. And again, I tested it, collected it, and marked it as State Police Exhibit 105, and the test results were positive.
States 10.
That is blood-like stains that were found on the steering wheel of the Chevy Suburban.
And same question, sir. Did you-
Same collection method. It was tested, test results were positive. It was swabbed and collected as State Police Exhibit 118.
Were there also any swabbings done further of the inside of the vehicle?
Yes.
Where?
I do believe we did DNA swabs of the various parts of inside the vehicle in an attempt to collect DNA. So we choose these areas based upon the areas that people touch when they're driving. So the inside the doors, steering wheels, top and bottom, gear shift, areas such as that.
States 11. What does that depict, sir?
That's the rear cargo area of the Chevy Suburban. The adhesive scales in the pink arrows denote areas where blood-like staining was found.
Specifically, I'm going to ask you about states 12. What is that?
That is an area of blood-like staining. It's hard to see with the dark carpet. And that was found in the rear cargo area. It was tested, collected and seized in the same manner as all the other swabbings of blood-like stains. It was denoted as State Police Exhibit 121.
And the test results?
Test results were positive.
Oh, one more, sir. What is that?
That's a blood-like stain found on, I believe it's the driver's side wall of the rear cargo area. This also field tested positive for blood and was swabbed and collected as exhibit, State Police Exhibit 120.
Your Honor, with respect to the next few photographs the state intends to introduce, I know the court's ruling previously, but if I would, perhaps now would be a time to excuse the jury for a few minutes, or the state can go into it.
Well, the court would not expect 10 minutes worth of argument.
No, sir.
So, ladies and gentlemen, we will excuse you for a brief period. There will be some discussion of the next exhibit. And so we ask that you retire to the deliberation room and please do not discuss the case.
Okay, sir. Okay. Next.
Please be seated. Thank you. Would you
Your
put those up on the screen, please?
Sure, Your Honor. If I may, I believe it is. This would be picture 14, picture 15, and picture 16.
Thank you. The easiest way for the court to probably do this is just a
If I may.
brief offer of proof as to how these exhibits are going to be explained.
If I may, Your Honor, may I just
Yes.
inquire of Detective
Yes.
Riley? Thank you. Detective Riley, I'm going to have you draw your attention to photograph 14 behind you. What does that depict, please?
That's a photo of the rear cargo area. It's a time exposure. So it's a photos taken over a longer period of time after the application of a chemical called luminol.
Okay, a couple questions about what you just said, okay? With respect to the content of the photograph, you said rear cargo area, is that of the Chevy Suburban?
Correct.
Okay, now with the, were you present when this happened?
Yes.
Okay, you used the word luminol, what does that mean?
It's a chemical that we use to detect latent blood, that is blood that's not readily seen. We use it as a search tool. It's not we don't use it as a presumptive. We use it to search for blood that's not readily visible. If we find stains of or areas of interest with a luminol, we'll go ahead, conduct further observations. We utilize the KM test, and if the KM test is positive, then we'll take evidentiary samples from those areas.
And with respect to a luminol, does that give it any presumptive, wait, you said luminol for blood that's not readily available. How does that work? Or readily seen, I guess is the way you said it.
Correct. Yeah, the blood, we use it to search for latent blood. So the luminol reacts, it glows blue due to the iron present in blood. However, it reacts with substances that contain iron, along with several other different substances. What we do is once we mix up a batch of luminol that we're going to use on scene, we'll apply it to our known blood sources, the horse blood, the pig blood, and see how that reacts, and then we'll use it on an area of interest and see if we see any similar reaction.
So is it really the detection of iron? Is that what luminol is looking for?
Well, that's what luminol reacts to in blood.
And with respect to the fact, well, strike that if I can. You said you mix it up on scene.
Yes.
Walk me through that process.
So we get our luminol from a forensic supply house. It comes with a solvent, a bottle of solvent, and the luminol comes in powder form. We follow the instructions, we mix them together, we attach a spray head, and then we'll apply it to a surface.
Is this something that you're trained in?
Yes. I remember one class where we did use luminol.
And is this a tool that you have utilized in the course of your career at the Connecticut State Police?
Yes.
About how often?
Not a lot. I would say I've probably applied luminol 15 to 20 times.
And with respect to the photograph exposure process, how does that work?
So we'll set a camera up on a tripod so it's steady. We'll put the camera settings to keep the shutter of the camera open for a longer period of time. And then we'll apply the luminol, and if there's a reaction, we'll open the shutter, the camera will do its thing, and once the photograph's complete, we'll move to a different area.
Is there a lighting on anywhere around?
Yeah, I apologize. So luminol has to be used in a darkened room. The bluish glow is very faint if we have a reaction. So in this case, we close the sally port door. If there were windows on it, I don't remember if there were, they would be papered over. So we basically work in the dark with flashlights.
If I may have one moment. That would be the state's offer, essentially.
May I briefly cross?
Well, this is just essentially an offer of proof.
Yes.
So this is how the court understands the offer. Luminol detects blood that cannot be seen with the naked eye. However, it detects, and the court is not certain that this was the testimony, it detects any substance that contained iron. That includes blood. After that, there's further testing. After that, there may be the swabbing and the collection and essentially the KM test. That's how the court understands the testimony. The photos that are viewed at this time are time-lapse photos. In other words, this isn't a snapshot. The court understands it. The time-lapse photo. The blue as it appears on the screen, as the court understands it, is bluer than what would be seen typically, because the testimony and the offer was that the blue is very faint. Here on the screen, the blue is not very faint. So during this offer, the court will ask you, detective, is the color of the blue on the photograph darker than the blue that would appear after the application of luminol?
That's what a positive reaction looks like, Your Honor.
So you would describe that as faint?
It's faint where if it was in natural daylight, you wouldn't be able to see it.
Oh, but because it's against the backdrop of essentially a dark backdrop, it looks more vivid than it would look.
No, that's fair, Your Honor.
Well, the defense is concerned, Attorney Schoenhorn, you may indicate.
Yeah, very briefly, the latter comment by Your Honor, this isn't how it would appear even in in the detective's visual appearance of the back of the vehicle. But my bigger concern is there wasn't, this luminol is not a detection for blood, it's a detection for iron. This is the back of a vehicle. It detects steel, iron. I understand it also can detect copper. It also can detect any vegetables or that have iron, such as turnips and horseradish, those kind of root vegetables, and a number of any other kind of food that might contain like meats and whatnot, or hamburger if a child was eating a hamburger in the back or it spilled a little bit in the back. So more so my concern than more so even than the concern I have about the Kastle-Meyer test, where there's an observation, it was a test was performed, a presumptive test, and then it was passed on. Here, there was no confirmatory test whatsoever. Therefore, and when there was when the DNA from these areas was later tested, there was no DNA that was determined to conform to the DNA of Jennifer Dulos. So in addition to the concern I have about it being misleading, the additional concern I have is that in light of what is going to happen later, there is no relevance to it whatsoever. And I'll just note as an aside, my other concern is that the court allowed in the Kastle-Meyer multiple times, suggesting that, well, I can take care of that in cross-examination. My concern, Judge, is that's shifting the burden to the defense to go over each and every time there was a claimed presumptive test when it's going to determine that many of them turned out to be negative when they were tested in the lab. But my concern here is different, at least in the other, my other objection. There was, at least as I understand it, the court said it was a visible item that was being tested, and that was why the witness did what he did. Anything else here, he's already testified up until this point that there were items he swiped. He can simply testify that he did take additional samples in the back without getting into what luminol is, what it does, and since it doesn't test for blood, it tests, and I left out bleach is another substance that glows when luminol is applied. I don't know how that's going to, I don't even know if the state would then not put on evidence of the what was done in the back of the car, and therefore that leads to the defense having to call laboratory people to say, no, it was negative. It leaves a false impression that this was in fact somehow blood, when I think the court is correct. It only tests for things that have iron in them, and I would know copper is not iron, but it also tests copper. But in a motor vehicle, all of those things, especially in the cargo compartment, would likely be found. And I'll just incorporate my prior arguments so I don't have to repeat it.
Well,
If I can just
the
clarify.
court can address this right now. The, again, issue of false impression, essentially giving life to what may be considered to be misleading, is not evident here. Not only is the luminol application far from conclusive, it is not even at the level of presumptive. It detects many more things than blood. It detects iron. Then there's further testing to get it up to the point of even being presumptive. So the court sees no danger for unfair prejudice or misleading evidence. The court is going to allow the evidence.
The court, at least, what I'm not understanding, the court's, I'm not understanding Your Honor's ruling, because what the court said is it has essentially no evidentiary value, and then the court rules that it's admissible. I'm not, the court at least articulate how it gets to that position. I'm just trying to understand down the road, since we're going to be having this happen more often than you think.
The court did not say it has no probative value. Relevant evidence is evidence that has any tendency to make a material fact more likely or less likely than it would be without the evidence. The court did not say it has no probative value. The state has the opportunity to present the case the way the state wishes to present the case. If it wishes to present evidence of luminol and latent blood that falls below a presumptive finding, that's the state's determination.
I'll just ask the court to note my strong exception, since I'll just remind the court that State versus Moody said that luminol has no probative value. So the fact that the court says it does, I don't know where to go with that other than to just enter my strong objection.
You can bring the jury back.
Just prior to the jury coming out, Your Honor, those 3 photographs are still ID only. May I just inquire, they moved to be full exhibit at this time?
Will counsel stipulate to the presence of all of the jurors?
Yes, Your Honor.
Thank you. Do you wish to make your offer of those exhibits?
Yes, Your Honor, I would. This would be States 9, file 14. The offer involves photographs 14, 15, and 16.
Objection, attorney Schroner.
I stated my objection.
Thank you. Overruled. Which numbers are they, please?
They are States 9, file 14, numbered photographs 14, 15, and 16.
States 9, file 14, photographs 14, 15, and 16 admitted as full exhibits.
Thank you. So if I can, I'm going to draw your attention. There. States 13, if you can take a look at it. Sorry, is that, where is that located in the Chevy Suburban?
That area is in the rear cargo compartment of the Chevy Suburban. That would be on the driver's side.
With respect to the rear cargo area of the Chevy Suburban, did you do anything in the course of processing the car with respect to that area?
Yes.
What did you do?
So we conducted a search for not only visible blood-like stains, but latent blood-like stains.
What do you mean by latent?
Latent just means that you can't see it. It needs something to be developed.
And what did you do to develop that?
So we utilized a chemical called luminol that we get from a chemical supply house. It's a liquid that you spray onto a surface in a darkened environment, and it will react with the iron contained in blood and glow a faint blue.
And with respect to reacting with the iron in blood, does it react to other things as well?
It reacts with a lot of different things.
Can you name a few, please?
So it reacts with iron, or anything with iron in it. It'll react with bleach. So it's a limited use in the bathroom. And it will also react with some foods as well. There's a laundry list. We utilize it as a search tool. We have to do further presumptive tests, and then of course, any samples that we collect, we have to send to a laboratory for confirmatory tests.
And just for the record, the photograph 13 behind you, was that KM tested as well?
That exhibit was KM tested.
Okay. And seized as exhibit, what exhibit number did you see?
State Police Exhibit 120.
With respect to the pink arrow, what does that depict?
That's the area where I took those evidentiary swabs from.
Now I'm going to show you what's been marked as States 14. What does that depict, sir?
That is a time exposure of our application of luminol.
Of it. Well,
Oh, I'm sorry.
Of
This
what?
is, sorry. This is the rear cargo area of the Chevy Suburban. While it was still parked in the Sallyport, we closed the doors, we make it a darkened environment. And, we sprayed luminol throughout the rear cargo area. It took several time exposures.
where do you get the luminol from?
We get from a forensic supply house.
And how do you, I guess, apply the luminol?
So it comes, the kit that we get from the chemical supply house comes with a bottle of solvent, and then luminol comes in powder form. We mix those two together. We attach a spray head, and then we do a test on our known blood samples, either pig blood or horse blood, and see what kind of reaction we get. Then we will apply it to an area of interest and see if we get any reactions. If we get reactions, we'll go ahead and test those areas with the Kastle-Meyer test. And then determine whether or not we want to take evidentiary samples.
And did you do that in this case?
Yes.
Okay. How did you take a photograph?
The photograph is a time exposure. So basically we put the camera on a tripod and either set the automatic settings or set shutter settings. So the shutter stays open on the camera for a longer period of time. Since it's a darkened environment, it takes that amount of time to take in enough light to make a photograph.
And were you, well, I'm going to show you behind you states 15. What does that depict, sir?
That was taken during our luminol examination. That's, again, the rear cargo area of the Chevy Suburban. I believe that's more focused on the driver's side of the vehicle.
And states 16. What does that depict, sir?
Again, taken during the luminol examination, and that's the passenger side of the rear cargo area.
Did you have an opportunity to examine the Chevy Suburban at a later date?
Yes,
When was that?
June the 26th of 2019.
And what was the purpose of that?
The purpose of that was to try and search for additional biologic material to aid the medical examiner's cause of manner investigation.
Did you look at
The car.
file 16? Show you picture 17. Do you recognize that?
Yes,
What is that?
that is the Chevy Suburban, Farber Dulos' Chevy Suburban.
Where is the location of this? Where was the location of this processing?
This was processed at Troop Chief Bridgeport.
Picture 18. What does that depict, sir?
That is the passenger side of the Chevy Suburban. You can see the black metal of the door on the upper part of the photograph.
If you wouldn't mind, again, sir, if you can get up and point to the photograph, please.
So you have the vehicle here, and here is the undercarriage. This is the underside of step bumper, frame rail. And this is some blow-like material we found on the edge of the undercarriage.
The word written on the white side, what does that mean?
So that was placed there by the photographer to designate which direction is the front of the vehicle, because the photographs can get a little confusing.
Picture 19. What is that?
Okay, this is an item of interest that we found during examination of the undercarriage. Again, this is on the passenger side. We're looking at this this clearish little specimen right there. So, and we designated this as item A. Our collection process for this is I've removed this with a sterile scalpel, packaged it in a little paper fold, and later the next day transported it to the medical examiner's office so he can do he can put it underneath the microscope and see what kind of cells are there. In the same area, after this was removed, I went ahead and swabbed the area with sterile water, same manner, with 2 swabs.
And photograph 20, please.
Item B, I believe it's on the frame rail. So you can see the exhaust here, bolts for the running board. And so I'm looking at this little fleck of material right there. Again, this was collected in a similar manner.
Picture 21.
Item C is on the running board. It's this area here. You can see it's a little heavier of a stain. There's a little, it appears to be like a little yellow to it. It's different than, there's more there than just typical blood-like staining, so that's why it was not of interest. Again, this is collected in a similar manner, scraped off into a paper fold, and then the area was swabbed afterwards.
Picture 22, please.
This is a photo of what looked to us to be a footwear impression on the inside one of the wheels of the Chevy Suburban. And I believe this was taken on the 28th of May during our vehicle processing.
Picture 23.
Again, we printed the exterior of the vehicle. And
I believe we took a swab from here, but I'm not really sure.
Would it refresh your recollection to take a look at your exhibit report?
Yes.
May I first report, Your Honor? So I'm going to show you what's been marked as ID states 12. If you can, just take a look, and please don't read from it. Let me know when you're done. Did that refresh your recollection, sir?
Yes.
If there was a swap done of that photo, what's the picture in that photograph?
Yeah, so this is the exterior side of the vehicle's tailgate. This is the bottom edge right here. And during our examination of, you can see the application of fingerprint powders. All right, so there's not a lot of, there's absolutely no ridge detail here whatsoever. However, it was handled, so we swabbed it. Or I took 2 swabs that were moistened with sterile water, swabbed this area, and then collected it and designated it as State Police Exhibit 113.
In picture 24, sir.
This was taken during a latent print exam of the exterior of the vehicle. Again, we're running sequentially with latent print numbers, so this is latent print 11, State Police Exhibit 114. And again, I designated it with blue China marker, arrow for orientation.
And picture 25.
It's appears to us to be like a partial palm print. On not sure where exactly this was on the Suburban.
Would it refresh your recollection? Didn't take a look at your report?
Yes.
And just for the record, I'm almost done with this section. And one more question after this.
Well, it's the answer, the length of the answer that concerns me. So the court is going to conclude for lunch recess after this photograph.
Thank you.
This is the this was developed on the rear edge of the right front door. So near the window. Okay. And so again, designated as latent print number 12, exhibit 115, marked and lifted in the same manner.
Thank you.
Okay, thank you. Ladies and gentlemen, we approach our lunch and recess. We plan to resume at 2 o'clock. Please do not discuss the case. Thank you.
Yeah, I think you said 2 o'clock. AO1 is here with me, hurrying away, so you may hear her. Let me take a look.
All rise. This honorable spirit court now stands in recess until 2.
Thank you.
Murdaugh hearing came back from their break. Okay, here we go. Let's see, maybe a bit. Like, still not arguing? Oh,
More
okay.
Will not
Helps to get the audio.
Our focus will be on the jurors that heard Before we proceed further, a few other things that you've asked about that I want to clarify before we then go forward with look at how it's to be questioned. First of all, how the jurors will be questioned. Everything will be done in open court. The jurors will be referred to by number. The court TV cameras, which are the ones used to film these proceedings, will not be allowed to focus on the image of the jurors as witnesses. And if there's some need to further obscure the way they are presented, we can talk about that. But they'll be examined right here in the courtroom as other witnesses would be. And I kind of looked at a little bit of exchange we'll have with attorneys for jurors to see what we can work out about exactly how the jurors are presented. But everything will be on the record here in open court with measures taken to ensure the privacy of the jurors. No photographs would be permitted of the jurors or anything of that nature. And I believe if I announce that in advance, the press that are present, the press that covered this proceeding throughout have been respectful of the judge's request, and I'm very confident they will be in this matter as well. With respect to the alternate jurors, I will question only the jurors who sat and considered this case. So the alternate who was dismissed by the trial judge. That alternate did not participate in any way in the deliberations about this case. There's nothing that's been brought to my attention about anything the alternate might have done that was improper at all in terms of communications with fellow jurors. Nothing's been alleged in that regard. So our focus will be on the jurors that heard this case and not on either that alternate or any other alternate juror that has been proposed for questioning. I will not permit that. With witnesses or testimony, I do not allow. Let me explain about proffer. Proffer will be a written proffer by the party dissatisfied with the limitations of my ruling. But there will not be some examination as to proffer. The proffer will be a written proffer by the attorneys in accordance with their positions about witnesses and testimony. With regard to the subpoenaing of witnesses, the parties should subpoena these witnesses. And when it comes to the jurors, I would urge that the parties, the state and defendant, jointly deal with the issue of subpoena of these witnesses. I do not think it is the court's place to subpoena witnesses or order witnesses' appearances. This case is driven by the parties and their positions. The initial position of defense was that only certain jurors should be called. The state said no jurors should be called, but if you do, all should be called. All who sat on the case should be called. If the parties can't agree on how that subpoena should be accomplished, then I'm sure they'll let me know, and I'll try to take some measures in that regard. The concept I would have is that the jurors would report to a place that I will specify, and when they report, they would be taken to a room with appropriate supervision by court personnel, and then called individually to recite their testimony. And then when their testimony was complete, they would simply take their place in the jury box until all were questioned. And then if there were any questions further by me that collectively made to the jury, I could do that. And if there are any further questions that were submitted to me by the parties that I chose to question, I would do that. And then when all of that was complete, the jurors would be allowed to be dismissed. So that is how I would handle the juror witness portion of this. And of course, I know I'm going to get some commentary from each side about that. That's why I talk about this in advance. The other witness that surely needs to be called because of the allegations made is the clerk of court. The state has submitted a preliminary affidavit by the clerk of court, and the defense has many areas they want to explore for the court. Again, I would like for the parties to develop some joint way of subpoenaing the clerk of court. And if I need to be a part of that, then I'm sure the parties will let me know. But I say this for the benefit particularly of the attorney for the clerk of court to know that I would expect that the clerk of court will be called as a witness in these proceedings, 29, 30, and 31 if necessary. Will be, and 3B will be used as an overflow for the press. Excuse me, 3A is the one over here, and that's the one I'll be using to conduct the hearing. This courtroom we're sitting in now will be the overflow courtroom for press with I'm sure a court TV monitor that's available for them to monitor the proceedings. If there's not enough room, based on the attendance today, it might be plenty of room. We'll see. We'll have this. I will try to figure out a way to be sure that the broadcast in here of the proceedings will not interfere with the conduct of the hearing past this partition next door. I will trust Mr. Bender to work with the press to arrange the courtroom and the overflow room in accordance with the rules I will set forth here and anything else that may come up that needs my attention. I think that covers it at the present time. So the first thing I'd like to do is to get some clarity from the attorneys as to what furthermore, for the parties, as to what furthermore needs to be discussed. And then after that, we'll explore with the attorneys for the jurors and the attorney for Clark Hill, any other issues that still need to be developed. Mr. Hopkins.
Please, Court, Your Honor. I'm trying to make sure I understand what you just ruled. Are you ruling that we cannot call the alternate juror or the so-called egg lady to corroborate what was said to the sitting jurors, since they were all told this at the same time?
I'm not sure I understand your question, but I'm just telling you that I want these jurors, these alternates would be called apparently to testify as to what the clerk said.
Yes.
At the present time, I see no necessity for them to be called to say what the clerk said, because we're talking about what the clerk said to the remaining jurors, those who actually sat on the case. The corroboration is something I don't think I need at this time. I think I'm perfectly capable of evaluating what the jurors tell me, and I'll do that. I think I'm also perfectly capable of evaluating the credibility of Ms. Hill and the jurors for that matter.
Well, Your Honor, for us to, and then you said you wouldn't allow a proffer of that except in writing. Now,
Yes, I'm not going to have a courtroom proffer of any kind. If you want to proffer what would be offered by means of affidavits, copies of emails, anything else you want to, that's fine. But I am not going to have a courtroom proffer, no. I think the only reason for the proffer would be to preserve your right to appeal. I believe your right to appeal my rulings will be perfectly preserved, frankly, even if you didn't have a proffer, but even more so if you supply an in-writing proffer.
well, I'm trying to determine whether an affidavit is sufficient for an appellate court, federal or state, when the state will have an opportunity to examine that witness. But I mean, they've given, I mean, we can get more detailed affidavits. You know, these people are witnesses to what the clerk said to the juror who deliberated. I don't understand how that can't be relevant to Your Honor's decision. I understand there's two steps. One, did she make the statement? And two, was it prejudicial? These witnesses corroborate she made the statement.
Well, of course, that's what you say. So far, I haven't seen any of that. If that's what you say and you offer it to me in some form that I can evaluate it, I may revisit that decision. At the present time,
Okay.
but at the present time, I see nothing that prompts me to think I need to have people who did not sit on the case talk about what they think the clerk said to other people when I got to direct people to who had said that I will question.
Well, Your Honor, we did submit an affidavit, but I have no problem with going back.
You submitted one alternate affidavit
Right.
and one affidavit of a dismissed alternate. I'm aware of that.
Right. So,
And that doesn't prompt me to change what I just said to you.
all right, we can get you more specific. I understand what the questions are you have, and I would only put those folks up to deal with those very limited issues that you described. Put them up in 10 minutes.
Well, again, I'm not going to rule in a vacuum. I'll see what you say and I'll rule on it.
We'll get affidavits and file them with the court.
Very good.
Thank you.
Your Honor, just one issue as to logistics. Obviously, these jurors are down in Colleton County, and we're up here in Richland County. I've spoken with SLED, and in as much as we need, there may be jurors who need transport. SLED has certainly agreed to have 12 cars if we need to make sure that they're individual. They can then come in through the garage, and obviously they'll be brought up to a jury room. I think Your Honor indicated they can be in a jury room with a bailiff in there to make sure that no one's talking about their testimony and that sort of thing, but also so that they don't have to come in through public entrance and that sort of thing. So that would be.
I think that would be a good solution, and of course, to satisfy the concerns that the defense may have, you could either have a member of the defense team or one of their employees ride with them, or if you could agree upon a sworn statement by the agent or person that does drive them, that they, A, will not say anything, and B, did not say anything, then that may clear the problem too. I think you all can work that out. But I do think having proper transport would, first of all, be a comfort to the witnesses themselves, the jurors themselves. But if they can arrange something otherwise, of course, they'd be free to do that. But to the extent it's a burden on them, yes, I think that's a good idea. And in all events, I would want arrangements to be made to have the jurors come to the parking garage in this building and be escorted up in a private way into their assembly room.
And yeah, absolutely, Your Honor, and we will, and I'm sure SLED, I'm already talking to them about that, have uninvolved agents who will be under strict instructions not to discuss the case, and happy to have them sign affidavits or whatever.
Very good. All right, anything further before I go to the lawyers for the jurors? All right.
Your only one other point, and that is, you asked us to give you exhibits that we would use.
Yes, sir.
Having not asked or had the opportunity to ask Ms. Hill a single question, I can't tell you in terms of, there's not thousands of emails we've used, probably 5.
I'm just going on some of the descriptions that were in the filings y'all have made to me.
Well, we've received thousands of emails from Colleton County, based on a subpoena we issued. We've received hundreds of pages from the AG's office and SLED.
It'll make it a lot simpler if it's a small number and a discrete number, submitting them to me. Again, I told you I would evaluate that when I did.
Of course, I don't think you can evaluate them until she testifies. You
I
don't
think you're going to have to trust that I am going to do some evaluating before she testifies.
Okay, and Your Honor, she's given an affidavit denying making any of these statements.
She has.
So these alternate jurors that have been dismissed, would you allow us to call them to impeach her if that's what she testifies to?
At the present time, the answer to that is no, as I have indicated. But again, I'm not going to rule in the vacuum. I would hope that what you always do is send me a pretty specific idea of what you want and how you want me to permit it. So I'm not going to rule on something I haven't seen yet, which is your proposal is exactly how these witnesses and alternates to be used.
All right, we'll get more extensive affidavits for those two alternates.
Oh, okay. That's fine, or scriptors of some sort from you is what you intend to do. I'm not going to dictate how you do it, but I'm going to have a lot more than just kind of the generalities that have been discussed in these briefs in order to permit.
Well, I think we're going to need an affidavit for appellate purposes, nothing else. I mean, my description to you is not evidence.
Oh, I agree, but again, I will tell you how I'm going to accept the proffer. What you put in the proffer, in the written proffer, is up to you. I don't want to dictate that or manage it.
Well, I just want to say, if we're going to hopefully be able to get affidavits from these folks.
Yes.
Much more descriptive than the original affidavit.
Oh.
Thank you.
Your Honor, may I consult the counsel very briefly?
Certainly.
One of the things that was discussed earlier was the independent SLED investigation that was done. There were recordings of some of these interviews and MOIs prepared that were just meant to be summaries. I know Your Honor mentioned earlier that you would be open to receiving those. I just
I'll be glad to review that.
discussed that with counsel, and I believe they said, well, we want to send the ones we want to send. I think if Your Honor is amenable to that, we would just add Your Honor to the discovery upload that was provided to the defense so that that information is available to the court for whatever purposes the court deems necessary.
Can I ask this?
Yes, ma'am.
First, would that discovery upload include your interviews, the tape of the interviews, as well as your summary of them?
Yes, ma'am.
All right. I will ask you to let my clerk, Eva Diaz, talk with you afterwards about how to send me something of that volume.
Sure.
Our court IT has a lot of barriers in our system to us receiving even conventional websites and web tools for examining and filing documents. And so I will want her to interact with you all about exactly how I am to receive that material. But yes, I would be happy to receive it.
And we would be happy to get a couple of flash drives and provide it that way, if that makes sense.
And that might be the better way to do it, because, again, I can very easily examine a flash drive and a text on, and typically you are kind enough to provide an index at the front of the flash drive as to where the various materials are located. That might be better than using one of these web document sources, since so many of them are excluded from our system.
We'll prepare one and have a copy for you, Your Honor, and for Ms. Diaz, the clerk as well. Thank you.
Now, on my list, I have in the courtroom at this time, Mr. Bland, who represents certain of the jurors, Mr. McCullough, who represents certain of the jurors, and Mr. Lewis, who represents Ms. Hill. Are there others in the courtroom who represent jurors or Ms. Hill?
Your Honor, Ronnie Richter, on American partner.
Went a little fast for me.
Ronnie Richter.
Oh,
Mr. Blank's partner.
right. Any others? All right. Well, then we'll begin with you, Mr. Bland, if you and Mr. Richter would come forward.
May it please the court, Your Honor. Ronnie and I represent 4 jurors who rendered verdicts in this case.
I would like their numbers, but only if that doesn't violate the attorney.
I have them now. Our job is we want to preserve their anonymity.
I understand.
2, we want to make sure that they're not harassed. And 3, we want to make sure that the verdicts of their conscience remain. And that is not only because they voted guilty, if they voted not guilty, we would feel the same way. After hearing what Your Honor has established by the way of procedures, we're very comfortable with what you have established to protect their anonymity and that they're not harassed. Ronnie came up with a good suggestion. Maybe you renumber the jurors 1 through 12. And that way, because there has been some public disclosure of the jurors' numbers in some of those emails, they were the big batch of emails that Mr. Arbuthnot referenced. So maybe we cross-reference with the chart 1 through 12 and the juror numbers. But as far as the questioning goes, there's no need for us to be part of this. You're going to make the questions. You indicated that you're going to preserve their anonymity, that they can't be photographed, they can't be on videotape, and that's about all we have to add.
Yeah, Your Honor, I would amplify that I certainly respect and appreciate the significance of the issues that are before you. And I respect your decision that you're going to make this public. I would have asked you to make the jury portion a closed courtroom. And Your Honor, only for this reason, that I don't know what the jury's going to say, I don't know what you're going to rule. But let's just say in a hypothetical setting that because juror number 9 said something that you believe deprived Mr. Murdaugh of his right to a fair trial, you're going to grant a fair trial, a new trial. I would hate for there to be any mechanism for somebody to backtrace to who was juror number 9. Because I know the public has very firm opinions about this matter, and I wouldn't want that person to be subject to any kind of public scrutiny. So I would have asked of you that for the juror portion that would be closed courtroom, that the press would be present, that their likeness, both voice and face, be modeled, just as an official safeguard. But I certainly appreciate what the safeguard you had put in place. I respect your ruling. I just throw that out for consideration. And on a broader perspective, I know that you've had this experience as well, Your Honor. It's becoming more and more difficult in this state to see jury. And I can't think of anything more injurious to jury service on a broader perspective than to see jurors who have given up 6 weeks of their lives being pulled back in for a process like this, as necessary as it is. So I worry that the process be handled as gingerly as possible, so as not to further prejudice our ability to get juries going forward.
Thank you, sir. What I will do is this. I think your suggestion of renumbering is a good one, something that my clerk and I have talked about between the two of us as well. In every proceeding I've ever seen where a juror was questioned, in every case I've read where jurors were questioned because of allegations either during trial or post-trial that they had been tampered with, those proceedings have been in open court. And I don't feel it would be appropriate for me to have some kind of in-camera proceeding, even if it included the attorneys, it would have to, and even if it included members of the press, but not the general public. I don't think that is in keeping with the public nature of trials in this state and public nature of court proceedings. However, I think we could make some protective arrangements for when they testify and the ability to be dismissed after they testify that would protect them from being self-harmed to the best extent possible. So that is the way I will handle it, and I hope all things on balance that is as protected as you think it needs to be.
Trust you, Your Honor.
All right.
Your Honor, on behalf of our clients, we will accept their service of the subpoena so that they don't have to be
Well,
served.
that's great, and of course, you don't represent all of them.
No, our four.
You're for, but that's great, and it may very well be that these parties are going to be able to work out something with respect to some of the rest of them. I don't know, but I appreciate that on behalf of the ones you represent.
Do you want me to come up and tell you our juror numbers? You want me to wait?
No, sir. You can. I don't need that this moment.
Okay. Thank you. Thank you.
Yes, sir. Mr. McCullough?
Would you like me here or later?
Go to the podium if you would, please.
All right, I believe that some of your rulings today, they've satisfied several of the things I was going to mention. One, Your Honor, was, of course,
How many jurors do you represent?
I'm sorry, Your Honor, I represent number 785 and 630. One is was a deliberating juror, I suppose we call her, and the other was the removed juror.
Right. Now, with respect to the replaced juror, I think my ruling about the end of any testimony from that juror satisfies any requirements you made. I ruled that I will not hear testimony from that juror, alternate juror at the present time. Now, Mr. Harpootlian is going to submit additional information. As regards your client, I'd ask you to submit that information to you as well. And then I'll see if there's any revision of the position I take about that. You also represent one sitting juror, so you may continue.
Your Honor, the other juror was not alternate. She was actual seated juror.
That's right, the sitting juror.
Who was removed at the end of the trial.
Oh.
Prior to the election. Whoops.
Can you just call speak up, please?
You need to speak up some, Mr. McCullough.
I don't get that much, Your Honor.
Yes, sir.
Your Honor, if you'll indulge me just a moment, I think much of what you've said today bears on a quote that I'm taking from the response of the state, which was filed and is part of your record. And my letter of November 10th responding to that filing is also part of your record. The state said that jury duty is this cornerstone of civic duty. Needless exposure of jurors to litigative stress and impeachment by zealous attorneys in a case especially of this public exposure can only serve to discourage citizens from willingly participating in this civic duty. Your Honor, I'm delighted with your ruling that you'll be asking questions. I've been subject to your interrogative skills in my appearances before the Supreme Court. So I'm pleased with that, and I check that off the list. I would like, Your Honor, for you to take judicial notice that there have been excessive public comments by, and I have to say, Your Honor, in my letter of November 10th, I took Mr. Waters, who signed the letter, to task for labeling one of my clients, one of these jurors, as dishonest. I think I wasn't pleased with that. I think that discourages civic participation. I would ask the court to admonish the litigants, attorneys.
Mr. McCullough, let me stop you there. I am not aware of any of what you're talking about in terms of comments about jurors or otherwise. So that's just not something I'm going to take into account by listening to it or by taking any judicial notice of it. I don't know what I would be taking judicial notice of. I do not know anything about what you're talking about.
Well, Your Honor, both my letter and the response of the state are part of the record, which you obviously have not gotten to, but I would assume yet. My only request is I would admonish lawyers, officers of the court in this courtroom and outside of this courtroom who represent people to be cautioned that this is a search for the truth, not an effort to protect the verdict, nor an effort to discourage people from participation. Negative commentary does that, or runs the risk of doing that. That's all I'm saying.
I understand, and I decline to instruct or admonish participants in this procedure in any way about what you say.
Thank you. Your Honor, next, I'd like Mr. Richter and Mr. Bland appreciate your efforts. I suspect that we will decline a ride to the courthouse, but I would ask the court to consider allowing the jurors who choose not to ride with SLED agents to be permitted an entry and exit from the courthouse that would involve or relieve them of the necessity of coming through the front door.
I think I've already said that I will make arrangements for juror witnesses to report to the basement where the law enforcement station is, and they'll be appropriately directed to their assemblyman.
And Your Honor, lastly, I think, if I understand your rulings or discussions about the process that will occur here, this may run at odds with it. I'm not arguing with you, Your Honor, you know best. I am of the belief that this litigated stress that I earlier referenced could be avoided, and the public and media not denied their opportunity to gain access and knowledge of the proceedings by not exposing these jurors to a crowded gallery, a full gallery of press, by allowing its recording through, I understand court TV will be the full camera. That is to say that I have actually in my history participated in proceedings that involved the questioning of jurors, which was done in camera. So I don't think it's without any precedent, but I would obviously respect your ruling, but I would ask you to consider or reconsider that no damage would be done to the right of the public to know and participate in the proceedings, but you can accomplish the same thing by allowing the pool camera and avoid the distraction and the imposition of that on these jurors. And
I hear what you're saying, and I'm not inclined to change the ruling I've made at the present time, but I'll keep an open mind about it as we make pre-trial preparations for the hearing. At the present time, the jurors will be examined in the courtroom, as I have indicated, with appropriate identity protection.
thank you, Your Honor. And subject to your rulings, I will have both of my clients available for these parties as they might be needed, subject to your subsequent ruling.
Thank you.
Thank you.
Your Honor, do you expect all jurors to be present for all 3 days?
So, let me make it very clear that I expect the jurors will be the first witnesses to be called in these proceedings. And the jurors will testify, and then they would be dismissed. They would not be required to stay for the rest of the proceedings at all. So that is very much a part of my thought about what it takes to protect their identities. They would be protected as best I can, and the ability of others to come and to set them with questions as they need would be protected. So,
Do you expect that you could get through all 12 in one day, or should I tell them, because a couple have to take off of work?
yes, I do.
Okay, thank you.
And Mr. Lewis.
Your Honor, I'll be brief. In light of your rulings, I don't think you need much from me. The only thing that I'll add is I'll have Ms. Hill available for here as the parties need, and happy to accept service to alleviate one issue for this court. Unless you need anything from me, Your Honor.
All right, thank you for that. And before you leave the podium, let me just consult with the lawyers. I'm not going to ask them to examine you guys to be paid off, but I'm going to ask them if there's anything else I need to inquire of before I let you go. As I understand, if the subpoena, and we would have a formal subpoena of Ms. Hill, would be placed in your hands as her attorney. And you would assure her appearance, and I appreciate that very much.
Absolutely.
Is there anything else on behalf of Mr. Murdaugh?
Your Honor, just in an effort to try to expedite this matter, I have two questions. One, will Ms. Holt meet with Mr. Griffin and I?
We should evaluate that.
You'll evaluate it. Okay, that's all I can ask. And secondly, should we have her here on that Monday or wait? I mean, if you're going to be doing the jurors most of all
She should
day.
be here as court reviews.
All right, thank you. Nothing from the state, Your Honor.
All right.
Thank you, Your Honor.
I'll go over my checklist one more time, but I think I've covered everything I want to cover. I'll come to each of you in a moment. Yes, just to clarify other witnesses, as matters now stand, the witnesses in this proceeding would be jurors and Ms. Hill. So I want to be sure that we all understand exactly what's going on in that regard. I would not allow the attorneys to be called. I'm unclear about the mention in some of the papers that SLED investigators would be asked to testify or any other witnesses. So I'm going to go one more time. I want to get real specific so you will understand what you need to prepare for by way of in-court examination and what you need to prepare for by way of submitting proffer. All right, first of all, for the defendant.
Please, Court, Your Honor, just a couple of issues. One, we don't know who we're going to call to impeach Ms. Hill. Because we don't know what she's going to say. So it's difficult for us. I mean, once she testifies, at that point, we say we'd like to call so-and-so and so-and-so and such and such and such and such, number one. Or maybe no one. I mean, she may concede every issue we had. For instance, she did tell, according to the state, she did tell one of her assistants, one of the people helping her, you know, I hope he's found guilty because it'll help book sales. Now,
I hope that's the last time you're gonna repeat that until, I ask for it again, Mr. Harpootlian. I've told you that I can't imagine a situation in which I would go that far. So a statement like that, and she may well have said it, if it goes to anything I'm asked to consider, it would be to her credibility. And I'll evaluate whether I think that's even proper to ask, but let's move on from that.
but there are other questions concerning her credibility.
Yes, sir.
404 motive, for if she did this, it is a crime. And so, you know, the question of why she would have done this extraordinary act, and we can argue this at another time, but in terms of me the reason I mention it is for us to proffer those people now, not knowing what she may admit, that question may get asked, she may admit it, there's no witness that needs to be called. So it's difficult for me to gain this out. I don't think I've ever been asked to list witnesses I would call to impeach somebody if they lie under oath. I've never heard of such a thing, but I will attempt to do the witnesses we would call prior to Ms. Hill's testimony. That's all I think I can do, if that makes sense.
It doesn't make complete sense to me because this is not the trial of Ms. Hill. And issues about motive and so forth and the possible commission of crimes are not what this inquiry is about. It is about her contact with any of the jurors and what she said. So I will be treading very carefully with a good deal of what you say about what you might or might not ask. But I am going to ask all the parties to be pretty specific with me about what I should be asking the jurors, and I can make a decision in advance as to what I am going to do about that, and what is going to be, at least by general topic, pursued with witnesses.
Yes,
And the reason I do that is because it gives me the opportunity to then consider what rulings I would make and move the proceedings along in an orderly way.
Well, Your Honor, maybe premature for me to note this for the record, but we would accept your ruling on that.
All right.
Okay. Secondly, Mr. Murdaugh has been unable to review any of the discovered material in this case because of the confidentiality order prohibits us to distribute to him while he's in jail. We don't have time in the next less than 2 weeks to go sit down with him and review everything. Would Your Honor allow him to have, and the materials are not as to the evidence in the underlying case, it's as to jury issues. And while he's no longer a lawyer, he was a lawyer at one point, and can evaluate this and be of assistance to us if he has an opportunity to review that material.
You're speaking to me about something in a complete vacuum as far as I'm concerned, so I can't really evaluate what you haven't been able to review with him and what you have been able to review with him. As I understand what you're telling me is, I have received certain information as the attorney for defendant that I have not been able to show defendant for defendant's review because of the confidentiality order. I can't imagine that. I think what you may be saying is Mr. Murdaugh has not been able to keep for himself while I'm not there confidential materials.
That's correct.
That is something common to many folks who are under incarceration or limited in the kind of materials that they can receive and keep in their possession when they're not with their lawyer. This is not an issue where he's being deprived of the ability to consider material that you have received. This is a question of whether he can have that material in his possession when you are not there or your representatives are not there and study upon it and so forth. I can't control what the limitations of the Department of Corrections are, nor can I control what limitations may have been put on confidential material because of the fear that it would fall into other hands. So I'm not going to rule in the abstract on things. I would have to have something that's pretty specific, but I can tell you this. I would certainly not order that these materials be wholesale given to him for him to take back to his cell and have in his possession, because I don't know who might see them were that the case. And if they are confidential materials, that would be an extreme risk of breaching the confidentiality of the materials to do that because of his situation. And his situation is as it is, not my making or yours.
Your Honor, I would only note for the record this: much of the material we've received has been within the last 2 weeks. This hearing is scheduled for 2 weeks from yesterday.
Yes, sir.
And you've given us more stuff we have to do between now and that hearing. There's nobody to go sit with him at the jail, and his time is limited as to when those people can visit. So without him being able to review this material, I don't believe we can be effective, and we would be ineffective in representing him.
Well, I understand that those are wise statements for an attorney to make to preserve your position on the record. It doesn't change my view of how we should proceed in this matter at all. I think you will be able to, if there are deficits in what you have been able to do with your client, you will place those contentions on the record, and the appellate courts of the state will have adequate chance to review.
Well, Your Honor, would you consider continuing hearing on the 29th allow us to meet with the client, effectively review these materials?
No, sir.
Okay.
Thank you.
We respectfully accept your rule.
I understand.
Thank you.
Mr. Waters?
I don't have much to address, Your Honor. The initial question that Your Honor asked was about SLED agents being listed on the potential witnesses. And, again, Your Honor, when these allegations were first raised, we instructed SLED to do an independent investigation, good, bad, or ugly. And only because of the results of that investigation, or the reason why we're standing here and litigating these issues before Your Honor, ultimately, the only way that SLED agents could potentially be testifying, and again, when we filed our response, we didn't know exactly the parameters of the court would rule. The only way that I can see them potentially testifying is in the event that there is an accepted witness by Your Honor, that there was some sort of prior inconsistent statement under Rule 613 or some other permissible inquiry. But I think Your Honor's rulings as to the nature of the inquiry we're going to conduct would probably remove or make very unlikely that need.
All right. Anything further?
Nothing from the state, Your Honor.
Nothing to defend, Your Honor.
All right. I say to attorneys for both sides, the court is deeply grateful for the very fine materials you have submitted so far. It's an extreme amount of work in a very truncated period of time, and I appreciate the burdens it places upon you, Mr. Hopgood, and I particularly thank you as a member of the General Assembly for not interposing your immunity because you are in session, and I respect that. I set these matters after consultation with y'all so that I could fulfill my obligations to the court as expressed in Chief Justice Beatty's order. But I realize that I'm doing that with your extreme cooperation in light of the other duties, and I appreciate it very much.
Thank you, Your Honor.
I look forward to further submissions from the parties and from the hearings commencing January 29th. Court will be in recess.
Thank you.
Thank you, Your Honor.
Okay, so there's going to be 3 days hearing.
I asked Ms. Harris before these matters commenced to please expedite, even if it's in a rough form and not in a perfect form, the court would like to produce the transcript. I asked her to produce a rough copy of the transcript just as soon as she possibly could for both sides. I hope you all will consider, without me having to order, sharing the expense of this production, this early production of the rough copy of this matter. She will be in touch with you. You may be in touch with her with regard to the rough transcript of these proceedings. We'll be in recess.
Thank you, Your Honor.
Okay, and we're about ready to go back to post-lunch in Connecticut. Okay, let's see. We're still on a break over here. Yesterday, I found out about a case. I'd heard mention of it in the past, but I didn't realize it was a local case, and that is Nicholas Salaverdian, also known as Nick Rossi, and a bunch of other things. He was, I think he was from Rhode Island, and when he was off at college, he assaulted a woman in a staircase, and so he became an RSO. And now he's let's see, he said that he was dying, and then his obituary was published, and his biological mother saw the obituary and went, he's not dead, he wrote this. And they tracked him down. He had COVID he was over in Scotland, and DNA showed him to be behind two assaults, one here in Orem and one in Salt Lake. And there might have been one other one. So anyway, he was fighting extradition, saying that he was an Irish orphan and that, he had nothing to do with this person and the tattoos that identified him. He woke up and the tattoos were on his arm. And so the people in the hospital tattooed him, or some random person came in and tattooed him in the hospital. Good one. Yeah. This was during the height of COVID. So anyway, he's been fighting extradition, and apparently he was extradited late last week, I think, to I think they said Maine, and now he's made it to Utah. And so this big international case, gonna try to follow that one. He doesn't have a hearing yet. Let me double check that. Oops. Yeah, just my cursor jumps around sometimes and starts something or closes something. Let's see, I need to go to the docket page to double check that. No, it doesn't show anything, but I expect pretty soon we will have an initial appearance for one of the assaults. I'm not sure if it'll be the Salt Lake one or the Orem one. But I assume that he will want to be out on bail, but when you've already faked your death once to avoid registering as an RSO and so forth, I think that the court is going to take a dim view on getting bail. So let's, oops. Okay, there's no sign so far of let me see. See if we can find a short piece on this Nicholas Salaverdian which caused such a sensation since it was involving countries on both sides of the pond. Oh, no, those are pretty long. Let's go for Jesse Kershevsky sentencing date. I thought she had a hearing today. Maybe I'm mixed up and it was Sarah Boone. Let me pull this up and I'll take a look. Oh, that's not it. Okay. Boy, it's taking forever.
All rise.
Thank you, everyone. Please be seated. Madam Court Reporter, are you able to hear me? All right. We then are on the record. The court will call State of Wisconsin versus Jesse Kershevsky, 21 CF 885. May I have the appearances, please?
Abby Nikolai, JJ Crawford, and Randy Sitzberger appear for the state. Good morning, Judge.
Good morning.
Ms. Jesse Kershevsky appears in person and in custody with Attorney Nicole Ostrowski and Attorney Jeffrey Jensen Jr.
Good morning. And I do have victim witness on Ms. Carrie Peterson. I also have one of the victims on by Zoom as well. So has the state complied with victim rights?
I'm just waiting.
Fast work.
What is that arrow supposed to do?
That arrow basically designates up, or it helps orient the print.
And last photograph on that file, 14, picture 26.
That is another latent print lifted from the Suburban.
With respect to the, was this also designated a number and exhibit number?
Yes, this was latent print number 13, State Police Exhibit 116.
With respect to the Chevy Suburban, was there another day that it was examined or processed?
Yes, in June.
Okay, so in the June processing, what did that entail?
That entailed examining the undercarriage of the vehicle.
And was there a third time that that vehicle was processed?
Yes, that was sometime in September, I believe.
In a few months later?
2019.
2019. Thank you. Where was the vehicle located when it was processed?
It was located in the impound lot at Troop L. Litchfield.
And what was the purpose of that examination?
That was to obtain more swabs from the interior of the vehicle, more swab samples.
And were any swabs taken?
Yes.
So what were those swabbings?
I seized swabs from the steering wheel, gear shift, I believe seat adjustment controls, things like that.
And do you recall what exhibit number those were?
Not off the top of my head, ma'am.
I may just have one moment. Don't have the box up here. Never mind. I may just have one moment, Your Honor. I'll withdraw that, Your Honor. I don't have my file for that one. May I just have a moment?
Yes.
Okay, so with respect to the other vehicle that was inside the garage, the Range Rover, I'm gonna draw your attention specifically to States 9, File 15. If you can, take a look behind you, sir. What does that vehicle depict, please? Or, I'm sorry, what does that picture depict?
That's the front of the Range Rover that was parked in the garage at 69 Wells.
Picture 2, what does that show?
That is the driver's side of the Range Rover.
And I'm gonna draw your attention actually down to and scroll in to the here where there's a pink sticky and a marking. It's a little blurry, but can you see what that depicts, sir?
I can't see, ma'am, but it's marked up in a similar manner of a swab being taken.
Do you recall what swabbing that was?
Can I take a closer look at the screen?
Yes, and would it also refresh your recollection to take a look at your report?
That would be better.
If I may just approach the clerk, Your Honor.
Yes.
Eleven for ID.
Thank you.
Thank you. Did that refresh your recollection, sir?
Yes.
If you wouldn't mind, if you wouldn't mind getting up and pointing to the screen again, I apologize. And could you please identify, if you could, to your knowledge and recollection, what markings those are?
Yes, that is Exhibit 61 is on the front door. And 62 is on the rear door.
And with respect to those exhibits, did you swab them?
Yes, they were field tested, swabbed and collected in the same manner as the other stains in the garage.
And was that 2 swabs?
2 swabs for the evidentiary collection.
And KM, the result?
KM was positive.
State picture 3. What is that, sir?
That is another blood-like stain found on the Range Rover. As far as location, I would have to refer to my report.
If you could, sir, please. And do you know the location of that photograph, or what's depicted in that photograph?
Yes, that is a blood-like stain we found on the left side of the hood.
Was that swabbed?
Yes, it was field tested, swabbed and collected.
And the results of the field test?
Field test was positive.
So picture 4 out of file 15, I believe. What does that picture depict, sir?
So that's the Exhibit 61 I spoke about before on the front door of the, excuse me, left front door of the Range Rover. And you can see the apparent spatter pattern that the stain was collected out of.
And same questions with respect to the seizing of it as an exhibit, please.
Yeah, so that was field tested. It was field tested positive, and then it was collected in the usual manner.
And that's 2 swabbings?
2 swabbings, correct.
Thank you. Picture 5.
That's a blood-like stain found on the left rear door of the Range Rover. It was KM positive, and it was collected with 2 swabs, similar to all the others.
Hey, when you say rear door, which side of the vehicle?
That was driver's side, left side.
Picture 6.
Picture 6 is the left front corner of the bumper of the Range Rover. State Police Exhibit 60 was a swabbing, or 2 swabbings collected from that stain that the arrow was pointing to. And Exhibit 69 is a sample of the blood-like stain that was found below it. Both items were field tested. They field tested positive, and both were collected in the usual manner, 2 swabs.
Picture 7.
That is a photo of State Police Exhibit 63. The location of which escapes me, ma'am.
If you could refer to your exhibit report, please, which for the record is states 11 Friday.
Okay, that stain is on the left rear fender of the Range Rover. It was also field tested positive with the KM test. It was collected with 2 swabs in the usual manner.
Picture 8.
Okay, so 8 is a latent print taken from the Range Rover. Latent print number 9, Exhibit 93. If I could double check the location.
If you could refer to your report, please.
And latent print number 9 was lifted from the front fender.
And just with respect to the latent print number 9, can you just walk us through the process of taking the print off of the vehicle?
So this print, again, once it was developed and marked, photographed, we would take adhesive acetate, something clear. Probably in this case, I used a gelatin lifter. Again, it's a thin layer of gelatin on top of a rubber backing. It kind of molds better to the curves of the car.
Picture 9.
That is a photo of Exhibit 58, which was a sampling of the blood-like stains found on the grill.
And if you could just head up to the screen, I have a few questions with this. Now, with respect to Exhibit 58, what did you designate 58 as?
I field tested these with the KM test, which was a positive test.
Okay. Actually, if you could, what about up here, one above, I'll start with the one above the V.
I believe those scales were placed there to document the apparent spatter found up here, probably placed there by the photographers.
Did you take any samples or swabbings, I should say, for anything above the rover, the words
No,
rover?
those are not marked as an exhibit.
Picture 10. So with respect to the, right above the, I guess, the measurement marking or the label, the exhibit 58, was that the area that was swabbed? Or that you're designated as exhibit 58, or is it, my other question is it above the grill? Is it separated, or did you include that as the entire, any of the blood spatter?
I'm sorry, can I refer to my exhibit report?
If you can.
Okay, I was mistaken. This wasn't a blood swab. We were treating this, this apparent impression or a print and blood-like material that we found on the grill. We photographed this in the usual manner, in a manner similar to the way we did the prints on the floor. So these were photographed, and then later the photographs were designated as exhibit 58.
So just to be clear, there was not swabbed in this?
I did not swab this.
Okay, and it was not tested or it was tested?
I believe,
Objection.
I'm just asking to
Well,
clarify, Your Honor.
The question is, was this swabbed or was it not swabbed? And the response was going to be, I believe. Well, there can be a follow-up question. Court will overrule the objection.
I can't say for sure.
And with respect to any testing on it, do you recall if there was any testing on exhibit 58?
Nothing beyond photography.
We on to photograph 11. What does this depict?
That is more blood-like stains on the grill of the Range Rover.
And picture 12.
That is another photo of the blood-like stains on the left rear door of the Range Rover.
And what about this marking from, I guess, in the middle
And
of
so, along the side of the car, you can see in this road grime here, salt, dirt, sand. You can kind of see it like a swipe mark through there.
picture 13?
Photo of some blood-like stains on this is the left front wheel of the Range Rover.
Now, with respect to the Range Rover, was there also a additional processing?
Yes, we process this in our usual manner of processing a vehicle.
And I'm going to show you what's marked.
Before we proceed, Attorney Manning, it may be more advantageous for the record if there was a better description. Is it rim?
That's true. Thank you, Your Honor. Sir, if you could just describe what you see in the photograph, please. This is states 13.
Sure. When I refer to the wheel, it's really the rim, not the rubber tire. So I'm looking at these, I'm referring to these blood-like stains inside the metal of the rim.
And for the record, you're pointing to where on the photograph?
Basically throughout in the approximate center of the photo.
And picture 14, sir, do you recognize that?
Yes.
What is that?
That's the Range Rover. We examined this along with the Chevy Suburban at Troop G in Bridgeport on June 26, 2019. For similar material, additional biological material from the undercarriage.
Picture 15, what does that picture depict?
This is an overall view of the undercarriage seen while the vehicle was up on the lift. You can see on this L-shaped scale here, the photographer added a directional arrow for front. So the front would be the top of the screen. And then driver's side or left side of the vehicle is toward the right side of the screen.
Picture 16.
This was seized from the lower area of the Range Rover as item D. Again, this was scraped into a paper fold, designated as item D, and later the area was swabbed.
And item E. I'm sorry, picture 17, with respect to item E on picture 17.
Yes, this is
What is
on
that?
the left side of the Range Rover. Again, kind of around the rocker panel. So item E is designated by the arrow. This material was scraped into a paper fold, and later the area was swabbed.
Picture 18, please.
Again, just another photo of item E.
Thank you, sir. You can sit down. I want to go back and ask you a few more questions about that October processing of the Chevy Suburban. Do you recall how many exhibits you took, if any, out of the car that day?
Not off the top of my head now.
If I can. Would it refresh your recollection as you go to your report?
Yes.
I may approach the clerk, Your Honor.
Yes.
So I'm going to show you what's been marked as 13 for ID. Please take a minute and take a look at it. Please don't read it out loud.
Okay, ma'am.
Okay. Did that refresh your recollection, sir?
Yes.
Okay. With respect to that processing, how many swabs were taken out of the car that day?
There were 6 exhibits containing anywhere between 2 and 4 swabs.
And what were some of the, for instance, do you recall exhibit 370?
Yes.
What was that swabbing of?
That was a swabbing of the steering wheel, and that was complete with 4 swabs.
And are you utilizing a report to refresh your recollection on this?
Yes.
Okay. Exhibit 371?
371, again, 4 swabbings from the steering wheel. These were from the areas with visible blood stains. The item before that, 370, was taken from unstained areas or apparent unstained areas.
Attorney Manning, the court heard that there was a third processing in September 2019, and counsel made reference to a processing in October.
If I may inquire of Detective Riley, Your Honor, is there another processing in September?
No, the processing where we took the extra swabs was actually, the proper date was October 18th.
Thank you.
I apologize.
And with respect to how about exhibit 372?
372 was 4 swabs taken from the interior side of the left front door.
Do you recall where that was on the door?
It was, I ran the swabs around all areas of the door in an effort to pick up as much genetic material as I could.
And exhibit 373?
That was taken from the left front seat adjustments. This was 2 swabs.
And by front seat adjustments, just what do you mean by that?
So they're the side buttons on the driver's seat used to adjust the seat for the driver.
And 374?
374 was swabs taken from the rear view mirror.
And 375?
And 375 was swabs taken from the rear seat controls in the cargo area.
If I may have one moment, Your Honor.
Yes.
I have nothing further, thank you.
Cross-examination, Attorney Shaw.
Good afternoon, Mr. Riley. You're retired, right?
Yes,
I hope you're enjoying your retirement.
I am. Thank you.
Let me ask you a few questions. Let's start with this presumptive testing that we've talked a lot about here. It's my understanding as you testified that when we're talking about these chemical presumptive tests, there are at least 2 that you talked about today, right?
Yes,
The first was called Kastle-Meyer, begins with a K instead of a C, right? It's like hyphenated 2 names.
yes,
And the second one was something called luminol, right?
yes,
And Kastle-Meyer, you said, is made up of 2 chemicals. One is phenolphthalein, right?
yes,
And the other is hydrogen peroxide, right?
yes.
Now, phenolphthalein is the stuff that they use to test swimming pools for chlorine, right? Isn't that the same stuff?
I don't know, sir.
So you're not an expert in science. You're not a chemist or anything like that, right?
No,
So when you said you had some training in it, you were trained in how to administer it, right?
yes,
You don't know anything about the chemistry itself and why something shows pink or glows or changes color at all, right?
that's correct.
And the training, you said you also received from the lab some kind of like a kit in order to administer it, right?
Yes,
And phenolphthalein is a liquid, isn't it?
yes,
And so is hydrogen peroxide, correct?
yes,
Now, hydrogen, that's the same chemical that you use maybe if you have an infection, maybe to disinfect, right?
yes,
And I guess some people might even use it to bleach their hair, right? In the day, right? There are people have peroxide hair where they really white bleach blonde. Is that the same stuff?
I'm not sure, sir.
Okay. But in any event, you also said that there are things, when you talk about presumptions, right? You're trying to see if there's a place that you're going to do some swabbing or photography, right?
For the Kastle-Meyer,
Yeah.
it's more, we do our searches visually.
Okay, so you see something that looks like a stain, right? You maybe do a little chemical wipe with the KM, right?
Or conduct the KM test, correct?
You do a KM test, and if it comes back negative, do you still take a picture of it?
Sometimes,
So we saw a couple of those. You tested a stain on the floor of the garage, and it didn't even come up with a presumptive test, right?
right,
But in any event, if it comes up presumptive, one of the things you indicated that it's presumptive for is blood, right?
well, the test, it's presumptive for blood.
That's what I mean. The test is presumptive for blood by putting the 2 chemicals together with the sample, right?
Yes,
And you did mention a couple of things that it also is presumptive for, right?
yes,
Right?
yes,
Doesn't distinguish between one animal or another, does it?
no,
I think you also mentioned horseradish is something that it tests positive for.
that's one of the classical examples.
Okay. Now, are you familiar with some of the other things that it tests positive for?
I'm familiar with turmeric.
Turmeric, right? Now, doesn't it also test positive for tomato?
I don't know.
What about rust, iron rust?
I don't know.
You don't know?
No.
How about bleach? You know about that?
No.
How about copper?
No.
You don't know. Is that what you're saying? Whether it'll show a presumptive positive for copper, like iodized copper?
I don't think so, sir.
How about malt, like you find in either beer or a milkshake?
That I don't know either.
Aren't there, in fact, 16 different food groups that test positive using Castlemire?
I don't know, sir.
We'd have to have somebody who's like a scientist that knows this to really answer those questions, right?
Yes.
But if we're talking about a presumptive test, if you wanted to be presumptive about the presence of horseradish, this would be the test to use, right?
I would need to presume something was horseradish, sir.
Well, the presumptive test is not what you think, it's whether it turns pink, right?
Yeah, I'm not sure I'm following your question, sir. I mean, it does react in a positive manner with horseradish.
So I'm saying if I wanted to presume that a stain on my kitchen cabinet is horseradish, I might use this test, right?
If you really wanted to.
Exactly. And so let's say a, I don't know, spilled hamburger, piece of hamburger juice, that would test positive, right?
I don't know. I've never tried it on hamburger, sir.
Well, hamburger is basically animal meat, right?
Yeah, but I've never tried it on hamburgers.
Fair enough. But it would also test positive for, I don't know, a cat, a little blood from a cat, right?
Oh, yes, animals, absolutely.
Mice, right? There's a garage, right?
If you had an injured mouse, yes.
But you would also agree, would you not, that you would need a confirmatory test done by a lab to see whether the presumption or assumption turned out to be correct, right?
Yes.
And you know that in your, never mind in this case, but in your experience, some of the things that you show a positive presumptive to be blood at all, correct?
I've never had that experience.
Well, you don't do the actual testing, do you?
No, I mean, when I learn of the results, I've never had that experience.
So you don't know that in this case, that was in fact, several of these items turned out not to have any evidence of blood in it?
Objection, Your Honor.
Sustained.
You didn't even test all of the spots that we just saw pictures of, did you?
Me personally, no,
Yeah.
I didn't.
Let me ask you a few questions about luminol. We saw some pictures in the back of the Suburban, right? Including a couple in the dark where you see this little purple glow, right?
Blue glow, correct, sir.
Blue, purple. Those were kind of like, those photographs were taken with a time-lapse photography, right?
Yes.
So they appeared brighter than they might with the naked eye, correct?
I can't say for sure, sir.
And you use that in order just to choose where you might take another spot, right?
Yes.
Now, you said that luminol tests for the presence of iron, right?
Yes.
So you know that a car is made out of steel, or most of them are, right?
Yes, it is.
And steel is an iron alloy, is it not?
It is.
So it would stand to reason that in a motor vehicle, there might be some exposed metal places that might test positive using luminol, right?
Correct.
So if you wanted to see if your car was rusty, you might spray some luminol on it and you would have a positive glowing result, right?
It would even glow on the non-rusted parts.
Right, but it would glow on even the non-rusted parts because you're in a car, right?
Yes.
And if you're talking about, let's say, a car where there are children that have been passengers in that car, there might be all sorts of other things that will test positive for the presence of iron. Isn't that true?
Possibly, yes.
You know that I think turnips also test positive for luminol, don't they?
I don't know that for a
You know, a
fact.
lot of root vegetables have iron in them, right?
No,
You do know that.
I do
right?
know.
And it's actually, they're good for you to eat, right? Am I right?
I'm gonna object, Your Honor.
Well, the question's not relevant, sustained.
If you wanted to see if you maybe dropped a turnip on the ground in the back seat of the car, you might use luminol and it might glow, right?
Objection,
Ground.
irrelevance, and I assume facts not in evidence.
Well, the line of the cross-examination is a number of substances or fruits or vegetables contain iron. This is just an extension of that line overruled.
All right.
I think you'd be able to see a turnip and would need luminol.
But the luminol might illuminate it, right?
I don't know. I've never tried it on
Never
a turnip, sir.
Fair enough. Bleach also will glow in luminol, won't it?
Yes.
You already mentioned horseradish for K&M. This would also test positive in luminol, wouldn't it?
I don't know for sure.
How about rust?
Yes.
So if a child had, let's say, ice skates in the back of the car, some of that maybe scratched off on the back seat, that would
Objection,
test positive for luminol, wouldn't it?
Well, here's an objection. And it calls for a hypothetical, but the hypothetical isn't developed in such a way as to aid the jury. Essentially what the question is since there are ice skates have metal, probably steel. Steel is an alloy of iron. In other words, it's an extension, but the extension is becoming very thin. But the court is going to allow the question.
And I will then move on, but if you're going to a million hypothetical.
Yes. This is possible.
All right. A lot of the photographs we've seen were various angles of the very same spots that you tested, isn't that right?
Yes.
So just by looking at these photographs, you have to look very carefully to see whether or not 3, 4, maybe even 5 photographs were of the same location that you did a swab, isn't that right?
No, I just swabbed from the areas that were marked as exhibits.
Oh, no, I understand that. I'm talking about the photographs from different angles to a certain extent of the same areas that you had swabbed.
Yes.
I also want to be clear about the measuring tapes that are in many of these pictures. The white tape is in centimeters and millimeters, correct?
And I believe it's inches on one side too.
Well, the yellow, isn't the yellow the inches?
You said the white tape, sir?
Yeah, doesn't the white tape say metric on some of them in those pictures?
I don't know. I would have to look at the pictures.
All right, fair enough. But if you're familiar with the fact that there's a distinction between the metric system, which uses centimeters and millimeters, and the American measuring system that uses inches and feet, right?
Yes.
I want to ask you a few questions about the paper towels in the kitchen. And the first thing I want to do is call up one of the pictures that was on the exhibit that was introduced through you. And if I could have 8-139. For your edification, this is the image where you put the state police exhibit number 13 on. If you would look at that screen behind you, sir. You see that image there?
Yes.
And I think you testified that this was the paper towel that you examined. You did some kind of a test on it as well, right?
Yes.
And you seized the whole thing or just a portion of it?
The whole thing, sir.
When you came into the house that day, this would be the 25th, correct?
Yes.
Was this exactly when you went in the location where you found this paper towel roll?
Not the exact location, no.
It was moved around?
It was in that general same corner of the sink, sir.
Did you move it so that somebody could take a better picture?
No, I moved it so I could examine it and field test it.
When this picture was taken and you put that yellow tab next to it, is that the location you found it in before you moved it in the exam?
No, I don't believe so, sir. Not the
Where
same
was
as
it when you
for the sink, sir?
So when you say in the corner of the sink, was it off the roller? That is the metal device that the paper towel roll is standing next to?
I believe so, but I'm not sure, sir.
Did you observe anyone else move it? Take it off it?
No.
And just so that we're talking about the same thing, right? I'm referring to this item here that's to the left of the paper towel roll. You see that there?
Yes,
You recall seeing that there, right?
yes.
But when you got there, that paper towel roll was not on that device, the dispenser roll.
I think they were separate, but I'm not sure.
Well, if you're not sure, do you not recall seeing someone physically remove it?
Objection.
Well, the response was he's not sure if it was on the holder. And the question was, well, if you are not sure, can you recall someone seeing, can you recall seeing someone move it off of the holder?
Sure.
So it wasn't placed there in order for you specifically to examine it in that location. Is that a fair statement?
No, I certainly.
Ask you now, I had a couple of screenshots taken from, I think it's Exhibit 7. We had Detective Clabby had a video. I took a couple of screenshots from it, and I'm just going to show you if I can.
Excuse me, may I have a moment with counsel?
Yes.
Yeah.
What time is this?
Give me a second. I'm gonna have this marked if I may.
Yes.
So I'm going to show you, is there any objection to Exhibit
That's those,
A? Those two?
that's this one, or this one?
Yeah, that's.
This one, A. No objection, thank you.
What's the marking, please?
That's Exhibit A.
Defense A admitted as a full exhibit.
So if you could, before we show you the image, before you got there, you know that Detective Clabby was also on scene, is that right?
Well, we were there at the same time, sir.
Fair enough. Did you all arrive in the van or did you come separate?
No, we came separately.
But you recall seeing him there?
Yes,
You knew that he was assigned the videography for that scene that day?
yes,
Did you observe him doing any videography?
yes.
Did he do that, at least the overview, before you got to work making any examples, any swabs or anything like that, taking?
Yes.
All right, so I'm going to show you a couple of screenshots from that video that Detective Clabby took. And have you seen that video at any point?
Not in a long time, sir.
All right, so I'm going to show you one screenshot called Screenshot. Let me just put that up, please. Now, looking at the video screenshot that I've just put up here, you see that the paper towel is on the dispenser in that image, correct?
Correct.
So my question to you, was that how it was when you observed it, or was it already off the roll when you examined it?
Objection. Asked and answered, Your Honor. He indicated he doesn't remember.
The response has been he does not remember.
All right, does that help? All right. Does looking at this image help you refresh your recollection as to whether or not it was on the dispenser when you arrived?
Objection, Your Honor.
Grounds.
Again, he's been asked and answered. It's now a full exhibit.
Well,
I'll withdraw the question. I'll withdraw the question. I'm going to show you another screenshot in a moment, but well, it's up there now. This is from the pantry. Do you recall looking in the pantry at the in that kitchen, between the kitchen and the mudroom?
Between the mudroom and the dining room, sir?
Yes.
Yes.
All right. So if you would just put up that image, this is also from the same exhibit. Do you recall that this was the view of that pantry when you looked at it?
Yes, that's consistent.
Did you take any swabs or collect any evidence from what's shown in that image?
I did not.
Could I have this marked, please?
Wait, oh, that's the video.
Mhm.
Okay.
I would offer exhibit, defense exhibit B.
no objection.
No, sir.
Defense B admitted as a full exhibit.
All right, I'm going to show you an image that was taken from the by the officer who arrived at New Canaan Police from the New Canaan Police Department on the evening of May 24th, 2019. All right, so if we could have that. Now, no, if you don't recognize the New Canaan police officer that's seen in this image, do you?
No.
And I'll just note the time is indicated at 5:24:19 at 19:57 and 33. This is from State's Exhibit 1, I believe, which was the video that was from the body camera of one of the patrol officers that was there that night. Okay.
Okay.
So again, I'm just going to ask you to note. Did you ever see the paper towel roll on the dispenser when you were at the house?
I don't remember.
Now, I'm also going to show you two other images. I think they're also from this exhibit. X8, please. It's image 0064 from that exhibit. Do you recall seeing any of the items that are indicated here during your your investigation on May 25th, 2019 inside the home?
Specific items?
Any specific items in the pantry that we're seeing here?
No.
I'll show you the next picture, please, which is it's image 0065, or I'm just calling it X21 for my. Does this particular roll, did you observe this roll of paper towel in the pantry at Wells Lane when you were there collecting it?
I don't remember that.
I'm going to show you a couple of pictures from the garage that we've already been through, and you described where you took certain swabs. The first picture I want to show you is from your disc exhibit, which I believe the whole exhibit is, I think, 7. I'm sorry, I'll just have a moment.
Which one? 9.
The large disc. What do you think? No, the one that we put in yesterday. That.
Yes.
It is 9. Okay.
9.
Sure. I'm going to show you some images from Exhibit 9, if I may. And the first exhibit I want to ask you about is marked on your Exhibit 9 is 12-362. If that, we could have that up on the screen, please. You recall this is the exhibit that you marked as A16, or somebody marked as A16, correct?
I don't think that was an exhibit. I think that was just for documentation purposes.
All right. So let me also get that clarification. If there's a yellow placard, then it was seized as some kind of an exhibit for your purposes of your investigation. Is that correct?
Or it was marked on a similar label with EX, whatever.
So the A letter, was that your writing on this document, on this image?
No.
This would be something that whichever detective was placing these markers down would have noted. Is that right?
Yes.
And I asked you this when we were first putting some of these pictures up. If we look at this image here, when you saw this particular marker, did you note the marking on the sticker itself?
No, I didn't note it.
You did not?
No.
Okay. So you don't know how that got there?
Specifically, no.
Okay. I'm going to show you another image. This one is 13-363. It's in the same series. And this is also one of the images that you testified to yesterday, correct?
Yes.
And I'm asking you specifically about the mark on the middle of this document here. Was that present when you were examining that particular spot on the ground?
I don't remember it.
You don't recall seeing that?
No.
And you also testified, if I'm not mistaken, that there was also a fair amount of, you called it vegetative matter, seeds or leaves and whatnot on this garage floor, correct?
Yes.
And did you gather any of those?
No.
Show you one more in this series. This would be 14-157. Once again, I'm just going to ask you whether or not you recognize or saw this item on the placard when you were looking at this particular location on it.
I don't recall it being there.
And when you talk about other items, whatnot, talking about, if you look at this picture, we're talking about all of these other specific items and whatnot that we see on the cement floor in a close-up. Is that what you're talking about?
Yes.
Some larger leaves.
Leaves,
And what else?
small stones.
All just on the, what you might expect to find on a garage floor.
Before you proceed, counsel, the court needs to clarify something that is quite subtle. Detective Riley, on the previous photograph, you indicated you did not remember whether you saw that spot on the measuring marker, correct?
That's what I said, yes, Your
But
Honor.
then you said, I don't recall seeing it. Now, it may sound the same, but there's subtle differences. I don't remember whether I saw it. To this court means I don't remember whether it was there or not. I don't recall seeing it means, in this court view, I don't remember that it was there. Which one is it?
It was the former. I did not take note of it, Your Honor.
Thank you.
With regard to the search of the Chevy, you said that you were sent back to take additional samples in October of 2019. Is that correct?
That's correct.
And as I understand from your testimony, it was from additional samples of the steering wheel,
Yes,
from the interior of the left front door,
yes,
from the front seat adjustment control,
yes.
from the cargo area, rear seat controls.
Weren't those one and the same, sir?
Well, that was going to be my next question. Were those separate places, or did you take them from the rear seat controls in the cargo area because the seats were down?
Yeah, I believe when I remember the rear seat controls were in the cargo area.
Because the back seat, the second row of seats were not up, they were down. Is that why you entered that way?
I don't remember whether they were up or down, sir.
You were sent back to do additional swabs because the first set didn't produce any information of value. Is that true?
Objection.
Well, the question is, you were sent back to take additional swabs because the first set didn't yield anything of evidentiary value. And what's the objection?
It's a mischaracterization of evidence, assumes facts not in evidence. And
Well,
it calls for a hearsay answer, Your Honor.
let's take them one at a time. Question was sent back. That's been sent because what you swabbed the first time did not yield anything of evidentiary value. Well, whether it was sent back or not is not material. It's the second section. Because what you recovered the first time was of no evidentiary value. Well, that assumes, in this court view, facts that can be interpreted differently, but in this court view specifically, it's misleading.
This of going back in October was an attempt to get biological material from those locations in the suburban, correct?
Yes,
And whatever you did, you made the same kind of swipe type activity that you described earlier.
yes,
And then you sent that on to the state lab at some point, right?
I don't know if I did personally, but That's the usual process.
All right, well, let me just, I skipped a step, all right? So you gathered it and it was then sent into evidence, right?
Yes,
And then at some point, that was done for the purpose of, at some point, having it examined by the state forensic laboratory, correct?
I believe so. Not sure though, sir.
Well, whether these particular items were then sent on or not, that would have been the purpose of collecting it, right?
Oh, yes, absolutely.
Just have a moment. I have no further questions. Thank you.
Is there redirect?
Just a couple of questions if I can. Detective Riley, do you recall Attorney Shohorn asking you about the other items that a presumptive test could test positive for? Do you recall that line of questioning?
Yes,
Okay. I think some of the things he questioned were about radishes. Do you remember that?
yes.
Okay. In the garage floor, did you find any evidence of radishes anywhere?
No,
Okay. What about cheeseburgers anywhere on the floor?
no cheeseburgers.
What about on the undercarriage of the Chevy Suburban? Did you find any cheeseburgers or radishes there?
No, ma'am.
Okay. What about the undercarriage of the Land Rover? Any cheeseburgers or radishes there?
No,
What about turmeric? Any bottles of turmeric or turmeric sources on the floor of the garage?
no, ma'am.
The Land Rover?
No,
The Chevy Suburban?
no.
All right. With respect to the cargo area of the Chevy Suburban, did you find any evidence of car seats? Any evidence that children were sitting in the trunk area?
In the back? No, ma'am.
With respect to that cargo area, did you see a lot of exposed steel and rust areas?
No.
With respect to, actually, that's all I have. Thank you.
Just a couple of questions. In any of those areas, starting at the garage, did you find evidence of rust stains?
Not that I remember, sir.
Did you notice it, whether or not under the undercarriage of the vehicle, there was some rust?
Yes.
No further questions.
Nothing further. Thank you.
Detective Riley, you may step down.
Thank you, Your Honor.
The time is now 3:10. You have another witness for this afternoon. do you
We
not?
do, Your Honor.
Judge, we do
Well-
have to take up a couple of matters.
Correct.
In advance.
So what the court is going to do is allow the jury to take the afternoon recess now. Well, how long do you anticipate your argument on the matter that we have to take up?
I think probably 15 minutes, Your Honor.
So we'll allow the recess now. It may be that the recess, ladies and gentlemen, will be a little more extended than usual. We hope you're not disappointed. We'll stand in our afternoon recess.
So are we going to break, or are we going to be hearing arguments outside the presence of the jury? Okay, it looks like we are going. So something on that. Oops. Oops. Okay. My computer's running rather slow here. Okay, where is that? Okay, here we go. This video is from...
Your tone influences how readers respond. With Grammarly, just highlight your text and type.
From a year ago.
Who are you?
Hi, I'm Arthur Knight, and this is my wife, Miranda Knight.
Are you Nicholas Rossi?
No.
Are you
That is
Nicholas
completely
Alaverdian?
insane. Absolutely not.
Are you Nicholas Brown?
Yes.
Police say this man has lived his life under at least 16 different names. They believe he fled from America to the UK to avoid rape charges in Utah. Then, in 2020, they were told he was dead. Just under a year ago, police believed they had found the fugitive in Scotland.
Pulled it over on a lot of people, but he got fooled.
Did the family believe Nicholas had died?
No, he's not dead. He loves life too much.
People who knew Nicholas Rossi, Nicholas Alaverdian, claim that it's you.
DNA doesn't lie.
I know my husband does not have tendencies as a rapist.
He's a con artist is what he is. I call him a jellyfish. Because a jellyfish, you can't pick it up. There's no spine to it, but it has long tentacles and it can sting you.
Is he capable of doing it? Anybody's capable of doing anything if they want to.
I'd be very happy though just to see him remain behind bars.
These are very serious charges that this man faces. They claim this man faked his own death to evade those charges. Did you fake your own death?
Sarah, we're sitting having a conversation. I've never been dead to anyone.
It's a story that began with an arrest in a Glasgow hospital, and it continues to attract international headlines. Rhode Island is more than 3,000 miles away from where the individual at the centre of this case was arrested. It's here many believe they've always known the true identity of the man behind the mask. This is Cranston, a small town near the capital of Rhode Island, where Nicholas Alaverdian spent most of his childhood. He lived with his mother and stepfather, David Rossi. The singer, who was an Engelbert Humperdinck impersonator, adopted him when he was 8.
There's Nicholas.
Nicholas took his stepfather's surname, but the pair's relationship was nothing short of turbulent and at times violent.
As a child, from day one, when I adopted him and his brother and sister, they weren't no bargains either. He was trouble. Hit his mother, hit his grandmothers, steal from the other two, trouble going to school, want to run everything, always want to be in control. He just wanted everything his way. He was the devil's spawn. I took a lot on. 3 kids, her. I took on what no man would, I believe. But I did it. I loved them. I loved her.
When Nicholas was around 13, he was moved into foster care, run by the Department of Children, Youth and Families. He lived at various group homes where troubled teenagers are placed under one roof. It was at this time Nicholas got his first job at Rhode Island State House. He worked with politicians, helping them with paperwork and other administrative duties. The most common word used by those who knew Nicholas Alaverdian during his time here at the State House was persistent. They say he was a man who refused to take no for an answer. Hi, Brian.
Why?
Nice to finally meet you.
Pleasure.
Former State Representative Brian Coogan took Nicholas under his wing. He initially thought the teenager was a genuine hard worker who had an unusually keen interest in the law for someone so young.
He kept asking me to adopt him because he didn't have any family and he was in a group home and a foster home and he was going to live on this very street, a couple houses down.
Why didn't you adopt him?
He called me up one day. He said, Rep, you got to come down to court. You got to come down to court. They're trying to get rid of me. So I get down to the courthouse, and as soon as I walk up, he grabs me, hugs me, and embraces me like I was the only thing he had in this world. I said, Nick, whoa, what's going on? He says, they're trying to get rid of me. You got to help me. And I went in with the judge, and he said to me, he goes, see this file right here? He had a file on Nick. So all the times that he was telling you and the other reps up the state house that he was being abused, cuts and bruises, those were all self-inflicted. He goes, I can't let you adopt him.
Brian decided not to adopt Nicholas, even though the teenager claimed everything the judge said was a lie. Nicholas stayed in foster care and lived in Florida until he was 18. When he returned to Rhode Island, he took his claims of abuse to the next level.
This is where Nicholas Alaverdian returns in his 20s to walk the halls of power in the tent to gain support for his campaign to improve the children's welfare system.
And I was subjected to torture, beatings, assault in various forms. I was refused to contact anybody at all.
It was at this time he met Representative Ray Hull. Together they worked on legislation to improve the lives of children in care.
Was Nicholas Alaverdian one of those kids who fell through the cracks?
Yes, absolutely. Or why would he be advocating so much to make the change if he wasn't one of them that fell through the cracks? He was a young individual with some tenacity that wanted to change the world, and you could really latch onto him. I'm thinking, wow, here is a young fella coming to us, our committee, and explaining why he needs changes in DCYF. He knows it because he lives it.
Around the same time, Nicholas was openly advocating against abuse. He had sexually assaulted a young woman in Ohio in 2008.
So we met at the campus cafeteria. He said, do you mind if I walk you to your class? So when me and him were walking into the basement, he starts attacking me, trying to kiss me rough against my face. He had his hands up my shirt, down my pants. And at that point, I ran up to my class and I was like, this is, I think, just the safest place for me to go right now. And then I come out and he's waiting for me. And I'm so sorry. I got caught up. I'm so sorry. I couldn't resist. You were just so pretty, and just giving me the whole line. And then I go and I report what happened to the police.
This happened in January 2008, and he was then sentenced in May of that year.
He gets sentenced. The judge does find him guilty in my case. He had to register as a sex offender every year for 15 years. And that part was hard for me because I was like, well, what if I'm ruining his life? But at the same time, I was like, if someone could have spoke up and prevented what happened to me, would I have wanted them to? I was like, let's end the cycle here. Let's get it documented, because I don't know why, but it felt very orchestrated and rehearsed.
Nicholas was initially wanted by US authorities over one charge of rape in Utah, dating back to 2008. He has now been served with 2 more extradition requests from his state, one relating to the rape of a woman in Salt Lake City and another for a sexual assault in the city of Orem. Investigations have also been carried out into various counts of fraud. He has been married several times. One in Ohio lasted just 7 months. Brian claims Nicholas's second wife never knew about her husband's criminal record, and she told him she was abused from day one.
He called me up one day and he says, Rep, I want to take you to dinner. I got married. I said, again? Because he was supposed to be married like 3 or 4 times. He said, I want you to meet my wife, Catherine. We met at a restaurant in downtown Providence, a fancy restaurant called Fleming's. And talking to his wife, very lovely girl, pure as snow, salt of the earth, very religious. So we parted ways, and then they went back to Dayton, Ohio. She called me up a couple of weeks after that, and she was horrified into the phone. Nick was locking her in the bathroom. He stole her identity. He got credit cards in her name. And she was just on the horrors. I said, Catherine, you call the police? She goes, I call the police. I'm going to get away from him.
What was your reaction when you got that phone call?
I was horrified. I couldn't believe it. I started Googling Nick's name, and I used all his aliases. I found he's a registered sex offender. He's suing people. People are suing him. He's got all sorts of court cases going on. Nick's a weird kid. I said I would help him out with some money. I need to get an apartment. And Nick had called me. He goes, oh, can you help me out? Can you help me out? And I said, yeah, Nick, I'll help you out. And I just decided not to. Why should I? I've given him money before. I loaned him money. Never paid me back. He says, you said you would. I said, no, I didn't. So we went right to his phone. He went to my folder. He went to the date and he played it back for me. How crazy is that? So I said, Nick, what is that? He goes, I record every phone conversation and I file them. I put them in a file. It's a dangerous kid.
Responding to emails takes time, but not with Grammarly. In a few clicks, Grammarly's generative AI drafts professional, relevant.
It's believed around 2017, Nicholas left the United States and travelled to Europe. Ray hadn't spoken to Nick in some time and then received a phone call from him to say he was unwell. At this stage, the state representative said he had no idea that the man he was speaking to was a registered sex offender facing further allegations.
I get a phone call once or twice. I'm in Russia now. I have a sickness. And he's going to be treated. And so that goes on. And then I get another call, I'm dying. I said, Joel, you can beat this. You'll be fine. His voice was scratchy. It's all coming back to me now. He was labored. I felt kind of sorry for the guy, you know, and I encouraged him. I said, I'll pray for you. This is not the end. There were many other people who come through this, and keep your chin up, you know, you'll be fine.
Police agencies were tracking Nicholas and had asked those closest to him to try and flush him out.
Next thing you know, I have the U.S. Marshals coming to my house. I had the FBI from Ohio call me. I had the FBI from Providence, Rhode Island call me. And they're all looking for him.
Was Nicholas Alaverdian still alive?
Yes, he was still alive. And he was calling me every now and then. And when he called me, I said, Nick, you got everybody looking for you. You got serious charges. He was calm and cool on the phone, talk like a lawyer. Oh, it's all a big misunderstanding. And you almost want to believe him.
Where was he? Where did he say he was?
I asked him where he was at. He says, I'm in another country. I'm nowhere around. They're never going to find me. He says, I'm married with 2 kids now. I said, married with 2 kids? I said, what'd you do? Add water? Was it like oatmeal? The very last time I talked to him, he called me and goes, Rep. I said, Nick, what's the matter with your voice? I'm dying. I'm in a hospital bed. I'm dying. I said, what's wrong with you? He goes, I got 2 weeks to live. I said, what's wrong with you? He says, I have lymphoma. I have cancer. I have this. I said, really? I said, listen, you cockroach. I said, cockroaches don't die. I said, you're not dying. I said, you're a sexual predator and you're trying to escape and you're faking your death. You are not dying. He goes, stop talking to me like that. I want to have peace with you. I'm on my deathbed. I said, and I was swearing at it. I was like foaming at the mouth. I said, you're a liar. I said, you're in a lot of trouble. They're going to get you. You can't hide from the law. I said, you know the old saying, the long arm of the law, they're going to get you, Nick.
Live and local news and information on WPRO, Providence, a Cumulus station. Sad news to pass along. The voice you've heard on the air here on WPRO. Nicholas Alaverdian, he's passed away from a long battle with cancer, leaving his wife and 2 children. Nicholas Alaverdian was 32.
His passing is a very, very sad incident for us, and may you rest in peace, Nicholas.
Next thing I hear a call from his wife, which I didn't know he was married. She's asking me to present the official proclamation of the passing of Nicholas Alaverdian as a memorial from the State House official.
Which you did?
Of course.
How do you feel about that now?
Well, from what I know now to what I knew then, I feel kind of, disappointed, but I would still do it again for the person that I knew who died or passed away. I would still do it, not thinking that he might have set this up himself.
Attempts were made to hold a memorial service at 2 separate churches. The priest here was told to cancel the mass by police. Officers believe that Nicholas Alaverdian may have been vain enough to attempt to attend the service himself to hear the tributes being paid.
What did you think when you saw that obituary?
I was furious. I said, this kid is a con artist, is what he is.
The obituary did raise a few eyebrows in Rhode Island, and suspicion quickly spread. I visited the pub where Nick gains a reputation for his gift of the gab and drinking ability. The achievement of downing 300 pints is celebrated on the walls of the Wickeden. They had a nickname for him here.
That's right. They called him 3 questions, Nick. Because Nick would just pepper them with questions. And then they had a house rule that he was only allowed 3 questions or they would cut him off. So he's known as 3 questions, Nick.
Nicholas Alaverdian, according to everyone, died.
Yes.
Did you believe that Nick
No,
died?
especially the crew here, they smelled a rat almost immediately.
Didn't I tell you when the obituary came out? Wasn't I the first to say
Yes,
it?
you were.
What did you say?
Nick's not dead. Nick wrote his own obituary.
I was more credulous because I was contacted by his family to speak at his memorial, and his supposed wife called me from Europe. The last time I spoke to Nick, he said he was living in Western Ireland. So I said to this woman, well, how are you doing in Western Ireland? She said, what are you talking about? I live in Geneva. I went, oh, that's interesting. But she said, Nick wanted you at his service because he loved what you wrote about him. And I thought, what did I write about? I've never written anything about it. And so she read me this very quote, fulsome praise for him. And I said, I didn't write that. She said, oh, well, no, Nick cherished it.
Do you doubt it all, everything, or do you think?
I doubt everything. I have no idea. I don't know him. I thought I knew, but I don't, and I certainly doubt every aspect of his biography.
Over in the UK, a man calling himself Nicholas Brown married a woman called Miranda Knight on February 22nd, 2020, a week before the date of death stated on Nicholas Alaverdian's obituary. This man began working for a Canadian woman who's expanding her business across the pond, but things quickly turned sour. She now believes the person she employed was Nicholas Alaverdian.
I knew him as Nicholas Brown. In January 2020 is when we started. And by the end of the month, I was not very happy. He seemed passionate. He seemed like he was determined. But then one day I just had enough and I texted him because I didn't want to tell him verbally on the phone because he was very aggressive sometimes. And then that's when he started to show me his smear campaign that he prepared. I lost a lot of money, not just the 40 grand, but hundreds of thousands because I had to do damage control. I don't think I'm going to ever see that money. Like I spoke to criminal lawyers over here and they're like, don't even bother. He cons somebody and uses that money to con the next person. I'd be very happy though, just to see him remain behind bars.
Reports have emerged of claims of fraud, in
I
particular
have
a
nothing
newspaper
to
report
do
from a
with
Canadian
fraud.
businesswoman.
Yes, a Canadian. I worked with that Canadian businesswoman, and I would love to show you how I worked for her day and night, irrespective of time zone, and even enlisted my wife to help me work with her because she was so demanding.
Grammarly now uses AI to help you write, not just revise. Type a prompt and
Your Honor, there's actually two matters that we're asking the court to take up at this time. You'll recall late on Friday, the state inquired about the court hearing the defendant's motion for a Porter hearing with respect to STR Mix, which is a deconvolution software that the state laboratory uses when interpreting DNA results. We did file a written objection on Friday, which I did email to the court, and we're asking that that be heard now, or at least at some point today, because we were intending on introducing DNA evidence as early as tomorrow, depending on scheduling, of course. And then there's a motion that deals specifically with the next witness, which was filed by the defense last week, which was specifically to exclude any and all evidence of so-called marital discord between Mr. Fotis Dulos and Ms. Jennifer Dulos, along with hearsay. So that is going to be coming up during the next witness, and so I certainly didn't want to run through the stop sign of the motion in limine.
Thank you. So the court will take up first as we would have to call it, what the code calls it, prior bad act.
If I could just have a moment, Your Honor. I apologize, Your Honor. I'm just looking for, I had written out. Well, I'll probably be able to do it from memory in any event, Your Honor. So I'll just note, Your Honor, just a couple of things with respect to the so-called prior bad acts. Firstly, this is a defense objection, but we are going to be making the offer. So I just want to alert the court as to what we intend on offering through this next witness. And they've also moved to exclude alleged hearsay statements from Jennifer Farber Dulos as well. And I'd like to take those up at the appropriate time additionally, Your Honor. But essentially, Your Honor, the defense in this case, as I understand it, from some of the cross-examination which we have heard so far, specifically with respect to presumptive blood tests, as I understand the defense, they are not conceding that there was actually blood in the garage. They're not conceding that Jennifer Dulos is deceased, and they're not conceding that Fotis Dulos is responsible for her murder. Now, I could stand mistaken on that, but I don't think that we're going to be hearing those concessions this afternoon from the defense. So I bring this up, Your Honor, because obviously, in light of the fact that none of those things are conceded at this point, the court needs to decide whether or not animus between Fotis Dulos and Jennifer Dulos is relevant to this case. And I did file a written objection this morning, Your Honor. But I would pose to the court this hypothetical as the court considers this motion. I want the court to consider if the defense had moved to exclude any and all mention of the fact that Fotis Dulos and Jennifer Dulos were married. Let's just say they had moved to exclude that, and the court granted their motion. The jury would naturally be sitting here wondering why Fotis Dulos would have murdered a random woman in Ukraine. It is the story of their marriage and the story of their discord and the story of their divorce that served as the motivation that culminated in the death and murder of Farber Dulos. That is our theory of the case. And Ms. Lauren Almeida is going to be testifying on behalf of the state in just a moment. And what the evidence is going to reveal, Your Honor, is that she was the nanny for the Dulos family from 2012 until 2019. And she was present for a series of events, including the breakup of Fotis Dulos and Jennifer Dulos in the spring and summertime of 2017. And she's going to be detailing very specific events for the court. Specifically, she's going to be detailing how, upon the decision to separate, Mr. Dulos chased Jennifer Dulos around with a piece of paper. That at one point they were in some type of screaming match, and he chased Jennifer Dulos upstairs and burst into the room. That she looked terrified when he was chasing after her. She's going to testify about the antagonistic behavior he showed towards her during those months leading up to her finally leaving the home. Specifically, Your Honor, that he had threatened to take the children to Greece. She's going to talk about an event in which he allowed the 11-year-old children and the 8-year-old children to drive his Porsche around a very dangerous area, thus upsetting Jennifer. That these things were occurring and seemed to be designed to antagonize Jennifer during the months after they had apparently decided to separate, but were still living together. She's going to detail for the court how he reacted when Jennifer surreptitiously left the home with the children in June of 2017. That he acted erratically towards her in court, her being Lauren Almeida, that he accused her of kidnapping her kids because she went with Jennifer with the children to New York. She's going to discuss the fact that Fotis Dulos yelled at her when she dropped the kids off and said that she needed to be the voice of reason with his wife, Jennifer Dulos. All of these things, Your Honor, are probative to Mr. Dulos's animus towards Jennifer Dulos and serve as the motivation for why he would commit this crime. Because the evidence is going to show that despite the fact that it had been nearly 2 years from Jennifer Dulos leaving the home until her alleged murder, that they still weren't divorced, that they were in the midst of ongoing marital discord. And the defendant, Your Honor, actually spoke about that marital discord during her interviews with the police. She indicated that, I don't know the exact phrase, but I believe it was 2 years of hell or 2 years of torture when she was speaking about Mr. Dulos's divorce proceedings with his then wife, Jennifer Dulos. She joked about how she wished Jennifer would just disappear. So this also serves as the motive for why the defendant would conspire with Mr. Dulos to kill Jennifer Dulos. And as the defense has repeatedly said during voir dire, the state has to prove beyond reasonable doubt that Fotis Dulos murdered Jennifer Dulos. They have repeatedly said that. So the fact that Fotis Dulos would have been motivated to harm Jennifer Dulos and all of the discord leading up and explaining that motivation is highly probative to Mr. Dulos's intent, his motivation, whether or not he would have conspired with the defendant, his live-in girlfriend. It also goes directly to an element of the case the state has to prove. And so, you know, if we look at some of the jurisprudence in the state, and I think I directed the court to State versus Lopez, 280 Con 795, just as an example, anytime there has been sort of hostile acts towards the same victim, Courts have routinely held that that is probative of the actor's intent and motivation. So unless the defense is conceding that Mr. Dulos committed this crime, that Jennifer Dulos is deceased, the probative value of this was extremely high before their cross-examinations. It's astronomically high now. And so I am asking that the court allow Ms. Almeida to testify about those events. There was an additional event which I neglected to mention, which was shortly, I don't want to say shortly, but after Jennifer Dulos had left the home, there was an event in which Mr. Dulos almost hit her with the car. And Ms. Almeida returned to the home shortly after, and Jennifer Dulos explained that situation to her. And she was extremely shaken up. And all of these things, Judge, we believe are probative again to the animus that he would have harbored towards her. With respect to, and if I can just have one moment, Judge?
Yeah.
With respect to the alleged hearsay statements, I would just indicate the following to the court. Number one, the statements that we're going to be offering that Jennifer made to Ms. Almeida are not being offered for their truth or meet a well-recognized hearsay exception. And I just want to give you some examples. Farber's then existing belief that Dulos was having an affair, in part because he had been more distant. We're not going to be offering that to show that Mr. Dulos was actually more distant in marriage. We're going to be offering it to show that Jennifer Dulos believed that their marriage was in turmoil and believed he was having an affair. Her then existing belief that she had found proof of the affair. Her future intention to confront Dulos about the affair. Her then existing fear of Dulos. Her then existing emotional state that she was not independently corroborated. Lauren Almeida actually witnessed an event where he threatened to take the children to Greece. Her intention to divorce Dulos. Her then existing hope that the divorce proceedings would go smoothly. Her intention to leave the defendant, including her future plan to surreptitiously leave the house, and her fear that Dulos would find out. Her request that Lauren Almeida continue to work with her after she had left Dulos. And her intention on May 24th, 2019. All of those things, Your Honor, just by way of example, are then existing state of mind, statements of an intention to do something in the immediate future, and therefore qualify as a state of mind exception under 8.3 subsection 4 of the Connecticut Code of Evidence. So they're not testimonial. There's no suggestion that these statements were made in anticipation of any criminal proceeding. They're made to the nanny, and that's what she's going to be testifying to, Judge. So all of these things, again, meet well-recognized hearsay exceptions. I would direct the court. There's a more recent case, State versus Ayala, but I also directed the court in our memorandum to State versus NIMS. Victim statements as to others as to why he was traveling to Connecticut, specifically that he was concerned with how the defendant was handling his sister's affairs, was not offered for the truth, but rather to explain why the victim went to Connecticut. State versus Smith, victim statements to others, with respect to the statements about the event with the car, Your Honor, we're offering those as spontaneous utterances. And I would just indicate that State versus Smith, which is 275 Con at 217, quote, "It is well established in our jurisprudence that where a marital or romantic relationship existed between a homicide victim and the defendant, evidence of the victim's fear of the defendant suggests a deterioration of that relationship, which is relevant to the issues of motive and intent." Now, what I'm gathering from the defense, even though they're apparently not conceding that Mr. Dulos is even responsible for this crime or that a crime occurred at all, is that there's somehow spillover prejudice to the defendant. But again, this is highly probative evidence as to why Mr. Dulos would commit this crime. We're going to flush out later on in the trial why it was also probative to why the defendant would conspire with Mr. Dulos. So we're asking that the court allow this evidence. We think it's very probative.
Thank you. Attorney Schoenhorn.
I guess we have to separate the fact two issues here. The first is that it sounds to me that if Fotis Dulos was on trial for this, the state would be seeking to offer this kind of evidence, and most of it would be explicitly prohibited against Mr. Dulos because of its prejudicial effect and its remoteness. This court, early on, before we started evidence, I attempted to get certain documents from the divorce file because it sounds to me that the state wants to litigate a dissolution action that never reached its conclusion. The court, in the most recent court proceedings involving the Dulos versus Dulos matter, prohibited the defense from having access to those documents. I want to preface my remarks with that because what I'm hearing now is the state wants to litigate matters from 2016 and 2017, years before the disappearance of Jennifer Dulos and the allegations that are set forth in the complaint. So first, there are a number of issues that apply here. The first is that most of what I just heard is not relevant because it has nothing to do with Michelle Troconis. It also would not be relevant as a motive against Fotis Dulos because of the fact that it occurred before the divorce. It's also relevant for your court's determination. There's no violence involved here. Every one of the cases that the state has cited involve prior acts of actual physical violence. What we have here are arguments about whether the children should go water skiing, whether they were loud, whether whether Mr. Dulos wanted his wife to sign a custody agreement, which is what the claim chasing her around, quote unquote, with a piece of paper is all about. To sign an agreement as to when the children would go, in other words, without litigating it, to agree to those terms. This might be true of any dissolution action, not only in Connecticut, but probably in the entire United States of America. So the problem we also have, which is unique to this case, is that all of these incidents were part of an attempt by Jennifer Dulos to obtain a restraining order. I want to emphasize, because the court may not be aware, Judge Collin had a multi-day hearing where all of these claims were litigated, and he found it not credible. That is, he denied the restraining order. So we have, at the level of a preponderance of the evidence, a coordinate judge of this court finding that the evidence did not meet the minimum requirements for a restraining order, and he denied Jennifer Dulos' motion for a restraining order. Again, it is testimonial in another coordinate proceeding. It was done for purposes of that. It was denied in that court. So how is the court here going to allow the same evidence in here without bringing in the actual findings, rulings by the judge in the divorce case? And then, of course, this all goes back to 2016 and 2017. The fact that there was that kind of discord is not the kind of violence that would permit the court to allow that to be presented, especially in a case of this nature. The police were not involved at that point. There's no contemporaneous documentation. Again, this was something that was prepared in affidavits for purposes of court. Ms. Almeida testified in support of the motion for restraining order. I think it's important also to realize that to the extent that there has to be reference to the fact that there was an ongoing dissolution matter, perhaps it's also relevant that Ms. Almeida was part of the plan by Ms. Dulos to simply disappear from the house and leave without notice and to ignore the police inquiry, which is what happened back then.
if the court looks at some of the cases, for example, State versus Espinal is a good example of that, where we talk about whether or not claims, there are a couple of, I have to separate this out because on the one hand, you've got a couple of incidents where Miss Almeida witnessed arguments between Fotis Dulos and his wife. Physical touching whatsoever, it was following and yelling. That was the nature of it. Then we have a hearsay statement that Jennifer told the babysitter that Fotis drove into the driveway recklessly, apparently telling her that he was allowing the children to drive one of his cars, to drive the Porsche. These were issues that she found to be unreasonable. It may have been part of the reason that she wanted to leave. And yes, there may be evidence that she, quote, found out that Mr. Dulos was having an affair. But again, that is a far cry from suggesting it is relevant to a claimed motive 2.5 years later, at least over 2 years later, to do away with his wife, particularly, Your Honor, and this is why Your Honor's past ruling plays a role here. Everyone who was involved that was involved with Mr. Dulos, his lawyers, the guardian ad litem, other people that were aware of it, knew that the report by the independent evaluator, the custodial evaluator, the psychologist, had recommended that Mr. Dulos was the better parent, that he was a better, more caring parent than Jennifer, and that therefore he was recommending joint equal custody, noting that Jennifer Dulos was opposed to that, and that Jennifer Dulos was refusing to turn over her psychiatric records so he could evaluate more in more detail whether or not she needed some additional counseling and whatnot to help facilitate the transition to joint custody. I submit, Your Honor, that opening up that can of worms is going to permit all of that, including the evidence that Dr. Herman testified, which is why I was trying to get those transcripts, which the court denied my right to have them, even though I submit under Davis versus Alaska now would be relevant to the issue of right to cross-examine anyone who's going to be testifying about hearsay about the discord and the divorce. Why is that also important? As Your Honor may recall, if any hearsay is allowed in, under our rules, it allows the opposing party to bring in any other hearsay as if the speaker was actually on the stand. And all of that would suddenly become relevant. It could actually delay this trial by having a week of testimony about who was the better parent, who was, quote, winning, unquote, in the divorce proceeding, which I assume that's not what we're here for. In State versus a couple of cases I just want to bring to Your Honor's attention, for example, there was some evidence about the marriage being discord, but in that case, there was actual violence, and it was relevant because it showed the current state of fear of the spouse when she disappeared. This is something, again, that goes back years, and there is no evidence, none of recent discord. In fact, Your Honor will hear at this trial that there was a party 2 days before. I don't know if Your Honor is even aware that this occurred, but there was a party at the house where Mr. Dulos was present, evaluator was present as well, and they were at that time. So that's going to come in no matter what. That comes in. But to suggest that the babysitter or not, he at one point while they were still married, threatened to take the children to Greece. That has nothing to do with what's going on at the time, where it concluded in an 80-page report, which I'll note I have, that says that Mr. Dulos would be the better parent for these children, but he was recommending equal sharing of custody in this case. There is also the case was only application of itself. None of the affidavit, none of the specifics of it, and the court was required to give a very, very, but as I hear what
Oops, we seem to have okay. The browser. Okay, let me get this back here. Oh, come on. Got the wrong tab. Okay, here we go.
contemplation that had happened suddenly that was spontaneous in that sense. And I note that the Reynolds case, it was 2 months, 1 to 2 months after the prior incident, so it's still considered relevant. This is years later, and it did not involve any violence. Finally, and I should mention this, there was a suggestion in one of the documents, and I think by Miss Almeida, that Jennifer told her that Mr. Dulos at one point had purchased a firearm. Now, when the restraining order was filed, it was turned into the Farmington police. It was never, to anyone's knowledge, ever recovered. It was never returned to Mr. Dulos at any time. But I assume, since the state didn't mention that, it has no intention of trying to elicit that, because there are several cases. The one that comes to mind is State versus Gerolamo from the mid-'80s, I think, said that any mention of a firearm when there's no evidence of firearms in the case is one of the most prejudicial things that could happen in front of a jury. And I note that, especially in this day and age, where there's all these mass shootings and all these on almost a daily basis, that would be so prejudicial for that to be blurted out that there'd be no way, short of a mistrial, that could be remediated at that point. Finally, there's no such thing as transfer motive. So even if this arguably, to a minimal extent, and with a very truncated offer of proof, was admissible against Mr. Dulos, there's transferred intent is if I throw a rock and I'm trying to hit victim A and it misses and hits victim B, there's a transferred intent in the actor to the second victim. It's not reciprocal, however. It doesn't go to another person who's standing to the side. It's just not relevant. And it certainly can't be used because it would even predate the allegation of a conspiracy or anything of that nature, and therefore there's no way to attribute that knowledge and those specific incidents to Ms. Troconis under any circumstances anyway. The fact that the divorce kept going is one thing. The fact that she said in her statement to the police that it was like, I think the term is 2 years of hell, doesn't mean that the specific acts of misconduct, of alleged acts against Mr. Dulos then can be applied to Ms. Troconis. I'll just mention very briefly, there's been some suggestion that it goes to state of mind. Whatever the state of mind is of Jennifer Dulos is not covered in this case under either 8-3 subsection 2 or 8-3 subsection 4. Telling her that I'm going to be taking a certain vehicle to New York, for example, although not particularly prejudicial, is, I'm only raising it because that's not the kind of state of mind that would be relevant to the examination. The fact that she was going to New York might be and then didn't show up. That is relevant, but to suggest that one person said, I'm going to be taking one vehicle when you have a choice of two is not the kind of evidence that goes to the state of mind. It's just not relevant or material in this case. Let me just see if I've make sure I covered everything. There's one last point that what I see is happening here is the state whole theory so far seems to be that they're going to tar Ms. Troconis with what happened that may or may not have involved Mr. Dulos directly. If he was on trial, maybe some of this with a cautionary instruction might be admissible, but it's not only so remote as to Mr. Dulos. When you try and drag my client into this, we've now gone so far off the playing field. We're out of the stadium. We're not even in the parking lot. We're down the street by the highway exit. And that is what we seem to be doing here. None of this evidence applies to Ms. Troconis. And therefore, it is so highly prejudicial. The state has been allowed a lot of leeway. I would suggest more than I believe. I'm not shy about objecting to the court project's notice, but in any event, that I believe has already gone so far down, given the state leeway to put on evidence that will later not be connected. And so for them to be able to put on such evidence, leave that speculation out there only later on to show it has nothing to do with Ms. Troconis. And some of it, in fact, has nothing to do with Mr. Dulos either, but I'm not objecting on that basis. But here we have a witness who can testify to certain things that occurred on that week. We're not objecting to any of the stuff that happened during the month of May of 2019, including the fact there were some court proceedings going on. But what happened at them, what the rulings were, what motions were being filed, any of that is both testimonial and therefore it violates the Confrontation Clause of the state and federal constitutions, as well as inadmissible hearsay. Based on that, Your Honor, I didn't hear the state separating out its claim. He just made all these things as if he's going to get into all of them. Some of them I might not object to, since he didn't say 1, 2, 3, or 4. He just said this is all what we're going to bring in. I'm not going to suggest which ones he might be able to get into that would object.
Attorney McGinnis.
Yes, Judge. And I'm mindful of the fact that we have a jury waiting. I just want to respond to this. Firstly, I'm not going to get into who has a better theory of the case at this point, because as near as I can tell, the defense's theory is that Jennifer Dulos, short before disappearing, ran over a squirrel in her garage that was eating a cheeseburger. Okay, so the issue.
I'm going to object to such pejorative, sarcastic remarks.
Well, before we proceed, there's no jury in the courtroom. The court can understand the cut and thrust of argument. The court is not going to rule on an objection that is not evidentiary. The court can understand that against some comments, counsel, either for the defense or for the state, may take offense. But unless those comments become unprofessional, the court is going to allow both parties to ride the wave of zeal.
So Judge, just responding to some of the specific things with respect to this issue of remoteness, we're talking about an ongoing discord over the course of 2 years leading up to Jennifer Dulos' death, and even by the defense's own argument at this point, shortly, apparently, before Jennifer Dulos disappeared and we believe was murdered, there was some report which she was opposed to, thus indicating further animus and discord between the parties. I would also just note, Your Honor, that in terms of the balancing that the court has to do, I think the defense sort of made our argument for us, which was that none of these acts involve a particularly violent act on behalf of Mr. Dulos. So in terms of whether or not this is going to somehow inflame the passions of the jury, I don't think that the court needs to worry about that, because the acts themselves are substantially less probative than the allegation that he murdered Ms. Dulos. I did not mention a gun. I did not mention a restraining order in my argument. I tried to keep my offer of proof to what I intend on showing through this witness, and we spent an inordinate amount of time talking about things that weren't part of our offer of proof. I'll also just indicate, Your Honor, that when the defense said that if hearsay is admitted, any other hearsay from that person can be admissible. I'm not familiar with a case that stands for that proposition. I'm obviously familiar with the rule of completeness, but any other hearsay, I'd love to see that case. So I don't think the court has to worry about there somehow being an undue consumption of time. And just because the defense attorney says that something's testimonial doesn't make it so. They have not cited a single case that any of the statements which they've been on notice of that Lauren Almeida is going to testify to, that Ms. Farber Dulos made to her, are somehow testimonial in nature. So I would ask the court allow us to have the witness testify to the specific acts that we've talked about, and just ask the court to deny their objection.
Thank you. Well, the court is going to scan a few items using a grocery store analogy. First, counsel spent in almost every case of every juror about at least 1 hour to determine which jurors would be appropriate jurors for this case. One of the salient questions to the jury concerned the ability to pay attention. And that was with regard to the anticipated number of hours of video evidence. Well, the court is going to credit the jury with being able to pay attention beyond many hours of video evidence. So the fact that some evidence may hang for a while before being picked up is not a reason for this court to believe that this jury cannot tie up evidence when it is time for them to deliberate. Secondly, there is a discussion between testimonial and non-testimonial hearsay. So the court has to hearken to Crawford v. Washington. If the testimony is if the evidence is non-testimonial, then the rules of evidence would apply. If the evidence is testimonial, then that evidence cannot run afoul of the defense's right under the Sixth Amendment. But we leave that discussion there. It was indicated by, not indicated, was stated by the defense that this court would have to relitigate the family matter, the dissolution matter. This court in no way litigates the dissolution matter. The dissolution matter involves testimony and rulings concerning alimony, pendente lite and post-judgment, child support, pendente lite, custody, pendente lite, and after dissolution, visitation, health insurance costs, educational costs, exclusive use and possession of the marital home, pendente lite, and post-judgment. This court is not litigating the family matter. So that premise is without merit. Under our rules, prior bad acts may not be admissible to prove bad character, criminal tendencies, or proclivity. However, prior bad acts may be admitted for other purposes such as motive, malice, intent, identity, knowledge, absence of mistake or accident, a system of criminal activity, common scheme or plan, evidence that will help corroborate crucial prosecution testimony, or to prove an element of the offense. Nevertheless, if prior bad acts are admitted, the probative value has to outweigh the danger of unfair prejudice. So the court cannot remember the court will refer to it as the grocery list of statements from the next witness. However, the court cannot at this point determine where those groceries will go until it hears more from the witness. In this case, as the court has stated before in discussions with counsel, the hearsay exception of state of mind cannot consume every thought that the declarant had and make it available to the jury. Because then that exception becomes the rule. In this court's view, the then existing mental or emotional condition of the declarant has to be focused. In other words, it's not just a matter of what the declarant said under a certain set of circumstances. The exception goes to the mental or emotional state. For example, fear or anxiety or terror. So simply everything that Jennifer Farber Dulos may have said to the housekeeper from what the court heard from the state would not fall into that category. But the court would have to hear the testimony. So concerning the issue of prior bad acts and what may be admissible, the court at this point understands that the testimony can go to malice and motive. However, everything that is said does not go to malice and motive as expressed from what the court understood the state plans to elicit. So the court will be keen to entertain the objections if it appears, even if it does not appear, that simply everything Jennifer Farber Dulos said to her housekeeper is coming into evidence. That is not the court's understanding of the state of mind exception to the hearsay rule. So the court is going to allow testimony of marital discord. However, the fact that there is marital discord in this court's view is not exceedingly probative. It's whether or not the statements by Jennifer Farber Dulos go to motive to murder, her fear, her anxiety, her terror. Not simply whether she did not like something that Fotis Dulos was doing. So the court is going to allow testimony of marital discord, but the court will be keen to essentially use a colander to determine what is relevant and what is not. Do we need to take the Porter factors, and the discussion of Porter is going to take up too much time right now. The jury is out. However, the state's witness is probably not going to be done today. We still have a half hour. So what the court would prefer to do is take up the next witness tomorrow morning, take up the Porter arguments.
That's fine with the state judge. I'll just note that what we're probably going to do then is not ask the representative from the laboratory to come tomorrow. Depending on the court's ruling, we'd ask that she come on Thursday.
Well, the lineup for tomorrow is probably going to be Ms. Almeida, correct?
Correct.
And after Ms. Almeida.
We have Detective Tom Patton. But I don't anticipate his testimony is going to be terribly long. But Ms. Almeida may take a substantial portion of the day.
Thank you. So we'll start now with Ms. Almeida.
A quick question, Your Honor. If the court is going to allow some of the marital discord testimony, will the court give a cautionary instruction to the jury about the limited nature of that testimony, and specifically in light of the fact that it's only relevant to maybe the allegation involving Mr. Dulos, but is even one step further removed from Mr. Troconis in that regard?
Well, the court will consider limiting instructions after both the state and the defense have had the opportunity to cross-examine and examine Almeida.
Your Honor, I'll wait for the jury, then I'll call Ms. Almeida.
Counsel stipulate to the presence of all of the jurors.
Yes, Judge. Your Honor, the state calls Lauren Almeida.
Please raise your right hand. Do you solemnly swear or solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon penalty of perjury?
Yes.
Please state your name and spell it for the record.
Lauren Almeida, LAUREN ALMEIDA.
And your business address?
Well, there's no need for a business address. You may be seated. Thank you.
Good afternoon, Ms. Almeida.
Afternoon.
Ms. Almeida, how old are you?
32,
And where did you grow up?
Newington, Connecticut.
Who do you currently live with?
I live with the Dulos kids.
And did you graduate high school?
I did.
Which high school did you attend?
Newington High School.
Could you just keep your voice up just a little bit?
Newington High School.
And did you also attend college?
Yes.
Where did you go to school?
University of Connecticut.
And what did you study at the University of Connecticut?
Psychology.
Did you graduate?
Yes.
What year did you graduate?
2013.
And you mentioned that you currently live with the Dulos children.
Mm-hmm.
Did you know someone by the name of Jennifer Dulos?
Yes.
When was the last time you saw or spoke to Jennifer Dulos?
May 24, 2019.
And did you know someone by the name of Fotis Dulos?
Yes.
How did you know Jennifer and Fotis Dulos?
I nannied for them starting in September of 2012.
Were Jennifer and Fotis Dulos married?
Yes.
When you met them in September of 2012, where were they living?
4 Jefferson Crossing in Farmington.
Where was Mr. Dulos originally from?
Greece.
Did he speak English?
Yeah.
Did he speak with an accent?
Yeah.
Where was Jennifer Dulos originally from?
New York.
And you mentioned the Dulos children. How many children did the Dulos family have?
5.
And what are the children's names?
I have Petros, Theodore, Christian, Constantine, and Noel.
And could you give the jury their age ranges currently?
Yep. Currently, Petros and Theodore are 17, Christian and Constantine are 15, and Noel is 13.
And you mentioned that Petros and Theodore are 17 and Constantine and Christian are
15.
Are they twins?
Yeah.
So the Duloses had 2 sets of twins?
Yep, 2 sets.
And when you met them in September of 2012, what was their respective age range?
Noel just turned 1, I believe. Christian and Constantine were 4, just turned 4, and Petros and Theodore 6.
How did you get introduced to the Dulos family in 2012?
I worked at a daycare center for a few years, and someone that I used to also babysit outside of the daycare told me that she knew someone that needed help.
Well, question is, how did you end up working for the Dulos family? Well, this is preliminary, so overruled.
You did mention that you worked at a daycare center. Would you just continue your answer?
Yeah, so someone that worked for Jennifer and Fotis said that she knew of a family that needed extra help, and I babysat outside of the daycare, so she introduced myself and my sister.
And was your sister also a babysitter?
Yeah.
What's your sister's name?
Ashley.
When did you first actually begin babysitting for the Dulos family?
It was September of 2012. I don't know the exact date.
How often would you babysit them beginning in September of 2012?
It started off just like a Saturday or a Sunday. Like I would usually work Saturday, and my sister would usually work Sunday, or we would swap. And then over time, I started to work more and more for them.
Were you and your sister the only babysitters for the Dulos family?
No.
You mentioned that you would work a Saturday or a Sunday. What were your typical hours at that point?
It varied, but usually like early morning, like 6 a.m. sometimes, because Noah would wake up early, and I wouldn't leave until like sometimes 9 or 10.
Were you still attending school when you first began babysitting for the Dulos family?
Yeah, I was in my final year.
What types of activities would you do with the children while you were babysitting with them?
We did a lot of puzzles, magnet tiles, and games. Board games was a lot. They like to play pretend and dress up. They also water skied, so we would spend a lot of time doing that.
And would you actually go water ski with them?
Yeah.
What did Mr. Dulos do for work when you first met the family?
He owned his construction business.
What was the name of the company?
Group.
And you mentioned that it was a construction company. What type of construction?
He was building luxury homes.
Where was the office for Farber located?
It was in Fort Jefferson Crossing. It's in their home.
Whereabouts in their home?
It was like right above the garage. They had a 2-bay garage, and above that was a space for the office.
What did Jennifer do for work when you met the family?
I knew she was a writer, but I didn't really know much more than that.
Were Mr. Fotis Dulos and Jennifer Dulos ever home while you babysat?
Yeah,
How often would you say they were home when you were babysitting?
most of the time.
How would you describe the dynamic of the Dulos marriage when you met them in 2012?
I mean, I tried not to judge, but he was gone a lot, but I just figured that was just kind of what it was in their house. But overall, when I first started working for them, they seemed to get along just fine.
And how did they act towards one another?
In the beginning, they were nice towards each other. I mean, from what I saw, at least in the beginning.
I'm sorry, I missed that.
From what I saw, at least in the beginning.
And did you continue to babysit for the family for the remainder of your final year of college?
Yeah.
And for that final year of college, were you just working weekends?
Yeah, because I was going to school during the week.
I want to direct your attention now to May of 2013. Did your role with the family change at that point?
Yeah, so May 2013, I graduated college, and I didn't really have a job in place yet, and Jennifer offered me a full-time position with the kids.
And what days of the week were you, well, I guess I should ask a preliminary question, which is, did you accept the job?
Yes.
And at that point, did you become the sole babysitter or nanny for the children?
I guess I became like the main one, but there were still some people that would come in, or sometimes there would be 2 of us, mostly on the weekends, because the kids were in school, or they were like at least in preschool, so it's easier with just with one. But
And what days of the week were you working for the family at this point, now that you're full-time employed?
I think it was like Monday through Saturday, so I always worked the weekend day, but it was like half a day, so I wouldn't go in until like maybe like 11 or 12.
When you say half a day, you're referring to the weekend day?
No, the weekend day was like a full day, from morning to night. So during the week while the kids were in school, I didn't have to show up like as early as I would on the weekend.
And what was a typical work day for you as the nanny?
Well, the younger ones, just like, you know, helping feed them or helping Jennifer if they had like certain activities that day. Just playing with them, keeping them busy, playing outside, giving them baths. I would help with dinner, help with like cleaning up after them.
During this time period, did you ever go on vacation with the family?
Yes,
Where did you go on vacation with the family?
all the places.
Yes.
So I've gone to St. Bart's with them. I've been to Florida. I've been to Greece a few times. I went to Virginia once with Fotis. We went to Colorado.
Did both Jennifer and Mr. Dulos attend these vacations?
Not all of them.
All right. And when you say not all of them, who would not attend?
Jennifer.
And did Mr. Dulos ever travel without the children or Jennifer?
Yeah.
Can you describe the dynamic between Mr. Dulos and his children?
Yeah, I mean, when they were younger, they kind of just, I mean, they listened to whatever their dad said. They didn't get a lot of time with their dad, so their time was mostly on the weekend. And I was with them most of the time on the weekend, so they did whatever Fotis asked them to do. But yeah, that was like the main time that he spent with the kids.
How often would Mr. Dulos travel without the family?
A lot, where I don't know the exact days, but enough where it was, you could tell it was a little odd how often he was traveling.
Could you describe the dynamic between Jennifer and the children?
Yeah, it was very silly, her relationship with the kids. they always wanted to be next to mommy. It was just kind of what it was. And she would sing to them and laugh at them. And she never raised her voice. She was like so soft spoken and never got angry. And she was just like incredibly nurturing.
What types of activities did Jennifer like to do with the children?
Oh, she would take them to like, we'd go to like these bounce houses all the time with Jennifer for like around the holidays. Getting the Christmas tree was a really big deal, and going pumpkin picking, and she'd draw with them, do puzzles with them.
Did Jennifer like to water ski?
No.
You had mentioned that the children did like to water ski, however, correct?
They water skied.
Did they not like to water ski?
They water skied a lot. So I saw times where they didn't want to, but still had to.
And as you worked full-time for the Dulos family, did you begin to develop a friendship with Jennifer?
Yeah.
How would you describe your relationship with her?
I confided in her with a lot of things, like in my personal life. I just always trusted her. She was my boss, but she was someone that, we just connected really, really well. We just worked well with each other. I knew what she liked, what she didn't. She knew what I was good at. We had a really good relationship.
Did you ever meet any of Jennifer's family?
Yeah.
Who have you met?
Her mom, Gloria, her father, Hilly, when he was alive, her sister, Melissa. I've met her cousins.
And you'd mentioned your father. Has he passed away?
Yeah.
What year did he pass away?
I think it was February of 2018, I think.
And is Gloria still alive?
Yeah.
How old is Gloria?
No, I think she's 88 or 89, but I don't want to get that wrong. But she's great.
Did there come a point in time when Jennifer began confiding in you things about her relationship with Mr. Dulos?
Yeah.
Did Jennifer ever express to you her feelings on whether Mr. Dulos was paying enough attention to her?
Objection, Your Honor.
Sustained.
Did Jennifer ever express to you a desire to avoid arguing with Mr. Dulos?
Objection, Your Honor.
Overruled.
Yeah.
Would you tell the jury what she said?
She just felt like arguing with Fotis, like he was harsh and she didn't like conflict. So she could never really like express how she really felt because it kind of got looked over.
Now, I want to direct your attention to September of 2013.
Mm-hmm.
Did you begin working at Farber?
Yeah.
Did Mr. Dulos, by the way, did he own Farber for the entire time that you babysat and nannied for the family?
From what I knew, yeah.
How did you come to begin working for Farber?
So I was working full time for the family from May of 2013 that year. And like I said, I still didn't have like a full-time job, the nannying was. And so he just asked if I was interested in coming into Farber and, having this opportunity. So I just decided to take it.
And were you working full-time for Farber after you took the job?
No, it was like half Farber and half being a nanny.
What type of hours were you working for Farber?
So usually I'd go in at like 8:30, 9 o'clock in Farber, and then depending on the kids' schedule, I would have to leave around 1 or 2. They would basically like cross the door, and then I was with the kids until like 9-ish, 9:30.
And just to be clear, 9-ish, 9:30 at night, correct?
At night, yeah.
How many days a week were you working for Farber when you began being employed by Mr. Dulos?
5 days, so Monday through Friday.
And were you still nannying 6 days a week?
Yeah.
Did you have any regular days off?
Yeah, usually at that point I was having Sundays off. But if I needed like another day off, it wasn't like with Jennifer, it was kind of easy to do that. But usually Sundays were my day off at that time.
What were your responsibilities with Farber?
In the beginning, it was really just like office work. I was like organizing folders, things like that. I would really like worked alongside Fotis, so I basically would follow him along to work sites, and he would show show me some things because I was totally new to this whole world. And then eventually, in time, I became in charge of the punch list at Foregroup, which was when a house was built, the owners would have a list of things that they wanted to finish off, like there's a chip here or whatever, and I would be in charge of making sure that that gets done.
How did you view Mr. Dulos when you initially began working for Farber?
Oh, I saw him as like a role model and a mentor, and I thought at the time he's given me this really great opportunity. So I considered him a friend.
And did Mr. Dulos encourage you to go back to school?
He did, yeah.
What did he encourage you to study?
Construction management, but he also was pushing for me to get my real estate license.
Was there a telephone number that was associated with Farber?
Yeah, it was Fotis's personal phone number.
When you say his personal phone number, are we talking about a landline or a cellular phone?
No, like a cellular.
And did you often see Mr. Dulos answering work-related calls or sending emails?
Yeah.
Would it be fair to say that Mr. Dulos kept his cell phone with him at all times during your time working for Farber?
Yeah.
When you were working for Farber, did Jennifer ever express to you what her intentions were with the children? Excuse me, strike that. When you were working for Farber, did Jennifer ever express to you how she wanted you to handle the summers?
Yeah.
What did she say?
Kind of said that.
Well, did Jennifer ever express to you how she wanted you to handle the children during the summers? Well, the question is, did she express to you how she wanted you to handle the children? Overruled.
You can answer.
Okay. Yeah, I would because the kids wouldn't be in school, so I would be with the kids full time.
And how many employees did Farber have when you began working for them?
Not a lot. It was very small, so like a handful.
When you say handful, can you just be a little bit more specific for the members?
Yes, I would. I guess we would have to count. I would say like 5 or 6, maybe.
Was Pavel Gumiani one of the employees?
Yep.
What was his role with, actually, before I ask that, when did he begin working for Farber, to your knowledge?
Oh, to my knowledge, I don't know. He was there when I started, even just babysitting before I ever even worked for Farber, but I don't know when he started. But
okay.
And he knew the family for a while. That's all I knew.
So by the time you began working for Farber, he was already working for the Farber, is that correct?
Yes.
And what was his role with the company?
He was a project manager. He kind of did everything, to be honest.
Did Jennifer know Mr. Gumiani as well?
Yep.
Would he assist her around the house?
Yeah.
How would he assist her around the house?
He would change out the light bulbs when they went out. He would build, I know he built they had this very beautiful playscape in the backyard. I know he built that. He would even sometimes help pick us up from the airport after a trip.
Did Jennifer ever work for Farber?
Not that I know.
And you had mentioned that Mr. Dulos was a role model to you during this time.
Mm-hmm.
Why did you consider him to be a role model?
When I first started working, he was just incredibly nice. He made me feel comfortable. He was funny. He, was fresh out of college. I didn't know what I wanted to do. And it sounded like I was getting this really great opportunity, even though it had nothing to do with any of the work I've ever done. And it seemed like he just wanted to push me and, make me better.
And did there come a point in time when the dynamic between Jennifer and Mr. Dulos began to change from when you first met them?
Yeah.
Could you describe how the dynamic changed for the jury?
The big dynamic change was March of 2017, which is when Jennifer found out about his affair. And a few months after that, it totally changed.
So I want to direct your attention now to March of 2017. Did you take a trip with the Dulos family?
Yeah.
And where did y'all go?
The kids had a 2-week break, and so the first week we spent in Aspen, Colorado, and then we flew to Miami for the second week.
Who went on the trip?
The first week was myself, 5 kids, Jennifer Fotis, and his friend Mark Masiello.
And I think you already mentioned this, but why did the family decide to take a trip in March as opposed to?
Oh, the kids, their school vacation, they get 2 weeks off in March. So that's why we went in March.
Where were the kids going to school at the time?
They were going to Renbrook. It's in Farmington.
I'm sorry?
It's in Farmington.
And where in Colorado did you vacation?
It was Aspen.
And what types of activities did you and the children do while on the trip?
Well, they ski. They're very good snow skiers. So they would ski. Noelle, who was younger than everyone else, we would just hang out, walk around the town a little bit. She would ski a little bit. Or whoever was tired, they would basically come back with Jennifer and I, and we would do the hot cocoa stuff. But they skied a lot.
And how old was Noelle at this point?
6 maybe.
And where did you stay in Aspen?
Jennifer's father won a house through a charity auction, so we stayed there for a week.
And did there come a point in time during the trip where Mr. Dulos told the group he had taken the children to an adult club?
Yeah.
Who was present for this conversation?
Myself and Jennifer.
How did Jennifer react upon hearing this?
She shocked because they were little and they were going to a day club. And so she was we were both disgusted, I guess is the word.
And what was Mr. Dulos' demeanor like as he was relaying this information?
He was excited that he paid off the people to let his kids into this day club where, yeah, he seemed really happy about it.
And approximately how long did you guys stay in Colorado?
It was about a week.
And at some point, did you travel to Miami?
Yep.
And I assume you flew?
We flew, yeah.
And who went to Miami?
So myself, the 5 kids, Jennifer, Fotis, and then Jennifer's mom, Gloria, met us in Miami.
And where did you stay in Miami initially?
Initially, we stayed at the W hotel there.
And describe some of your daily activities in Miami. I assume you're not skiing anymore.
Yeah, no snow skiing, but there was water skiing. So they went from snow skiing and they went to Miami to water skiing. So really, that was the activity.
And where would the family ski?
It's a Miami ski club.
And who would go to the ski club?
Myself, the kids. Sometimes Noelle would stay back with Jennifer. Jennifer would not go, and Fotis would go.
And during this trip, did Jennifer discuss her relationship with Mr. Dulos with you?
She did.
Well, at this time, did Jennifer discuss her relationship with Mr. Dulos with you? The answer is either yes or no. Overruled.
Is that a yes?
Yes.
And what did she tell you?
Well, what did she tell you about the relationship?
I'll rephrase. What did she tell you about the relationship?
Well, that question is very broad. Well, calls for an answer that could be a narrative. So the court is going to sustain the objection, but allow you to pursue the line.
You mentioned earlier that Jennifer had found out about the affair. Do you recall testifying to that?
Yes.
What did Jennifer say to you about the affair when you were in Miami?
Objection.
Well, that's going to be overruled.
She told me she believed that Fotis was having an affair.
And did she say why she believed that?
She just said she had this feeling, he's been acting weird, and I didn't really believe her at first.
And when you say you didn't really believe her, what do you mean by that?
At that time, I had a good relationship with Fotis, and I believed him to be an honest guy, and I couldn't imagine him having an affair where there's 5 little kids involved.
So what did you say to her?
I said, no.
Ground. But what this witness said is not hearsay. This witness is testifying about what she said, not what another declarant said.
It's an out-of-court statement now.
Well, it's an out-of-court statement, but this witness is the declarant. The witness is telling the jury what she told Jennifer. She has personal knowledge about what she told Jennifer. Overruled.
What did you say to Jennifer?
I told her I don't think that's true.
What was her demeanor like during this conversation?
She was very anxious, like kind of tight. And she seemed upset.
Was anyone else present for this conversation?
Yeah, her mom, Gloria.
Now, during this trip, did you meet someone named Michelle Troconis?
Yep.
Do you see Michelle Troconis in the courtroom?
Yep.
Would you just point her out and tell us what color shirt she has on?
Beige.
Judge, she identified the defendant.
Thank you. The record will reflect.
Where did you
before you proceed, you have about 2 minutes perhaps. This is an appropriate point at which to conclude today because you're about to go into other matters that are more significant than just identification. So, ladies and gentlemen, we will conclude today's session. Would ask if you not discuss the case. We plan to resume tomorrow at 10 o'clock.
All rise. This Honorable Superior Court now stands adjourned until tomorrow at 10.
And that pretty much concludes that for today. So we shall have more tomorrow. It's starting to get more interesting now. So I'm quite looking forward to tomorrow. So we shall start again. I think it's around 8 in the morning tomorrow. My time. 10 a.m. or 10 a.m. Eastern. And I've got a lot of good things to play on breaks. Didn't get much of that played today because we were sitting through the Alex Murdaugh hearing, which was interesting. I suspect he'll get a new trial. And he might get off a second time because the defense is going to know not to fall into some of the pitfalls that they did the first time around. And so it could be a completely different outcome if they they don't make the same mistakes again. So, I bid everybody a good afternoon and good evening, and hope to see you back in the morning. And see you then. Bye-bye.